Okay. Ladies and gentlemen, I actually opened up this presentation already, as you all know, and what we're going to do is we're going to browse through this real quick. We had a technical difficulty. My apologies. I want to get through this, and we've already gone about 15 minutes, so I don't want to do every single aspect. Again, we did pray, so Lord is already blessing us. I did say, again, the following information may be offensive and too revealing for some audiences like banks or CEO or the like, so viewer discretion is advised. I did do the disclaimer already. The disclaimer is on the screen. Just keep in mind we are not practicing legal advice. Again, questions, post them at the end of the day. Post them into the chat room. We'll review them at the end of the day with Joe Esquivel. This is not for public dissemination. This is privately owned by HISAdvocates. Breaks and lunches are here on the screen. We went through them audibly before. Again, we have about 400 slides, so we're going to be moving very quickly. Hang tight. You will get a copy of this entire presentation at the end of the weekend, so don't worry about understanding all the terms within the seminar. We've designed it to train you so that these terms that seem difficult and hard to understand will be completely understandable by the end of the weekend. I am your presenter. You may refer to me as Kelby Smith. I do hold a California real estate broker's license. Personally funded 700 loans in my career. I've gone through and complianced over 5,000 loans with my company that was A-rated with the Better Business Bureau, dotted every I, crossed every T. Funded private hard money through my company, funded private loans, funded public loans, helped homeowners stay in their homes since 2008. I have published, marketed, and produced and spoke at over 50 seminars in the last 5 years, and I am the founder and director of HISAdvocates.org. All right. I will slow down after we get to that mark where we had before, but a lot of this stuff, since you're hearing twice now already, it'll start settling in. This webinar, we want you to learn how to use a chain of title assessment. That is your educational tool. To, number one, obtain a declaratory judgment. Number two, argue in proper theory and venue to enforce perfected right to title. And three, to enforce perfected right to title. And number three, to enforce perfected rights title. That's everything. The title is the legal right to control and dispose of property. Listen to me again. I'm going to say this twice. Title is the legal right to control and dispose of property. This is why in non-judicial states they think they have a legal right. And it's because in a non-judicial state there's what's called split title, and we're going to explain that in just a minute. The union of, the union of all elements constituting the legal right to control and dispose of property. That's number one regarding title, the importance of title. The link between a person who owns property and the property itself. The evidence of a person's ownership of rights, interest in the property. Title is the manner in which the right to real property is acquired. The conditions necessary to acquire a valid claim to land. Title is the right itself. The legal consequences of such conditions. In dissecting this topic, we want to look at what rights. All rights, some rights, conditional rights, rights to possess, right to use, right to dispose, legal right. How are they transferred? What what processes are lawfully established and required for recognition of such transfer? By what law? I.e., by what law are perfected rights transferred? And therefore, what law do we want to avoid in asserting such rights when disputing? The kind of rights one has over the property determines the kind of title one has. One who has all rights over the property has perfected title. One has partial shared rights or conditional rights has imperfected title. When rights to property are purchased via a loan, or what we would refer to as an alleged loan, An arrangement is set up which either encumbers or splits the title, yielding in perfected title. The first scenario is called a mortgage in a state governed by lien theory. The second scenario is called a mortgage in a state governed by title theory, split title. In a third scenario, one is called a deed of trust, which we have here in California, and that's a title theory state. Lien theory is judicial. Title theory is non-judicial. I want you to get this through your head because that's a nugget. So beneficial title, one on whose behalf the title is held. Think about what I said. Legal title, one who controls the legal purposes. Equitable title, one who enjoys the use of equitable beneficial title. And they are largely interchangeable terms in law. So here's your nugget. You do not hold title free and clear of all encumbrances until you hold all three: beneficial, legal, and equitable title. The beneficiary is the owner of the debt and the grantee in the public records. So now you understand why they don't want you to sign the grantee on the grant deed, because then you would own your house. So in a judicial lien theory state, title is presumed to remain with the borrower. Title is encumbered. But in a non-judicial title theory state, title is presumed to remain with the lender or the trustee. The title is split. It is imperative for the borrower to capitalize on his claim to title in any contest with a pretender lender, regardless whether the presumption favors him or not. Even in a non-judicial title theory state, the borrower must stand on his equitable right to title. Possession is 9/10 of the law. Remember, they always tell you everything. Possession is 9/10 of the law. This is why when you go to UD court, they're arguing with you the fact that this has nothing to do with whether or not your right to title on the house or fraud or lender never made a loan or you discharged the debt or. It's all about possession. Why? Because that's your only hearing that you get judicially under color of law to take you out of the house, because they need a sheriff to do it. They need a sheriff, because a mortgage lender can't come and knock on your door and say, here's the papers I'm serving you. No, they want a sheriff to, because the sheriff is the enforcement arm. And so they've made these administrative courts called an UD court, unlawful detainer court. It's not that way in every state, but for the most part, this is why they do, and this is why they tell you possession is 9/10 law. So if you're able to get around that UD case, which is huge, you win. Okay, take a look at the map. It clearly outlines judicial versus non-judicial. Title theory states versus lien theory states. It's pretty basic. I ain't going to read the paragraph there, but it really should just say non-judicial or judicial. But we're trying to make those names synonymous in your minds, and you'll understand why as we go. Okay, so this is what the major attorneys out there are doing in having success at quieting the title. They're basically going only for the homeowners out there that are current on their home, meaning people that are late. The judge will say, they'll bring it into equity. They're not just able to argue statutes and or whether or not that MERS has a right to acquire, or whether or not the servicer has a right to acquire the property. And so when you're late on your house, they bring it into equity court and make these arguments of the fact that the intangible obligation, the payment stream, is not being paid, and therefore, boom, 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 and you're out of your house before you know it. So the attorneys only need to go in and challenge whether or not the lender is the holder of the note. And most every attorney out there, they want a $25,000 retainer, and they want a portion of your home to be able to effect quiet title. What the process that we're doing, the declaratory judgment relief, which, by the way, our back office just got one last week and got 3 more settlements. We're going to talk about that this weekend. The stuff that's going on where you get a declaratory judgment, that's really the step one for the person who's late on their payments, because no court is honoring quiet titles. Anybody out there doing a quiet title, stop, or get the declaratory relief package and readjust your complaint, because you're going to lose. And this is important for people to understand in going from a quiet title to the declaratory relief, because the declaratory relief, you put a permanent cloud on title, you're stripping, potentially stripping the assignments and the deed of trust, and or one or all, and that permanent cloud on title cannot be advanced upon. So essentially, you're not quieting title, but you're taking the load, the monkey off your back. Okay, so we know the difference of real property and land. Do you? What is the difference of real property and land? We are dealing in a civil venue, and we will use the civil and the public terms because we're dealing with real property. In a nutshell, there is a term for land, and it's dirt, earth, soil, ground, land. Those are the only 5 acceptable terms for your home. You don't have a home, you don't have a house. I want to get this point across to you guys. You have land, okay? Now, this is an important thing to understand. But since you've already contracted with the lender using a legal description and not meets and bounds, it's important for us to understand that we need to go with the elements of the contract and dispute the elements of the contract itself, the deed of trust, and so on. So this webinar will cover the transfer of split rights and or secured interest in law in context of securitization, and proving and demonstrating the lawful failure of split rights in securitization using a CODA, the chain of title assessment. Adjudication of rights through a declaratory complaint and judgment leading to your next action, which is quiet title. Because if you take the lender out through this process first, the declaratory relief package, and you get one of those assignments, you get the deed of trust, whatever, you've quieted that or clouded permanently that particular portion of your title. Going after an action in quiet title then becomes a whole lot easier, because your people you technically need to serve are who? Where are they? Think about that. In layman's terms, this is going to teach you how to sue the lender by pulling out your 45 of law and smoking them, using the statutes that they did not honor themselves, the ones that are in place to make sure those allonges are securely attached, to make sure that the chain of title is proper. Fundamental transfer of perfected title is accomplished through a grant deed, which contains a pledge or a covenant of season guaranteeing that the one transferring the right of possession is fully seized. Okay? That's important. That's a big word. It presumes the freehold, unencumbered, unrestricted possession, providing the basis for warranty deed, warrantying that the seller's right of disposal is free from all encumbrances, which the current freehold seller will defend. Season, remember that word, S-E-E, season, is at the heart of title. Freehold possession of property is the basis of standing, okay? Season is the completion of the feudal investiture, sorry, I'm getting all my words mixed up, by which the tenant was admitted into the feud. And this is right off of dictionary.com. Anybody can get this, S-E-I-S-I-N, go look. And I want you to memorize this. This is important. This is nugget. By which the tenant was admitted into the feud and performed the rights of homage and fealty. Season represents possession with an intent on the part of him who holds it to claim freehold interest in fee simple title, meaning that upon the conveyance of the estate, the person has a right of immediate possession according to the nature of the estate. Hold on one second, please. A deed without season covenant is a deed to nowhere. Remember that word. So, quiet enjoyment means there is no defect in title. A deed without a covenant of season is a deed to nowhere. Remember these terms, guys. These are things we're going to beat into you today and tomorrow, because it guarantees the possession of nothing. A deed to nowhere guarantees the possession of nothing, because people sign such contracts without reading them. The borrower's covenant of season is the season mechanism. There are other covenants of possession, of title, and or further assurance. So covenant, which is usually inserted in a conveyance of land on the part of the grantor, which binds him for the completeness, security, and continuance of the title transferred to the grantee. These covenants are comprised of covenants for season, for right to convey, against encumbrances, for quiet enjoyment, sometimes for further assurance, and almost always of warranty. Don't be confused. Don't be scared. Don't be worried. These terms that we're speaking on today, they'll settle in. We've designed this seminar so that it hits you and that reiteration training settles in. And I just want you to be assured. I know there's a lot of people going, oh, this is too complicated. No, it's not. Open your brain. God will open your mind, and it will help you understand exactly how to use this for your benefit. So quit claim deed example. I quit claim to you my rights of ownership in the Brooklyn Bridge. Okay? Wild deeds are daily filed of recorded by the banks, MERS, and substitute trust deeds. And a wild deed is a deed that only purports to transfer rights which the transfer does not have. Okay? Deeds are recorded onto the public recording to give public notice to the transfer of title. In the event of an unknown imperfection of title, transfer prior to the present, a buyer obtains title insurance which warrants against such defect and indemnifies the buyer should such defect later appear, creating an unmarketable title for any reason. So, how many people, raise your hand, I know I can see you all, have ever heard of anybody using title insurance because they sued the title insurance company for warranting unmarketable title? I don't know of anybody. I don't know of one person in the country that's ever used their title insurance to go after the title insurance company because title was bad. Well, let me explain something. We're not going to get into it at this seminar, but on HISAdvocates.org there is a lot of information pertaining to lawsuits all over this country that are being settled with the 5 big banks. And these are done by the county recorders and the county recorders' attorneys, which are saying 90% of all documentation in the county recorders, and this is for all attorneys and judges nationwide. This is for you guys. 90%, I'll show you the cases, you'll see the settlements of all documents recorded in the county recorder are fraud, which means you have imperfected title. So consideration becomes the special importance later when evaluating the validity of negotiation of the instruments associated with the transfer or rights to title interest under a mortgage. Remember that on a grant deed it says that for good and valuable consideration. Generally that is referencing money or digits or the currency that the agreement would be set under, or that the agreement would lie under. So consideration. What consideration did the banks give? Nothing. Remember that. We're a Christian ministry, and I'm telling you to go after your banks. Why? Because the contract is fraud. So the transfer of rights from a borrower to a lender must occur in the compliance with the contract law and the statutory law. Subsequent transfers of rights from lender or the lien holder to lender or lien holders, meaning these assignments, must occur in compliance with the contract law and statutory law. See, when a mortgage arrangement is established wherein the rights of interest to title become split, creating a lien hold interest in property as a collateral guarantee for repayment of debt, the transfer of legal and beneficial interest rights from borrower to lien holder and between subsequent lien holders must occur within a specified lawful framework. Our chain of title analysis specifically researches the lawful elements of the rights to transfers between the lien holders. So in MERS, in a MERS mortgage, not MERS doesn't give a mortgage, but in MERS mortgage, people that have MERS all over their house, MERS this, MERS that, MERS on the initial documents, MERS trying to foreclose. MERS acts as what's called an interloper, don't need to memorize that, by calling itself a mortgagee or beneficiary, while still referring to the lender as a separately identifiable party and calling itself a nominee. This is a bogus splitting of the office of the securitized party at the heart of much foreclosure litigation and is absolutely worth challenging. At the end of the weekend, I'm going to put a couple of books I want you guys to read, pictures of them and links to go and purchase them on the back office on the wall of where you came on to here. This is important because if you want to really learn the nuts and bolts and get through the declaratory relief package, you need to be trained up in these things, and these books will really help you in those regards. So the splitting of rights of interest between the borrower and the lender is memorialized in two documents which form one instrument. Okay? Two documents form one instrument. This is nugget time. These are called the promissory note and the mortgage or the deed of trust or the security deed, to be discussed further. The mortgage is predominantly used in lien theory states, meaning judicial, and operates only as a lien. So the deed of trust is predominantly used in the title theory state or non-judicial and operates as a transfer of the legal portion of title in succession to the grant or warranty deed on the public record. So in other words, when we look at a chain of title to make it an assessment of whether this information was done lawfully, you're going to hear from Joe himself, our back office, tonight. We have never seen one, a properly vested chain of title. Isn't that sad? Not one. Why? Because it's tough. They made the rules, they made the laws, and they can't perform upon them. So all we got to do is figure out how to make the judge perform upon what we're asking them to do. So mortgages explicitly state that the lien holding parties, your pretender lenders, have the right to resell their interest in the debt and hence assign their lien hold interest in the land to another party. These are judicial states. This means they have a right to sell the promissory note and assign the mortgage or the deed of trust on the public record to the same party. According to the mortgage or the deed of trust, the lenders are responsible to release their claim of interest on title when transferring their interest. This is called a reconveyance. It's also called a release of lien, but this is an important thing to grab onto. I'm going to read it twice. Lenders are responsible to release their claim of interest on the title when transferring their interest. So, does anybody know or have they ever seen a reconveyance done after the time of the grant deed? Because remember, you get a reconveyance from the old lender. You purchase a house, B of A is paid off. B of A gives a reconveyance of payment in full to the old borrower. Now, the new borrower gets a grant deed, gets a deed of trust, and they go out and get a refinance. I want you to think about this. Refinance. How come on the refinances we don't get a reconveyance? We're going to discuss that later. We should. The majority of this seminar will be given to in examining the transference of split rights and the loss of perfected lien hold interests through the unlawful actions of these pretender lenders, especially with regard to the securitization of the notes and assignments, as these violations are discovered through the means of our chain of title assessment. See, if they don't abide by state, federal, and under federal TILA, RESPA, FDCPA, Uniform Commercial Code, Section 3, Section 9, if these requirements are not met, the lien hold interest becomes unperfected, preventing the right to enforce interest in title. They can't take your home if they don't abide by the law. So you got to watch out for ping pong in court, and this is what we're going to talk about today. So this webinar is about proper venue within the public context. Remember, public-private. We're private citizens using our public side trust, known as our name, to go into court and deal with the issue within their own laws. So at this seminar, we're not going to be dealing on the private venue on things, and we will later. We'll do another seminar on this stuff, like what a state citizen would do, or land patents, or deed acceptance, private non-recorded common law contract, etc. That is for another webinar. So this is only going to be about using the proper court venue with the proper civil statute framework, okay, statutory framework. We always go into court thinking that the judge is impartial and fair. Well, maybe not all of us. But that's how we were raised to think, that they're a third party. They're not vested in anything. They're just there to be a non-biased man of God in a black robe. So in reality, what we have is an issue whereby trying to hold a judge to the letter of the law and his oath of office, versus him trying to make a contract with us moving into the equity side of the equation. So this is a fine game of ping pong. That's what I call it, of which we have an advanced training on in the near future, meaning how to play ping pong in court. So for the most part, the game of ping pong is done by watching how the other player's angling his paddle so that you know where the ball is going to go and come, and keeping focus on that ball so that it doesn't stay on your side of the court, because you're playing in a court on ping pong. But rather, you head the ball back to the other side of the court so that they can't swing back at you. In other words, that is the equivalent of watching the judge try to contract with you over and over and over, and you not accepting the terms. And you could do this in their court. So, Your Honor, the defendants are attempting to exercise a right to plaintiff's property without lawful authority to do so. Although mortgage servicers are able to foreclose under the Texas Property Code or California Property Code, the ability derives from a principal-agency relationship with the owner of the indebtedness and that of perfected right to real property. Therefore, we shall concentrate on grasping the various bodies of law that expose the fraudulent actions of alleged lenders, majoring on the law closest to the contract and on pushing for adjudication on the merits of law over equity. We can only enforce through adjudication, the sheriff, the judge, that standard of law by which we understand and are prepared to argue. How do we argue? On our pleadings. Shut up. Do not engage. When I say argue, I mean on your pleadings. The question is you must be able to and be prepared to stand on the documents as submitted before the record of the court. Playing ping pong with experts, you will lose every time. Do not jump into their game. Stand on your own game. The last major prong of this seminar will teach how to argue from a lawful basis in order to obtain declaratory judgment in our favor that establishes the lost, non-perfected lien-holding rights of any and all alleged lenders, which in turn paves the way for quiet title action for restoring perfected title in the hands of the borrower or homeowner. Although it is generally a statutory rather than any equitable remedy, that's all we're trying to do here, this has nothing to do with foreclosure. It is a standalone action. So it is a status quo legal determination about parties that have acquired rights in accordance to the law. So we are saying that they have no acquired rights in accordance to the law. So the declaratory judgment is a legal determination of a court, the judge, as to the legal position, the litigants in a case where there is doubt as to their position in law. Okay? So, remember that elephant? You got a bunch of blind men feeling an elephant. Oh, it feels like a spirit, feels like a wall. No, it's a rope. It's a tree. It's a fan. Well, for us, the elephant looks like this. The chain of title analysis helps us to put the entire elephant into perspective because it is an elephant. It's big. Being able to dissect starting with the deed of trust and moving forward throughout the history of your chain of title gives you the upper hand in understanding of all unlawful violations and or statutory requirements to beat your lender. This webinar will no longer allow you to be blind. Okay, notice all the diverging arrows. These are the points at which rights to interest in title become split, sub-split, and or lost according to the law. The splits deep to the right occur because of securitization. Violations towards the right on the event line are harder to nail as murkiness proliferates and law becomes obscure. The chain of title analysis examines these split rights specifically to reveal the lawful violations causing loss of perfected interest in title, showing that they are not a holder in due course. Please remember, guys, you're going to get a copy of this, and so don't worry about it. You'll be able to study it all later. Now, there's 4 key splits affecting the rights to title. Let's break down the big elephant, 4 real splits to consider. Number 1, the mortgage from the grant deed, the note holder from the mortgage, and the payment stream from the note. What is the payment stream referred to? Because we're going to talk about tangible obligation note, intangible obligation payment stream, tangible obligation note, intangible obligation payment stream. Keep saying that. Payment stream is the intangible obligation. Okay? The intangible assignment from the public record. That's the 4th one. So, right away from the inception of your mortgage application, the lenders are working on the monetization of your instrument, the 2 things. They're taking your application and they're getting ready because they're going to throw you in a pool, referred to as the note. The whole game is to put these notes into a very large blocker pool and attach them to what's known as a PSA, pool servicing agreement, and split the pool into tranches. It is a very complicated system so that they can use to raise capital known as digits. Emphasis here on maintaining legal significance of physical attachment of the note and mortgage has steadily eroded with the proliferation of electronic duplication of documents, in other words, MERS. So the note and the mortgage holder, lien holder, writes only as a single instrument, meaning the note from the mortgage. So splitting of the mortgage from the note occurs as a physicality at the beginning of securitization. If the note and the mortgage are split, guys, and you can prove it, it's game over. Courts are not in hot debate nationwide over the impact of the physical splitting of the lien holder rights. Why? Because it would be game over. Everything's been split. That's why. So to be covered in depth in the law of negotiable instruments and the process of securitization, we must understand RMBS, the residential mortgage-backed security, splitting the payment stream which the note represents from the note occurs at the base of the securitization chain. The note is converted into an e-record, often timed with the destruction of the physical note. So the legal character of the paper note are altered under commercial contract or commercial law. They're greatly affecting the right to title. The strongest split available to defeat perfection of a lien hold right to title in statutory law altogether with contract law is this. So the REMIC is basically a conduit holding fixed pools of mortgages that back securities collateralized by mortgage cash flows, the intangible obligations. Assignment, the transfer of property, especially the transfer of property to be held in trust to be used for the benefit of creditors. I know, guys, look, I'm feeling your weight. I'm just going to ask the Lord to just please come upon this seminar and just give us the wisdom, again, open our minds, help us to understand what we need to understand. This is very serious stuff. We need to protect our homes. These basic terms and words are putting fear in a lot of people's minds. Don't let it. Father God, just bless these people that are listening to this seminar. Let them understand this is not that hard. So please understand, guys, these words, they sound big, but trust me, the entire back office, you don't need to understand most of these words. You need to understand concepts, and we're teaching the whole thing here. So we're going to get behind you on the concepts, and we got your back on the words, all right? Players in securitization don't believe that they have to be publicly recorded to maintain perfect lien hold interest. Really? Well, that's kind of what they're doing. The standing of MERS is a lightning rod at the core of this split. We will focus on this in the discussion on MERS. So the next three parts of this course will be dealing with the issues affecting an acquiring and losing of rights to title in law over the latter three splits. The note from the mortgage, the payment stream from the note, which is the intangible obligation, and the intangible assignment from the public record. This will be followed by how a chain of title analysis is constructed to bring these details together in usable form for law. The final section will be discussed how do we use the code in court to lay the court suits for declaratory relief and quiet title. And now it's break time. So I'm going to put this thing on pause. Guys, I will see you in 10 minutes. All right, guys, here we go. We're going to give about 30 seconds and launch part 2 of the seminar. So come on in. Break is over. It's time to get busy. 30 seconds. 10. Okay, again, quick disclaimer. We do not practice legal advice. That's what that says. Okay, part 2, transfer and a split of rights in title, the note from the mortgage. The splitting of rights of interest between the borrower and the lender is memorialized in 2 documents. Listen to the next 4 words. Which form 1 instrument. This is a nugget. These are the promissory note and the mortgage or the deed of trust or the trust deed and or security deed. The mortgage is predominantly used in lien theory states and operates only as a lien. The deed of trust is predominantly used in a title theory state and operates as a transfer of the legal portion of title in succession to the grant/warranty deed on the public record. So again, we're doing some reiteration right there for you guys so that you understand. And deed of trust is title theory. Okay, mortgage is lien theory. Chain of title analysis assessment examines the chain of transfers of both the promissory note and the mortgage or the deed of trust for perfection according to the laws and statutes governing each transfer. The failure of perfection in either negotiation or assignment is the loss of perfected security interest, meaning you can't take my home. Period. Carpenter versus Longen establishes the requirement that the note and the assignment must convey together to retain perfected interest in one instrument. Remember those two things, the note and the deed of trust, are one instrument. So this case, I don't care if it's 1872, it's been shepherdized, which means it stands. It tells you that the requirement of the note and the assignment, they must convey together. Okay? All in one. So with the modern proliferation of electronic reproduction of documents, lawyers and judges increasingly argue and decide that Carpenter versus Longen means the mortgage automatically follows the note by virtue of essence regarding of actuality instead of interpreting it as a conditionality that voids the mortgage if not met. So wait till you see the next slide. Stress is put on the phrase in red to the exclusion of the phrase in blue, which will be extremely important when discussing securitization. Okay? This may be refuted, the dog in the tail illustration, in the physical, if the physical asks how the tail can be joined back to the dog once physically separated. It's the same principle. Cut the tail off the dog. How do you join it? You don't. California case law and California civil code conflict with federal and commercial law, which requires assignments to be recorded for perfection of lien hold interest to be maintained. And we're going to discuss this further under lawful transfer of assignments. See, this is a section 108.4 of the California Civil Code provides that the transfer of a thing transfers all of its incidents unless expressly accepted. So, the endorsements of the note by the payee was sufficient to transfer the deed of trust without other assignment. This is where I sneeze and say bullcrap. But we're going to deal with that. So, excuse me. My voice is kind of giving out. I'm going to go for it, though. Even though the complete mortgage instrument is comprised of two parts, the obligation to pay, at the heart of the lien right, interest is in title is embedded only within the note. You hear me? The obligation is the intangible promise to pay contained inside the note. That is the only thing that gives them lien hold right interest to foreclose. So when the assignment says for value received, it is memorializing the purchase of the note. You cannot buy a deed of trust. A deed of trust contains no value and cannot be sold for value. When we say, remember, the deed of trust is the evidence of the note, right? So Sorry about that. So when they say we have the assignment for value, the question becomes what value was given and what exactly was sold. Because the only legal obligation to pay is in the promissory note. So you want to get the judge to realize that there is no monetary value in the deed of trust. That's it. Note, again, the ambiguity of and conflict set up regarding the severability of the deed of trust from the note. Nevertheless, this case does show that everything ultimately hinges on the validity of the debt and its transfer in accordance with the law. Damarad, I don't know how to pronounce that, versus Fisher and Burke. So a deed of trust is inseparable from the note, the debt. The deed of trust is incidental to the note. The deed of trust is inseparable from the note. The deed of trust has no value independent of the note. Dog with no tail is a tailless dog. The deed of trust is not assignable apart from the note. Any actions contrary to the foregoing are a nullity, void. These transfers of the loans are actual sales, buying of a loan. Despite the debatable meaning of the demand for physical association of the note and the mortgage, the ultimate issue is over the transfer of the debt, not the assignments of the mortgage. The lawyers focus on the assignment while, taking away the transfer proofs of the debt. Think about that for a second. So any conflict over the relative transferences of the note and mortgage, the biggest fight is based on the obligation, the note, not the assignment. For value received only means when they bought the note, which is memorialized in the deed of trust or the mortgage. But the deed of trust has no value. You don't sell it. To argue, or to the argument about the foreclosure statutes being comprehensive, then we object to arguing that the obligation controls. You always have to take back to the contract and go with unclean hands. And you'll understand that later. The assignment always starts with for value received. So you have to go back and challenge how that transaction relates to the transference of the debt. Period. In the next few slides, we're going to be examining the laws of governing negotiation, the laws governing assignments, and the interrelational evidences of non-compliance that invalidate perfected interest in title. I know, big words. Relax. Breathe. Transfers of the negotiable instruments must be in their own right according to the law. Assignments of security interest must be in their own right in accordance to the law. And these transfers must be in accordance with one another according to the law. They must match. Negotiation of the note. UCC came about in 1961, but which statutes have been in effect since 1881? Their effective law. These laws were in effect before the RMBS, Residential Mortgage-Backed Securities, market came about in 1970, and they're applicable to that market, the RMBS. So the main object of the Negotiable Instrument Acts is to legalize a system by which instruments contemplated by it could pass from hand to hand. Period. This still stands today as the point. Promissory note. I promise to pay B or order R's $500. It's going to be kind of complicated. We're going to show this to you in the law in just another slide. I acknowledge myself to be indebted to B or to Alan for in RS $1,000 to be paid on demand for value received. Mr. BIOU R's $1,000. I promise to pay B R's $500 and deliver to him back a black horse, blah, blah, blah. Okay, so I'm not going to get into this. It's not that important, but the instruments marked as A and B are promissory notes. The ones marked as C and D are not. The Securities and Exchange Act came about 1934 to govern secondary trading as well, but you have to know these rules in order to apply them. So you're going to be able to read all this. This is basically what is a promise to pay. Okay? Pete. Don't forget this. This is another nugget. Pete. Person entitled to enforce. Pete. It's going to be a big word for the rest of your life. Pete. You're going to talk to your friends. Hey, does that lender, when they talk to you about their foreclosure, you're going to say, I bet they're not a Pete. Pete is something that you must remember as being an acronym that means the person who has a lawful right and action to take your home. Okay? So the two may not be the same. Remember, who is Pete? So before seeking a declaratory judgment, we must have an understanding of parties claiming to take part. We need to identify the parties entitled to enforce. Pete, using statutory requirements of law on a mortgage loan instruments. So when promissory notes fulfill the technical requirements of negotiability, we go to UCC 3 and the state equivalent. We have to know who is Pete, to whom is the note owed. Real question, is there even a note? We're going back to that. Remember, show me the note? You know how many times people lost to that because they brought in a note and the note was fraud? I can't even imagine. Felonies. These, meaning the conditions of each of these terms, are outlined in the UCC. We will look at each and break them down. The holder, negotiation, endorse, bearer, order. That's all I need to read to you. So, three primary entities are involved in this definition that have to do with missing promissory notes. A holder of the note, key term holder, a non-holder in possession who has the right of a holder, and somebody who recreates a lost note under 3-309.6. Let's take them one by one. The issuer of a note is obliged to pay the instrument according to its terms. At the time it was issued, the obligation is owed to a person entitled to enforce. Pete, the instrument. 3-301, person entitled to enforce, the holder of the instrument. What does holder mean? It's just they physically got the note, the real note. That's it. That's a holder. But it's different than a holder in due course. A non-holder in possession of the instrument who has rights of a holder. That's kind of what they're trying to tell you as a servicer. And a person not in possession of the instrument who is entitled to enforce. Okay? That also could be a servicer. So this requires an examination of the note and any subsequent endorsements. We will discuss this difference between order paper and bearer paper shortly. Okay? To be Pete, you must be a holder in possession of the note, which either the note is payable to Pete or the note is payable to bearer. So, this is a nugget, guys. To be a holder, to be Pete, person entitled, you must be in possession of the note, and it must be payable to you or to bearer. What's bearer? So, we'll get into that in a sec. In other words, a person that's holding the note claiming to be Pete needs to prove the purpose of the delivery of the note and how he came into possession of the note, including possibly through what power of agency or attorney? This has to do with the payee transferring a note still unendorsed. We're going to talk about endorsements in a bit. By him to a third party by special contract for enforcement. It also could apply to the ability of the third party to endorse that note on behalf of the payee through an agency relationship. A mailman can be a holder as a transferee but not acquire the rights, so he cannot be peat. Mailmen are often holders, by the way. So a non-possessor who is able to prove lost note. They must prove prior lawful possession. Okay, they can't just do an affidavit, guys, on a hearsay claim, but they do this, and it must be disputed. What did I say? Dispute it. So there must be many proofs required to be peat. Article 3 of the Uniform Commercial Code. Remember, guys, this slide is a nugget. They dispute it. They bring in affidavits. This is your nugget right here, okay? Of the Uniform Commercial Code could not be clearer when it comes to the issuance of mortgage note foreclosure. When somebody signs a promissory note as its maker, issuer, he, she automatically incurs the obligation, UCC 3-412. UCC 3-412, that the instrument will be paid to a person entitled to enforce the note. The peat, person entitled to enforce, is in turn defined in 3-301, UCC subsection 3-301, person entitled to enforce. An instrument means the holder of an instrument, a non-holder in possession of the instrument who has a right or rights of a holder, or a person not in possession of an instrument who is entitled to enforce the instrument pursuant to section 3-309 or 3-418D. Let's take them one by one. Relax, guys. We're going to get this. Essentially, a holder is somebody who possesses a negotiable instrument payable to his or her order, or properly negotiated to the latter taking by a proper chain of endorsements. This result is reached by the definition of holder in subsection 1-201B21. 1-201B21, right on the slide. So proper chain of endorsement means simply this: A, B, C, D, E, F. We didn't skip anything. That's a proper holder in due course. A proper negotiation of the note creates holder status in the transferee. Don't get hung up on big words. You're going to get this, guys. Makes the transferee the peat, the person entitled to enforce. So again, the proper negotiation of the note, the holder, status is in the transferee, and it makes the transferee a peat. The two terms that complement each other, holder takes through a valid negotiation, and a valid negotiation leads to a holder status. Negotiation is perfected through a proper chain of endorsements. So, negotiation means transfer of possession, whether voluntary or involuntary, of an instrument by a person to another, to other than the issuer, to a person who thereby becomes its holder. So, except for negotiation by a remitter, if an instrument is payable to an identified person, the negotiation requires transfer of possession of the instrument and its endorsement by the holder. If an instrument is payable to a bearer, it may be negotiated by transfer of possession alone. No, we did not spell endorsement wrong. I thought the same thing a few years ago. It is both, but in the UCC it's spelled with the I. Words are the same. E and I, they both mean the same. The endorsement means signature. Okay? Negotiation or transfer for the purpose of enforcement is perfected only through signature, endorsement. An endorsement is a signature. If there is no signature, there is no endorsement. Pretty simple. Here's the kinds of endorsements we have. You've heard of these terms: blank endorsement, special endorsement, restricted endorsement. So this is where you go in the future if you want to see what they look like, if you're going to argue these points in court. Blank endorsement: a signature by the creator of an instrument, such as a check, which enables the holder of the instrument to assert a claim for payment because no payee is specified. Such an endorsement essentially turns the instrument into bearer security. What does bearer mean? I can cash it anywhere I want. Okay? Special endorsement: an endorsement of a check authorizing payment to an entity other than that entity to which the check was originally written. A special endorsement consists of a signature and a statement identifying the entity to which the check should be paid. Paid to the order of. A restricted endorsement places a limitation on the use of a check or other negotiable financial instruments. The most common restricted endorsement is the phrase "for deposit only," when written along with the payee's signature on the back of a check. Not that hard. So when a blank endorsement, because a lot of people go in and say, "We have a blank endorsement, Your Honor," one that does not have a name, a new payee, the payee simply signs its name on the back of the instrument. If an instrument has been thus endorsed by the payee, anyone, and I mean anyone, acquiring the note thereafter is a Pete, person entitled to enforce. This is why they love these blank instruments. Once a blank endorsement has been placed on the note by the payee, all later parties in possession of the note qualify as holders and therefore Petes. Example: a check. Now listen, this is the greatest analogy you can ever hear. Not the greatest one, but a good one. A check made out to you or to cash and signed by the promisor on the front requires only your signature on the back. Your signature on the back is a blank endorsement. If it is made out to cash, anyone can sign it on the back in blank and cash it, enforce it. If it is made out to you and you sign it on the back in blank and you lose it and somebody else finds it, they can enforce it. So you're holding a check, it's payable to cash or you, and you've endorsed it on the back and you lose it. Anybody has the lawful right, and I don't care, anybody, there is no violation. If you lose that $1,000 check, there's no misdemeanor, there's no felony. It's their lawful right to go and cash it. It's bearer paper. That's what is bearer paper. Once endorsed in blank, the instrument is able to be negotiated by anybody, bearer paper. So if the payee's endorsement on the back of the note names a new payee, pay to X company, that is called a special endorsement. Now, only the newly nominated payee can be the holder. Okay? Pay to the order of. A status postponed until the new payee acquires the note, you have to hold to be a holder, the note. The special endorsee wishing to negotiate the note to a new owner may now sign in blank, creating bearer instrument, or may make another special endorsement over to the new owner. Only if there is a valid chain of such endorsements has a negotiation taken place, thus creating holder status in the current possessor of the note and making that person a Pete. So with the exception of allonges, the endorsements have to be written on the instrument itself. The note on that page where you signed, they have to sign it. So example, a check made out to you or to cash and signed by the promisor on the front, requiring only your signature on the back. Your signature on the back is a blank endorsement, and the check is now cashable by you or anyone whom it passed or who finds it on the ground. But instead of cashing it, you want somebody else to be able to cash it, and you don't want to risk that they might lose it and someone else find it to cash it. So you endorse it on the back and write paid to the order of Jane Buck. That is a special endorsement, and now only for Jane Buck can negotiate the instrument. It's also called order paper, to be discussed in a later slide. Once Jane signs it, all she does, if all she does to sign to deposit, Jane has signed in blank. Or else Jane can make it another special endorsement of her own to give it to somebody else, and so on, and so on, and so on. So now you're learning the chain of title and these restricted and or special and or blank endorsements. A restrictive endorsement purports to put conditions on the payee's options for negotiating the instrument or otherwise on the payer's liability for the instrument. To put without recourse under the endorsement absolves the endorser of all liability for the instrument's fidelity. Think about that. I'm going to tell you something. This is a nugget for anything you do for the rest of your life. This one thing, without recourse. Okay, you put your signature on something that you're leery about, without recourse, all rights reserved. I put that signature on everything, and I've been training people to do that for 6-7 years now. And I'm telling you, it is by law, it's something on the broker application, coincidentally, protects you because there is no recourse to you by you endorsing it that way. It's crazy. They've made these rules and regulations for them. So what are they putting on their notes when they sign? Without recourse. Isn't that interesting? Why? Think about that. So I'm going to let you guys read this later. An instrument requiring the payment to order of an unspecified payee is an incomplete instrument, which must be filled in for negotiation to occur. So an example, the pay to line on the front of a check must be filled in with the name of at least one word, cash, or perhaps the bearer, but it must be filled in. So the pay to the order line shows intent that it must be signed from party A to B to C, etc. Yet assignments routinely are filled in from party A directly to party F. Now, mind you guys, this is an important thing. We said holder in due course, Pete must be A, B, C, D, E, F. It cannot be assignment A to assignment F. You feel me? So where there is no agent-principal relationship can only be shown through established chain. They only have baseless hearsay claims. All 50 states have these statutes. Nobody is using them to nail these fraudulent assignments and transfers as of yet. There's a few, but not many. Here's a few samples. Special endorsement. Number one. I'm just going to tell you the answers. Why? Because it specifies a party to be paid and is endorsed by the preceding payee. So you have here, let me break out a little. I've never done this before, so forgive me. We're going to do whatever. Doesn't even have I thought I was going to have a laser pen. Must be an older version of Office. All right. So you look on that line, you got it specifies the party to be paid and is endorsed by the preceding payee. Paid to the order of Countrywide Home Loans and is endorsed by a senior vice president. Number 2, that's an incomplete instrument. Why? Because the pay to order shows intent but is not filled in. There's no endorsement by a preceding payee. Blank. Incomplete. Blank endorsement. Why? This is number 3. Why is that a blank endorsement? Because this is simple endorsement without further order. What is that known as? Think about it. So answer, this is not a blank endorsement. This is an incomplete instrument. Why? Even though it is endorsed by the preceding payee, the stamp shows that the further intent to order and therefore must be filled in to yet another payee, paid to the order of blank, without recourse Countrywide Home Loans. So let's go back. There's your complete one on number 1. There's your incomplete one on number 2. Okay? Hold on. Incomplete number 1, or complete number 1, paid to the order of Countrywide Home Loans without recourse, executed, incomplete. Okay? This is a problem, guys. Meaning we're going to teach you how to deal with this. So bearer paper requires no identified payee, only the endorsement of the holder, paid to bearer, paid to order of bearer. Otherwise indicates means a fully endorsed instrument without further order to a specific person. UCC 3-205. UCC 3-205, it's on the screen, says that if you sign the back, then a bearer can just come and cash it. This is why you find a check on the ground that's signed on the back, and that front says pay to order of, and it matches the signature on the back. You can go and cash that check. Now, I'm not going to say do that. I'm just trying to show you what Pete would look like making bearer paper that falls on the ground. So order paper requires a statement of intent to pay an identified payee. Pay to blank, pay to the order of blank, like a check. That's order paper. Bearer paper and order paper are interchangeable depending on how they are endorsed, whether or not a further named payee is identified. Okay? Now you're looking at their bearer instrument on the top left. Bearer instrument says pay to bearer on demand. See that there's no empty space to be filled in on these notes. The word bearer is clearly indicated. Okay? This is bearer paper, $100 bill. This $10,000 bill is bearer paper, paid to the bearer on demand. Okay? Not sure where it says it on the 100, but I'm sure it does. So these are bearer instruments. Okay, so comparing bearer paper and order paper, order paper simply says pay to the order of, which is a specific set of instructions, and the bearer paper is paid to the bearer, meaning the person that's bringing the instrument to your counter to cash that check. Bearer paper still requires authentication of of the identity of the holder to determine relationship to the original intent of the maker. So if you go to a bank with a check fully endorsed on both sides, even though it's not made out to you, you are still required to provide ID. It doesn't mean that you can't cash the check. You just got to get there before they do the stop pay. I'm not saying to do that. I'd personally call them and say, I found your check. But the point is if it was, that's a good example of what bearer paper is. Attorneys who try to turn order paper into bearer paper, excusing the requirement of intent, But bearer paper has statutory requirements to be identified as such. So you must not leave it up to the courts to interpret the law or the meaning of what the order paper and what the bearer paper was. Okay? That's a little bit of a good nugget for you to consider, because as we're going to have these notes and different things pop up before us for examination, it's going to be neat. By the way, much of the people that are coming in are pulling out their notes and starting to look. So even when a blank check requires the filling in of the names of the payee, until it is filled in, the right to enforce is a static right only. It is not an enforcement action. So without a perfected interest, there cannot be a secured claim. So you cannot enforce until you endorse. You cannot, if the glove doesn't fit, you must quit. I'm sorry I said that. That's just one of those things you never forget. This is one of these things I don't want you to ever forget. You cannot enforce until you endorse. Bearer paper does not allow you to enforce, only to hold the right to enforce. So bearer paper means whoever holds the paper has a right to be paid, regardless of the payee line is filled in. If it says paid to the order of bearer, that is actual bearer paper. So if the payee line is not filled out on a check, it is an incomplete special endorsement, though it is commonly improperly referred to as bearer paper. It is also called a blank endorsement, provided that the payor has signed and the payee has signed. If the payee has not signed, meaning signed the back of the check, it is not a true blank endorsement, and even though there is a blank payee line on it. Okay? A payor only signed instrument can be handed back and forth between anyone, and that is called transfer. Pete requires endorsement and negotiation. But in order to be enforced, it must be endorsed. If glove doesn't fit, you must acquit. Just kidding. I just want you to get these things through your mind, and this is really important. So I want you guys to read through this stuff later when you get the slides in front of you, and these are everything you need to refer to for your cases. So this is the only statute that deals with the acquiring of rights. State equivalents, they vary a little bit, but A says what is to be done. B through D places restrictions on how it is to be done. The restrictions are important. B prohibits fraud or illegality. I've been talking too much. Break coming up in 4 minutes. In the transfer. C says no negotiation occurs without signature endorsement of the transferor. And D requires transfer of the full value of the instrument. This is huge. D, UCC 3-203D, if a transferor purports to transfer less than the entire instrument, negotiation of the instrument does not occur. Remember what negotiation is. The transferee obtains no rights under this article and has only the rights of a partial assignee. Boom. You should shut a lot of deals on that right there alone. Okay. So Freddie Mac is not named on the note or in public record and can lay sole claim to the obligation. They are not Pete. If they say they are the holder, you must ask, are you the holder in due course? There is to have been a verifiable true sale of the note for full value. Remember D, what we just spoke about. If they cannot admit and prove that they are the holder in due course and have devalued the note and or destroyed the debt or to evidence ratio, they're toast. So if they did not pay full value of the note, nugget. The note has been stripped of its value, devalued, and no longer worth what it was. Therefore, it's no longer negotiable by transfer, but it can only be negotiated in writing with description of the value that was left. It becomes non-negotiable note. Negotiation only by contract under Article 9. We only want to see a note in order to compare it to the chain of record. Pretty cool, huh? All right, guys, what I'm going to do is take another break, and I'm looking for the black screen. I'm just going to leave it right here. I'll see you in about 7 minutes. Okay, here we go. So let me get that going. A specially secured standing of holdership that allows one to foreclose on the security lien without suing on the note. That's holder in due course. Only a holder in due course can foreclose non-judicially for all you non-judicial states. Holder must have an unimpeachable, undefaulted instrument, meaning the two combined, the deed of trust and the note, for which he can then be paid full value. The holder in due course also needs to be able to verify that the one he got it from was also Pete. The phrase, call into question its authenticity, becomes the basis to question every claim to holdership. In due course, because of the fraud over the last 20 years, they have to prove it now with all canceled checks, wire transfers, acknowledgments received, and ledger books. Without these, we insist they cannot prove that they are the holder in due course. Okay? Pete, again, person entitled to enforce. Holder of the note status versus holder in due course note status. Full value must be paid. Perfected, unbroken, chain of title necessary. Always non-judicial foreclosure. The person must be Pete. Sorry. Holder in due course. The reviews. This reviews the terms of negotiation already studied for the holder. It adds the special terms that mark negotiation for the holder in due course. So Section 5, read it with me. A document is duly negotiated if it is negotiated in the manner stated in this subsection to a holder that purchases it in good faith, without notice of any defense against or claim to it on the part of any person for any value, unless it is established that the negotiation is not in the regular course of business or financing or involves receiving the document in settlement or payment of monetary obligation. I'm not going to read that again, but you are. You're going to read it a lot. You got to read that a lot. So watch. This is cool. The illustration, you pull out some car keys, accidentally pull out a $100 bill. Both fall to the ground and are retrieved by a jogger down the road. Okay? The jogger, he can keep the bill as bearer paper, but he cannot use his possession of the house keys to then claim ownership of the house or of your car. Get me? This illustration is the difference in rights between a mere holder and a holder in due course. A mere holder cannot sue on a security instrument. A thief can be a holder but it doesn't give him the right to foreclose. Only a holder in due course of a perfected chain of a lien can foreclose. This is because the land cannot transfer by negotiation, but only by written contract. Listen to that last sentence. Okay? So when we say we are the holder, ask them if they are the holder in due course. And then get ready to play ping pong. Because only a holder in due course can serve and foreclose non-judicially. So, was the borrower given knowledge or reasonable opportunity to learn of the securitization character of the note he signed, in which its payment stream would be immediately stripped from the tangible note? Question. Even if the holder in due course takes the instrument without notice of the borrower's defense against such fraud, he is still subject to those defenses, nullifying the unquestionability of the holder's status. So, Section 3-305, a defense of the obligor based on, number 3, fraud that induced the obligor, meaning your lender, or excuse me, you, to sign the instrument with neither knowledge nor reasonable opportunity to learn of its character, and B, the right of a holder in due course to enforce the obligation of a party to pay the instrument is subject to defenses of the obligor stated in Section A1. Study, study, study. So, it is one thing to be entitled to enforce. It is another thing to actually claim to be enforcing. And to enforce, one must endorse. I love that. No, I won't do OJ again. It is not enough to be possessor of bearer paper. Because this is what they do. They hold it up in court. Look, blank endorsement. To enforce, they must be able to allege they have an injury. Okay, you can't just pick up bearer paper and have an injury. It is not enough to claim that I am in default, which only allows the right to accelerate. It is not about what I have done, but about how they have harmed. These claims are not the same, however similar. So you must challenge the incomplete terms they use, such as holder and endorsement in blank, or endorsed in blank. When they say that they are the holder in blank, you must ask them, are you enforcing or are you transferring? Ooh. You have a right to do either with this in blank paper, but if you're enforcing, I need to see that endorsed. Otherwise, you're enforcing nothing. You are only telling me what you have a right to enforce. The term holder in blank is meaningless. Get this through your head. This is a part you're really going to want to nail. This is their argument in court. Allonges are supposed to be added only after the original paper has been filled up. Okay? What does that mean, the original paper? The note. Look at the note. You're going to see those endorsements down the note. Then you have an allonge, and it's a permanent attachment to the note. Okay? Here's the code that cites that. Allonges and endorsements do not go on assignments. Allonges and endorsements do not go on assignment. They are only used on promissory notes. Okay? Allonges are necessary because if they write on the back of the note, they deface it and invalidate it. How many of you have something written on the back of a note? How many? How many? Allonges are to be hot glued to the note as a permanent attachment. If an allonge is involved, we want to see that there is at least an endorsement on the original note. Guys, when they come into court and they hold up that note, look at just the last 2 or 3 slides. Do they go from A to B to C to D to E? Do they match on the note with the transfers paid to the order of? and the signatures? And is there an allonge that shows it going from A to F? Or is it going from A to B, to C, to D, to E, to F? Because they are not Pete if it goes from A to F. They can't just show you a note with your signature on it with the endorsement of Wells Fargo. It has to meet the requirements, and here's all your case law supporting it. So we have a right, like mad, over every one of these points to argue with the judge. Your Honor, if you allow this copy into evidence, you're creating a second original. Would you allow me to bring a suitcase full of copies of $100 bills to pay off my debt? No. Then you cannot allow me to be held liable for a counterfeit seized copy of a promissory note. If you will accept this copy, I will gladly pay the alleged debt with my $100 bill copies. Think about that. Remember, they bring in also affidavits. Okay? Well, I can bring in an affidavit to pay off my debt. Think about it. If a note is a copy of the original, there should be a copy of a stapled evident, meaning if the copy is of staple holes, it is a copy of destroyed original disablement. Meaning, look, you're looking at it, and you see two little holes in the upper left, but you don't see holes. You see a copy of holes. What else do you need to look at on a note? We're going to examine in a later slide. So, as to, look, I know you can't read all this right now, but our Code of Preparers, this is a basic checklist for what a Code of Preparer must do in order to check against mistakes or fraud on just the allonge or on the promissory note. We go through all this, and you're going to have a copy of this. So you'll be able to check what needs to be worked on and looked at pertaining to the allonge of the note. So true sale via an assignment, okay? Assignments of a deed of trust are meant to memorialize the sales, negotiations, and transfers of the obligation. What is the obligation? The note, for which it acts as the security. Okay? The assignment acts as the security. Now, I don't want to go through all this with you, but here is a copy of all the things. This is an example assignment. You'll receive a copy of this so you'll be able to review it later and understand what you need to be checking for, okay? So Pete, person entitled to enforce, quick review, the mortgage / deed of trust and the security deed are basically the same thing. The evidence of the note, a negotiable instrument, is the tangible promissory note. A negotiable instrument is the tangible promissory note. For a negotiation to be a true sale, certain documentary requirements pursuant to law must be met. To be a Pete, one must have acquired rights in accordance to the law. Such accordance is conducted through the assignment of the mortgage or the deed of trust or the security deed. The purpose of the assignment of a mortgage is to memorialize a transaction pertaining to the negotiable instrument being the tangible promissory note and the acquiring of the rights in accordance with the law. The assignment does not cause the sale. The sale is caused through the statutory requirements of the law. The assignment is only memorializes the sale. Under state law, assignments must be publicly recorded, and under California commercial statutes, the holder must be the holder in due course, having been paid full value of the note, or having paid full value of the note. Otherwise, it is disallowed as a claim under 11 U.S.C. 502b1. Okay, 11 U.S.C. 502b1. If they haven't been paid, in full that note, and with an assignment memorializing the transaction, they're not a Pete. So under 1641, a servicer cannot receive an assignment simply for convenience of foreclosing or administration. If the servicer is enforcing, they must be the owner. You hear me? It cannot be Fannie Mae as the owner and the servicer foreclosing, or Fannie Mae as the beneficiary and the servicer foreclosing. They must be the owner and the holder in due course. How many servicers are not the holder in due course? You all heard of Fannie Mae and MERS, right? Here's the supporting law. This is important, guys. So when you're looking for recorded assignment, this is important. You're going to look at these four major things. On the next page, I'm going to show you what a CODA preparer, what must they look at. And anybody interested in wanting to become a CODA preparer, I'm going to recommend going to David Krager in Florida to get that training. I believe it's going to be a career that'll last 50 years if the Lord tarries. I think we're going to see some amazing things. So, look, often when they file documents at once, the problem for them is there must be timeliness of filing. So you got to look at what county it was filed in, what date was the recording, what time was it filed, the instrument number. Often they do not file the things correctly. And so look at what we have to do as it pertains to an assignment. This is what we look at as CODA preparers. Crazy. Again, you're going to get a copy of this at the end of the weekend. So don't worry about it, because I don't want you reading this while I'm talking. I want you to learn. We got this down to the point where you guys are going to really go, this is unbelievable, because this lays it out. So this is a document recording what it looks like. The recording number, the county it was recorded, the time, the date, the assignment number. Simple review for you to look at later. Hold on one second. We've already shown this to you. I don't know why it's in there twice. And here's a note. It must match the information on the note. Okay? Remember something, guys. The deed of trust, or the mortgage, and the note are one instrument. Okay? The assignment must match, because the assignment is a memorialization of the transfer or sale of the note. So the note better start having a record on the note until you run out of space, and then an allonge that matches. So you go get that chain of title, and you look at the chain of title report. It starts laying out for you everybody that's touched your note or not touched it. And if they haven't touched it, they went ABD or ABF, and you have imperfected title, and you have a hell of an argument to stay the sale and get a permanent cloud through declaratory relief on title. Okay, substitution of trustee. Look, they do a substitution of trustee based on the new beneficiary of the assignment. Okay, the most recent assignment showing Wells Fargo, MERS, or not MERS, but B of A. So the substitution of trustee is based on that. And so when the B of A or whoever that lender is substitutes the trustee, their intention is to foreclose on the property because by statute there needs to be a third-party, non-biased person that's going to mediate the sale. Does that ever take place? The answer is no. Those substitution of trustees will not listen to you. They are, and they think they are, bulletproof and have nothing to do with accountability from the law. It's because if you think about this, guys, when the substitution of trustees start becoming held accountable, and you start including them in lawsuits and say, oh, no. On XYZ day, this information was sent to them, and we requested the sale stop, and they ignored that. And so we're including them in the lawsuit. They were noticed of the fraudulent transfer of information or an assignment that never took place. and they were noticed that this is not the rightful party or the holder, the Pete, and therefore these people will pay. They are not getting out that easy. So they do a notice of default from the newly substituted trustee, meaning that trustee sends out the notice of default, notice of trustee sale after 4 months. The bottom line is all these documents have been filed in the public record, and they must match the chain of endorsements on the tangible promissory note. The dates and the amounts must match on all the documents. This seems trivial, but these things are what catches the thief at work. These are really good white-collar thieves. I don't know if you all seen a show called White Collar on cable, but if you haven't, go, or Netflix, go watch it. Love that show. No, it's not a holy or godly show, and I'm sorry, I do watch some television regular. Anyway, when we do an investigation, we want to know who are the parties that are being named. All right? The NOD signer. We're looking at details. It is important because these are the parties claiming to be Pete, and they're trying to steal, guys. Listen, all right? I want you to drill this home. They are trying to steal. There's no other way to put it. They are thieves. There's no other way to put this. And they have the support, unfortunately, of high-level people that are starting to maybe become a little afraid at what's happening with the people waking up. So that's why we gave the viewer discretion at the beginning of this video, or this presentation. It's because criminals will pay eventually. They will not hide forever. This is what we need to be teaching people, is why they're criminals. Knowing that they're not Pete, but yet still trying to take the house on behalf of who? Who is Pete? In a whole nother day, a whole nother conversation, you are Pete. And I don't want to deal with that right now. But you're Pete. You're the only person with the right or entitlement to enforce, because all the digits were derived from you. Social Security Administrative Act 1935, around page 650. I'll prove it to any lawful or any law enforcement officer. So when we are going for declaratory judgment, we are going for proof of acquiring rights in accordance to the law, okay? So these are the issues in an assignment. We need the party making the assignment. It's normally they're without any authority or capacity to assign. Remember A, B, C, D, not A, D. It needs to be a clear holder in due course. Pete, party receiving assignment is without authority or capacity to accept the assignment. Party claiming power of attorney is suspect. Listen to this. For lack of recordation in the land records where A, the signer is located, B, the assignee is located, C, the subject is located, and D, the alleged real property and interest is located. Do you know how often we're contacted by attorneys regarding issues that we can't verify that they have any lawful claim to say anything to us about? Events leading up to the recordation of the assignment are suspect for document manufacturing. That's an issue in a future assignment. Okay? You can have a clean assignment or something that looks like a clean assignment, but events leading up to the recordation of that clean assignment maybe are suspect for document manufacturing. And let me say something to you guys. If you don't think that there's a thing called document manufacturing called felony, I'm going to tell you, there's manufacturing mills. When I was in the mortgage business, I'm going to drop a name. This is a true story, I would stand up in front of the room when I had all my sales guys, and at one time I had about 70 sales guys on the floor. And I would stand up in the room, I'd do my little reports and do my rah-rah and do all my stuff. But whenever I had new sales recruits, I'd always keep them over on the left-hand side of the room. And I'd always keep my leaders on the right. And my leaders were behind me. And I would point to the new sales guy and say, look at these guys over here. You could be that guy one day. And those guys were all making $10,000, $20,000, $30,000, $50,000 a month. And those guys, I would say to the new recruits, I said, these guys are licensed, and these guys are your bosses, and these guys will not accept your fraud, because in our business, I would tell them, if you commit fraud by adding 2 months onto a person's residential stay, and I find out you think it's not important, if you commit fraud and you do this, that, and the other, I will personally call the FBI and have them down here for an interview with you and fire you on the spot. And then I would show them a video of a guy who committed basic small levels of fraud. And I would show them how he got the phone call from the FBI and how they came down and they picked him up outside of the office, arrested him, embarrassed him, and he went to prison for multiple years for fraud. And by doing this, my documents would come through so clean. Well, this is what we would hear in the industry, document manufacturing mills. That's what we have right now. Back then, it was fraud rooms. Ameriquest Mortgage, out of business now. Ameriquest Mortgage was known for having a fraud room, known by management, known by vice presidents, known by the very top. This room was a copier room with all the necessary tools to document and manufacture whatever they needed to make a loan. Now, what they're doing is they're trying to cover their butts with all the document manufacturing mills so that these attorneys can come in and pretend to have something real, and it's not. So when you see and they bring a note in, let me explain something to you. That note is more than likely already been destroyed in fraud. They have machines that they take your handwritten signature and they convert it to a metallic signature, and it is unbelievable at how good it is. And that document can be analyzed in future for how long that ink has been on that paper. Remember. And even if that document did have your signature on it, is it Pete? Are all the other signatures on it, all the other endorsements in that chain of title, did they do it right? The answer is going to be hell no, and there is no Pete in this room, and Your Honor, I move this court. Boom, boom, boom. So in a judicial foreclosure, they are suing on the debt. And in a non-judicial foreclosure, they are not suing on the debt. You are prejudged or prejudgment. You signed a prejudgment. It's all about how you treat it and what you accept. MERS assignments are accepted as evidence unless you object. Ping pong. Can they foreclose without any record of assignment? The issue is not the assignment, but the note. What does the record of the note say? Can they transfer assignments all day long as a nullity? The judge's focus must be kept on the debt obligation. The assignment is meaningless. The assignment is a recognition of the sale. That's it. But the note, was it paid in full? And all these things we're talking about. So we attack it for the value received, okay? Then we attack how can one person sign for 4 entities through mergers without any written assignment or assets, right? Name changes are not enough to assert transfers of assets. There must still be an assignment because those assets are controlled by state law, which says assets can only be thusly transferred. All of those formerly known as and successor by merger to are breaks in the chain of title. Bull crap. Objection. I wouldn't say it like that, but you know. I might. Public notice must be specific, not generalized with and or. Each entity must give its own notice in the claim. Then we attack for stripping of the intangible obligation. Remember that the assignment is nothing but evidence that the debt changed hands. So we demand evidence of transference of the debt to back up transference of the trust deed. Is it going to happen? No way. They don't have it. So a security interest is a personal property interest. Okay? Assignments represent a personal property security interest. In real property security, in a real property security instrument, and thus are governed under UCC 9, UCC 9-312J, G and H, perfection of rights and acquiring of secure interest dealing with personal property. Every state has a statute regarding acquiring secure interests. Okay? All right. An instrument must be perfected by filing it into public record within 20 days of transfer, period. Period. Here it is. It is true that the mortgage follows the note, but the mortgage only follows a properly perfected note. Oh, you got a right to foreclose on the deed of trust or the mortgage? See, the note doesn't follow the mortgage. The mortgage follows only a perfected note. A, B, C, D, E, F. Not with a specific company's right to accept the assets of a previous one. It doesn't work. Perfection is through timely filing into the public record. For this reason, all mortgages are immediately filed into the public record upon closing. Thus, in any subsequent sale by negotiation, transfer and delivery of the instrument, the seller endorses, transfers, and delivers it, and simultaneously assigns the mortgage instrument, releasing interest in it to the next party, and files it into the public record, perfecting the next party's interest. Again, this must be done within 20 days. Perfection is only temporary for the 20 days, right? Yet entities show up to foreclosure that are not named on or anywhere around the note and have never been put into public record and are only put on public record years after the alleged transfer, and nobody calls them out on this. You are not the holder in due course. Shut your mouth. I don't know if I'd say it like that, but you know what I mean. I'm getting a little feisty right now. Wow. Bringing those fighting days back. Permissive recording states allow liens to be recorded at any time prior to a suit to recover. Non-permissive states such as Pennsylvania require liens to be recorded within so many days of execution. Lien positions will be reversed if recording times of liens are reversed. Assignments are covered under fraud statutes. Okay? However, we do not immediately prosecute for fraud. That's not what we're going after. Fraud is hard to prove. 18 U.S.C. 47-1021 also covers fraudulent documents. Documents purporting to pass title to land are defective due to the lack of rights acquired. If rights have not been acquired, rights have not been transferred, regardless of what the document says. This is the purpose of declaratory judgment, is to establish the status of parties claiming rights. The assignment does not cause the sale. The sale is caused by negotiation, transfer, and delivery. There's a lot of people that don't get this. An assignment does not mean you are Pete. It's caused by negotiation, transfer, and delivery on the full face value of the note. And that note better be delivered with the proper chain of endorsements. UCC 3-203, 7-501, 3-110, 3-115 are the statutes used for investigation, for laying foundation, and going forward with declaratory judgment. Go read them. Guys, we're going to take an early lunch. I appreciate you guys coming on. I will see you in 30 minutes at 1 p.m. God bless. All right. I want to thank you guys and welcome you back to part 3 of HISAdvocates Advanced Chain of Title Education Seminar. Again, like we do in every component of this, we want you to understand we have a legal disclaimer. And we do not provide legal advice. This is for education only. Okay, part 3, transferring of split rights in title, payment stream from the note. What is a payment stream? It's the intangible obligation, payment stream, intangible obligation, and securitization. All right, so in IRS Publication 938, it can be used to hold your pretender lender's feet to the fire. This comes out quarterly and outlines all the rules governing REMICs. Okay, REMICs must be filed with the SEC and the IRS. All REMIC trusts with tranches are listed with startup dates. Keep that in mind. Collateralization, debt organization, the CDO. Insurance is sold. This does not apply to the homeowner. The issue, the startup date of these trusts is what matters the most. By the startup date is when the assets need to be in the trust. Did you hear me? What is the asset? The note. Tranches are tiered from senior to junior to junk classes, carrying increasing rates of return on higher risk and longer periods of time groupings. This is why people that, in a system of debt that we are in, HJR 192, we're in a bankruptcy. Corporation, well, since the inception of the United States, we have been in debt, period. But when you have fiat currency and you're basing everything from an upside-down status because you're already in bankruptcy, the reality is there is no money. So everything is notes and IOUs, and that's what you're transferring back and forth. And those notes, and really what everything is based on, is people paying on a debt. That's how this whole system works, is payments. This is why they want to do the modifications with people. Why Fannie Mae just came out recently saying they're not willing to just foreclose and kick people out. That they're going to do you a favor, steal your house, and then rent it back to you now. That's the words from Fannie Mae, those God-fearing people. And I'm being facetious, but I'm being truthful in how I feel, because they're not living in accordance to the rule of the law, but they are the government. So I want you guys to understand that, our system doesn't work unless people are paying into the system. Debt is that intangible obligation. The payment stream is the most important thing to these people, and why you're able to get the loans you're able to get is because you pay. So that's what increases your FICO scores, because you pay. The RMBS definitions, the definitions offered here are not substitutes for legal definitions provided as appropriate legal counsel. These definitions are provided to offer a general understanding of terms. Now, are we talking about the tangible promissory note or the intangible obligation, the payment stream, or the electronic note, or the mortgage document, or the mortgage loan? What are we talking about here? Okay? It is not enough to speak of the loan or the mortgage in a court. Okay, the word loan and mortgage is not broken down. Look, just memorize this. What are we talking about here? The tangible promissory note or the intangible payment obligation? Equity. And we'll get into what is equity later. Or the electronic note or the mortgage document or the mortgage loan. See, specifically, we need to know where we are going when we are fighting our case. We can't just hear these terms and accept them. You need to define what they're saying and object and then strike. And we're going to deal with that not specifically today, but we are going to have an advanced court training specific to the declaratory judgment package. So specificity, I can't even pronounce this right now. I've been speaking too much. Specificity is required in order to determine if stop laughing. If action has been carried out according to the law. All right? Yet everyday people talk past each other and make assumptions of understanding of what is meant by the terms they use, like loan or more. Your Honor, they're in default on their loan. Well, that's great. What are we talking about here? Are you talking about the promissory note that you're not a Pete on? Is that what we're talking about? Okay. The documents. An actual loan, where it exists, consists of transactional documents, including receipts, electronic wire transfer, entities, bookkeeping, ledger entries, and paper instruments, including checks and cash, including coin. A mortgage loan is a loan secured by real property. I'm going to stop just right there. When you go into these definitions, this is critical. Real property is a trademark word by the United States. And that is something I want you to just get through your head, because you have a loan that's secured by real property, which is outlined by a legal description which talks about everything above the ground. Possession is 9/10 of the law. So let's put the permanent cloud on title. Let's quiet the title, blah, blah, blah. I'm talking about protecting my land. I'm not talking about protecting my house. I'm protecting my land. That's the thing I want you guys to get through your head. So when it's secured by real property through the use of a tangible promissory note, which evidences the debt and the encumbrances of the property rights through the granting of a mortgage or deed of trust, which secures the loan. However, the word mortgage alone in everyday use is most often used to mean mortgage loan. So, tangible promissory note, the debt instrument, defined as the evidence of the debt, okay, contains the legal obligation to pay. This is where it's at, your note. It's all about the note, not just show me the note, because they're coming in with these fake instruments. Show me the note, and let's see how good in fraud you are with A, B, C, D, E, F. And don't give me that crap about you just accepted the assets of a previous lender. No. Proper chain of custody is this per this statute. Federal Uniform Commercial Code. And the state statutory law mirroring federal statutes create the promissory note of the tangible mortgage loan instrument. According to statutory law, real property secures from the promissory note. A copy of the note is not evidence of the debt. Okay? There's only one document you signed, and only that document is evidence of the debt. So when you're holding a document that is your original note, does it have all the allonges on it? Look at your chain of title when it comes out. Read all the participating parties. Does your note that they sent you through your administrative process to make a determination if they, of that note in present day, because we're sending out these requests from them, asking them for all this information according to the federal law, and they provide crappy responses to us, and sometimes not even anything, or they'll send a copy of the note and it has one signature on it. But that note, is now being collected on by B of A, and that one signature on it is from Wells Fargo. What's the problem? You're not Pete. What do you mean, what's the problem? You're not Pete. Talk about power and your ability to talk to your lender, pretender lender. And that's the whole thing about, I'm sorry, I keep clearing my throat. I'm going to try to mute it from now on when I do that. I'm not thinking right now. I'm just getting excited about teaching, so forgive me. But when we understand what Pete is, and we understand what an instrument is, and we understand that the instrument busted apart, and we understand that, wait a minute, this is not evidence of a note or your ability to be Pete, and you know how to respond to that, that's when power hits. The intangible obligation, the promise to pay. The note is not the debt. The debt itself is tangible. Okay? Similar to the way that we handshake is evidence of an oral contract. The debt is the oral promise, not the handshake. Isn't that weird? So defined as the collateral for the debt contains the power of sale as security against the default. The power of sale is the tangible security interest. Contains no legal obligation to pay any money. Without an obligation, the note, the lien is empty. Thus we fight to show the obligation is void. If the security instrument is not filed of record giving constructive notice to the world, that's what constructive notice is, public recorded and noticed. The word constructive is public recording. Then we do not have a true property lien. So the mortgage deed of trust is seen as the real property lien if filed of record and is a separate contract listing an alternative means for collecting payment under the intangible obligation. What is the intangible obligation? Payment stream evidenced by the tangible promissory note. So, you figuring some of this out? I love this. The deed of trust only allows the lender to substitute the trustee, but is always a stranger that does the substitution. Did you just hear what I said? The deed of trust, the original document that came with the note, the deed of trust, the original document that came with the note only allows the lender to substitute the trustee. So who is it that's substituting the trustee? It's generally 3 or 4 parties down the road. So truster is maker, also known as the grantor. Trustee is the one who holds the power of sale. Beneficiary is the payee on the secured note, like Wells Fargo, the bank, whoever loaned the money, the phony money. The owner of the debt and grantee in the public records. Upon default, provides instructions to the trustee. The trustee cannot transfer title to the real property without the authority of the true owner of the debt. So you got XYZ trustee foreclosing on the property, and you've sent them information showing them that the lender is not the holder. They're not Pete. They're nowhere near Pete. You show them a copy of the note that they sent, the paper trail from the lender that communicated to you, trying to make an appearance of honoring federal law and showing you the fact that they are truly going after the obligation. I love it when a servicer shows me you ask them for proof of who they are and why their ability is to collect, and they'll send you the original deed of trust and the original note, a copy, and that's it. Who are you? There's no assignment to you. There's no nothing on recording, and they're trying to steal the property, and you tell the trustee this, and the trustee does what? Nothing. Sue them. It's fraud. Because when you can serve constructive notice to the trustee, and the trustee sees that your public recorded notice of fraud against that property has been served upon them, and they do nothing, that's a compromised trustee. So The entire instrument, you need to track the note as well as the mortgage, deed of trust, in order to get the chain of title. It is comprised of both documents, the tangible promissory note and the tangible security instrument, which would either be a mortgage or a deed of trust along with the intangible obligation. What is the intangible obligation? The payment stream. So note all three parts, unless the sole interest of the tangible note, the security instrument, and the intangible obligation, the payment stream, rests with a single person, and a person can be a corporation, there cannot be enforcement. For there to be a right to enforce any party of the entire instrument, which is two documents, all three parts, tangible and intangible, must be named to the same party. Meaning, servicer, ASC, receives your payments, payment stream, right? The last person who received assignment is Wells Fargo, right? All three parts, the note, the security instrument, and the intangible obligation, must be the same. In case of the tangible security instrument named in the public record, and in case of the tangible promissory note on the document itself, and in case of the intangible obligation on the transfer, in the transfer record. The parties. Usually the homeowner, the party whom signed the tangible promissory note. The tangible obligee, the party whom is named on the tangible promissory note as either lender or is named as the payee on the payee line, physically affixed to the tangible promissory note. The intangible obligor, also known as the account debtor. This is the party who sells the payment stream. Associated with the promise to pay by the tangible obligor. Kemp versus Countrywide. Testimony exploits this. Countrywide is in the business of selling beneficial interest, many times referred to as the sponsor/seller. So this party that creates the intangible obligation using the intangible payment stream of the tangible promissory note. Don't shake your head and go, what? Just read it a couple times. Using the intangible obligation, the payment stream. Intangible payment stream. Using the intangible payment stream of the tangible promissory note. That is cool. It'll sink in a few more times. They are seldom filed of record, meaning the intangible obligee, because all that was purchased was the intangible obligation. Okay? Making them an unsecured party without public recording and without proper sale, transfer, and delivery of the negotiable instrument. This would be the Remick Trust, Freddie Mac, Freddie Mae, or Fannie Mae, the investor. In a securitized loan, the Remick trustee will be the one to sue in a judicial state to foreclose. But the mortgage says the lender has a right to sue to foreclose. This can and should be argued. Only the lender is given this power, not the beneficiary or the successor in interest or in any entity by any other title. If they are not the original lender, according to the terms of your contract, what proof is there on the record in the county that they are the beneficiary? But they have a recorded assignment. But they operate language in the assignment. The operative language in the assignment is for value received. Think about what that just said. Not what was the value received. Was it full face value? The deed of trust contains no value. So again, where's the obligation? they should easily be able to prove it, right? Where is it, Pete? These are the secondary market sales being made every day without any evidence of transfer of note or public record or assignment. Hold on one moment. Sorry about that. The account debtor stands at the beginning point of conversation of the obligation from Article 3, negotiable instrument, to Article 9, non-negotiable security, the rules of transference for which are different. Boring. UCC 9 account defines intangible payments, rights, incidental but not directly tied to negotiable instruments. Yeah, this is where I go to sleep, guys. You can just read and you'll get more tired. It's okay. My voice will get softer. I can't do that to you. I'm going to wake you up. All right. So the account debtor is not the homeowner, but the intangible obligor. It is the intangible obligor who set up and sold the payment stream to the intangible obligee, thus becoming the debtor accountable for the delivery of this payment stream. Fannie Mae purchased an electronic record of an intangible obligation, the payment stream, off of a note that the tangible obligor signed. If the tangible obligor goes bankrupt and it is discharged, there is no more obligation attached to the note. Yet Fannie Mae is still called the secured debtor. There are no laws governing the transfer of electronic instruments. Isn't that funny? Only tangible property. So, what does this look like to move mortgage loans through the RMBS structure? All right. So, we've created a map here for you guys to look at later and take a nap and focus and digest. These are all the contracts formed, the Master Loan Purchase Agreement and the PSA, the Pool Servicing Agreement. There is also the trust indenture. None of this is negotiable. Okay? All of these securitization steps have to be acknowledged and signed off. So what they are supposed to do is the lender makes the loan, then sells the loan to the sponsor so he can make more loans. The sponsor sells the loan to the depositor, and the depositor sells to the trust. Then they fund the trust and sell the certificates. Instead, they have pre-sold these certificates on Wall Street to get the money which should have be in the mortgages already backing the security that aren't there. Isn't that creepy? Think about what I just said. And they want to nail somebody for check kiting? Really? Money is supposed to come from the REMICs, but it never does. Tier 2 yield spread premiums, where they are to take money in advance from investors, then loan it out, is unlawful. They are supposed to first make the loan, buy the loan, pool the assets, then sell the certificates to investors based on that asset. Instead, they have pre-sold all applications, the 1008, the 1003, the mortgage applications, the transmittal summary, and the residential mortgage loan agreement. Those 8.5 by 14 pieces of paper get pre-sold into these pools. And they get the money up front, and they use some of that money to make the loans and some of that money to buy insurance policies to pay out the debt. The applications with your signature is used immediately to create money, which is why MERS, MIN numbers, are pre-printed on the applications before even registered. MERS. That was a whole ball of wax. Isn't that crazy, guys? So the promissory notes were never lost. They were destroyed when they hit MERS, and they were converted into electronic copies, and they never can produce the original, but can only manufacture fraudulent original copies. Listen to my words. The note has been paid off because it was securitized through the sale. This means the debt has been extinguished by operation of law. Even if the investors are the true beneficiaries of the note, they cannot enforce it because the note has been separated from the deed, which is the entire instrument. There's one instrument you're talking about. If you want my home, you cannot separate it. Because when it was put into that securitization pool, the REMIC must become the beneficiary of record by the assignment. According to California law, you must be the beneficiary of record to foreclose. They do not have a right to have a valid lien, CALDO, C-A-L-D-O, case. But they do have a record to be able to foreclose statutorily. In effect, the statute encumbers the lien until recorded. In the second scenario, the electronic mortgage is stripped from the note and sent all the way up to the trust, the computer screen to computer screen. While the paperwork is failed to process, the original instrument is the only evidence of the debt on the earth. They were originated in paper and must die in paper. You hear me? If that paper gets destroyed, burnt, anything, there is no evidence. A picture of it is not evidence. This is why the law is in place that when your debt is paid off, they send you the note back. That is your evidence that you now have repaid the debt. They cannot be converted to code which disallows per UETA and e-sign. We will look at another securitized transaction diagram in more depth as we go on. Lawyers will defeat you based on this terminology, so pay attention. If the transfers don't happen, the securitization is in effect securitization attempt. See the Glaske case. It is important to stick to the terminology used in this case, ineffective rather than illegal or didn't happen. They use unsafe and unsound as euphemisms for illegal to remove liability for actions. So, Article 9 is for non-negotiable instruments. Every note produced for or by the FMs is for non-negotiable. None of them say negotiable instrument. They all say uniform instrument. This is proof that it is never supposed to transfer as bearer paper. A security can never be transferred like a negotiable bearer cash instrument. It must be in writing and signed in acknowledgement. Article 3 governs negotiable instrument. Article 9 governs non-negotiable. Article 9 actually governs all instruments, but people push Article 3 because that is where they can claim holder status. So we challenge those claiming to be holder. If they are holder in due course, are you a thief or did you pay full value for it? If he did not pay full value for it, his non-judicial foreclosure is out of reach. So why would these players create one instrument that is negotiable to turn it into one that is not, creating a mess? That's why they are recreating their copies and holding up their proof by claiming to be the holder. But a holder is only a holder of a negotiable instrument. It is meaningless once securitized, yet most people don't know that. They have to be a holder in due course, but they are claiming holder over bearer paper. Otherwise, they would not be able to enforce anything. which it is no longer, from the standpoint of their ability, guys, to come in and claim holder status when they don't even have an original note, and the one that they fake and phony and put up in court is not A, B, C, D, E, F. You just need to understand the UCC behind that and the case law behind that and get your mind set on that, because your declaratory paperwork is going to outline that for you. And you're not going to let them get off track. So the only thing you need to fight is pulling it into federal court. And there's a few tactics you need to fight, but it's these word plays, it's ping pong, and striking everything they put into their case as being not valid. So how can a mortgage automatically follow the note anymore if the mortgage is no longer a negotiable instrument? So if it is no longer simple bearer paper, it has to be acknowledged and signed to be transferred. Article 9 requires more steps with less potential problems than Article 3. To the right, which requires fewer steps to perfection. To the left, more. Only on the left, everything is done by contract. On the right is whether you had a right to hand it to me. So look at Article 3 versus Article 9, negotiable versus non-negotiable. And you will, again, get a copy of this. You'll be able to review it all you want later. This is the account debtor, i.e. the sponsor, the seller, who is the seller of the securities. The context is the selling of pooled papers. So Article 9, Secure Transaction, Pooled Papers, Scope 9-20383, covers the sale of accounts, chattel paper, payment intangibles, and promissory notes, as well as traditional security interests. A debtor that has sold an account, chattel paper, payment intangible, meaning stream, or promissory note does not retain a legal or equitable interest in the collateral sold. 9-318. Read that one over and over and over. The debtor in Article 9 language includes seller or promissory notes. So these conditions guarantee security. This is why the note meant for securitization is a non-negotiable instrument. The claim that they are negotiable is just lies. And if we can convince judges of Article 9, we will win much easier. The sale of notes is enforceable against the seller when value has been given. Only that. Okay? Has value been given? Remember, we keep talking about that. Full face value of the note. Seller has rights for the power to transfer rights in the collateral notes. Either of the following conditions must be met. This is kind of what a pool of securitization, it's kind of like concrete. A securitization pool, like concrete, with securitized notes in it that takes 90 days to cure. Once cured, you could only get something out of it with a jackhammer. I love this analogy. And destroy the trust in the process. You got to remember, it's a part of something bigger. And so when these people are selling the trust on Wall Street to investors, it's the whole thing they're selling. So you can't pull anything back out of it, and it's already been separated. Therefore, there's no tangible way for them to go after the hard asset, the home. So once it goes into the trust, it can never go out. So when they say they are negotiating notes via assignments years after the trust closed, that is impossible. Listen to that last sentence, please. When they say they are negotiating notes via assignments, where they write an assignment out of thin air and go from A to B to E, it's impossible because the trust is closed. So, how did they negotiate this in 2009 when the pool concrete dried in 2006? You know what I'm saying? even if the deed of trust is assigned back out of the trust into a note holder, it doesn't matter. It's dead. Why are you saying the security can reunite with the debt? That is a stretch, Your Honor. So the illustration of the security guard homesick from the bank. The security guard was homesick and the bank was robbed that day. So it is with the separation of the deed of trust from the note by securitization. It's the same thing. So did the bank have security? Yes, but it was of no value because he was not able to guard the obligation. He was home somewhere, but yeah, you still had security, but he was still responsible, but you still got robbed. Why? Because the security wasn't there when it was supposed to be to protect the obligation. You can have a security guard, you can have a gun, but it is not with you when you need it. So what good is it? Remember, Article 9, the debtor is the account debtor and depositor. This is saying that the secondary market securitization gives right to the security, collateral, underlining the note sold into the trust. The account debtor is also the guarantor. The account debtor is guaranteeing to make payments to the trust. So does the promissory note debtor have a contract with the account debtor such that if the account debtor advances funds into the trust, the promissory note debtor must therefore pay the account debtor? You see, if the guarantor guarantees to make your payment, then you're never in default. This is what we've been talking about with what they do with the 1008 and the 1003. So if they don't have the contract with you and they are not required, they did not acquire your note in the secondary market through the paper process first, they got jack, nothing. And if we have to prove that they have nothing, the only obligation is the one you signed. Where is it? Where's all those signatures that are supposed to be on the instrument itself? And when you run out on the instrument, the allonge is supposed to be glued to it, showing the proper chain of custody, showing that you are the holder in due course. Pete. I'm looking for Pete. Shut up. You're not Pete. You are a thief. So ask yourself, did you make the loan or did you buy the loan? If they say we made the loan, so ask me to show your escrow. If they say we bought the loan, you ask, well, then it should not be hard for you to produce the general ledger showing the wire transfer that you paid in full value for the loan. You thief. Sorry, don't say that second part. It might be a little distressing for the court. So this shows that the debtor in Article 9 is not the promissory note debtor mortgager. This is a pooled loan debtor. And every time your loan was pooled, it created another note under Article 8. And then your security is supposed to act as a security for that note, as we saw above. But you did not contract for that. 9-28, comment number 6, for example, if the obligation is evidenced by a negotiable note, then Article 3 dictates that person whom the maker must pay to discharge the note and any lien securing it. Of course, the secured party's rights derived from those of its debtor, subsection B, would not entitle the secured party to proceed with a foreclosure unless the mortgager also were in default of the debtor mortgagee, otherwise enjoyed the right to foreclose. I know it's confusing. Relax. Take a deep breath. It's all sinking in slowly and you just don't realize it. All right. There's no way I'm going to go through all this with you. I've put this down for you guys to show you a guideline of the flow chart for UCC articles both in 3 and 9. This is everything that you guys need to understand and to ask yourself the questions if they are the holder in due course status under Article 9, or if they are the holder in due course status under Article number 3. Here is the streams. Go to the right for Article 3, and you end up either with a Pete or with a thief. Go 9 straight down and read, and you either end up with Pete or a thief. I don't know how else to word them. So they were stripped by the originator or by MERS, okay, the obligation. Once they convert these tangibles into code before entry into the trust, they violate UETA and are not supported by law. You can pull the intangible payment stream out, but only after the trust receives the paperwork. But instead, they strip it from the beginning and destroy the original. In securitization, the payment obligation gets stripped from the tangible obligation, and that's okay so long as the paper is properly processed, A, B, C, D, E, F, G. Once the trust receives the actual paper into the trust, then they can sell their certificates as electronic code. If they strip it before they've received the paper, document is void. What does that mean if your note is void? That means there's a permanent cloud on title. And there ain't nobody kicking you out of your house. So how is the intangible promise stripped from the note? The note and attached mortgage stapled at signing is one instrument. When it is unstapled, it becomes invalid the same way a certified copy becomes invalid as certified once the staple is removed. As soon as the staple is taken out, the note is destroyed. They unstaple it to run it through a high-speed copier to create electronic image. The recipient, such as FM, Fannie Mae, is then using the electronic note as the original and claiming to be the holder while receiving nothing that is legitimate. Being disablement, and then stripped by an electronic transfer, the original paper retains only the value of paper and ink. That is crazy. So, how do you use this? The paper note can no longer be transferred or negotiated. The obligation is gone from it. The obligation is being claimed by a trust that is collecting it. The paper note has thus been devalued. It is now non-negotiable and dead. Love it. So is the original stripped of the obligation, is it the original stripped of the obligation, or is it a forged copy and true original delivered to the REMIC? So what did the REMIC receive? The true and original was never delivered to the REMIC. It never left the originator. The court does not have the original, but only a copy reprinted in a blue ink signature by a machine if need be. Interesting. All right. So how do you detect an electronic forged note? There's a lot of ways, but you tell the difference between an original and the color copy by the color of the ink and the underlining magnifying glass. The original has the smears and the indents, while the copy is flat and pixelated. The ink, meaning where you sign. The edges are perfect on a fraud copy, even if digitalized and laser printed. But even if they had an original, the question remains, was the intangible obligation stripped from it? Do they have the proper endorsements? Was it made out in blank? Did they endorse it to be able to enforce? Though they may have used an auto pen machine, you must ask yourself these questions and examine and test the ink for time and dating and go under a magnifying glass and look at the rest of these questions and expose these guys on, yeah, you're presenting this as the evidence. Would you be willing to stand up on and for the record under the pains and penalties of perjury to be the expert witness on the stand on behalf of the bank in which you represent to assert that these documents are true and correct and not forged? Hell no, that attorney won't. Okay, guys, we're going to stop right here, and we're going to take a break for about 5 to 10 minutes. Go get your food or whatever you need. I appreciate you guys being patient. I know this is a tough training, but it's going to be good. Come back in about 7 minutes. All right, guys, we got one more slide on this particular set. So what we're going to do is do this last slide, and then we're going to change sets. The walkaway scenario, exposing the fraudulence of securitization. Trust has to take funds out of the trust to fund the loan. They are allowed 45 to 90 days to figure out the borrower, why they didn't close. The 1003, the original loan application the borrower fills out on a mortgage for a house, was utilized to fund the transaction. Think about this. They take your application to fund a transaction, to get the money out of the trust pool to the escrow agent, starting the process on Wall Street of selling and fractionalizing the note before the actual note was ever signed. Think about that. Expecting that all this would actually occur based on the non-disclosure to the borrower, who was to sign the note and the docs, which were to end up in the collateral loan file and hence to the custodian of the security, where it would sit while events with MERS spin out of control and the borrower has no idea who holds the lien interest in his property. The only one on record remaining is the original lender. And if the originator goes under, who owns the loan? Without a recorded assignment, who knows? That is why that is the MERS Achilles heels. If the originator goes under and there is no assignment, borrower in California can sue for quiet title served by public notice to the Secretary of State to that original lender that went out of business. An evidentiary hearing produces no claimants. Interesting. I love it. Okay, so we're going to shut that down. I'm sorry, guys. We're going to open up the next slide. Okay, here we go. Again, disclaimer. Let me get it opened up on the next screen. Give me just 1 second. I have a few screens going right now. So transferring of split rights in title, MERS. It sounds like a disease. Oh, it is. Sorry. Mortgage Electronic Registration Systems is a wholly owned subsidiary of MERS Corp. Inc. and serves as mortgagee in a nominee capacity for the lenders or lender and a subsequent assignees. The electronic database that is used to track the intangible obligation as well as the servicing rights. Okay. Give me 1 second. Okay, I really want you guys to buckle down because the next few slides are going to be intense. All MERS is an electronic database to track intangible obligations as well as the servicing rights. MERS only operates in the intangible world. MERS tracks the beneficial interest, which is the rights to future payments. Okay, MERS does not record anything, only registers it in their system. So you got a MERS tracking number, transfer date, MIN number. All they are is a database with supposed rights to foreclose. So MERS is like an iceberg. You only see the 10% that's above the water. Isn't that interesting? MERS was set up by the bankers as a means of greed and to hide information beginning in 1993. Isn't that crazy? Angelo Mozillo. That's the extremely well-tanned, well-groomed, in a big suit that was CEO for Countrywide and sold all of his stock and just told everybody he's thinking about retirement. That's why he sold all of his stock right before it crashed and was picked up by Bank of America. As seen in the Milestones report, MERS tracks only electronic transactions, electronic transfers of servicing rights. National Registry only intended to satisfy third time in a row, UETA and e-sign for electronic notes. Due to limitations of UCC3 and UCC9, MERS could not replace the actual land record registry, so it only tracks electronic transfers. MERS does not deal with the tangible promissory note. MERS does not track the paper promissory note. MERS only tracks electronic obligations, e-notes, registered in the MERS e-registry. So MERS is limited to electronic notes and does not engage in paper notes. Where's Pete? The original instrument is the only evidence of debt on the earth. We got to get this down in our minds, guys. They were originated in paper, and they must die in paper. They cannot be converted to code, which is disallowed per UETA and e-sign. Electronic instruments are legal but must be originated as electronic instruments. They can't start as a note. MERS was invented to get us to this point and to create the bubble that would burst, resulting in the taking of the land. So they are going after the land from a law standpoint rather than an arms standpoint, meaning forceful takeover of the land. E-sign originated docs have disclosure agreements a mile long to which you agree to before signing. How is it loan applications have MERS numbers before even being signed? Think about that for a sec. It is because the securitization originated with the applications and was set up ahead of time. Then it is registered. But at the moment it is turned into code, code cannot be rematerialized into the original. It can be printed out again, but that is not original. Your living signature is the only evidence of debt. Your living signature is the only evidence of debt. Pete. Who is Pete? A, B, C, D, E, F. With all the signatories proper on the note. The CODA, the chain of title assessment that we do, it's important because it shows that the original evidence of the debt has been destroyed. There really is no original signature on an electronic e-signed document. Years later, after a default, a recording is done by an unknown beneficiary. That's like me just walking up to a woman and reaching in her purse and telling her that I have rights to something. What is my claim to those rights if it has not been recording in the transfer of an acknowledged sale between that woman and myself? I'd be committing a crime. So they're reaching into your purse. literally by trying to steal your property, and they have no lawful right to do so. So we figured out a way to use the declaratory process to get a permanent cloud on title and then go after the quiet title. The securitized instrument must be vaulted, stored to where they hang on to it for 30 years in a passive entity within 90 days of the closing of the trust. So these assignments that happen years after the trust are invalid. Remember, that trust closes and it becomes a cement pool that you cannot take something back out of. Once it gets into the trust, it can never move. So for 30 years, they can take the payment stream to pay out all the certificate holders. That's why all the subsequent assignments are lies. The National Registry is intended to satisfy the requirements of UETA and eSign for electronic notes only. Attempting to provide functionality for paper note tracking will greatly complicate the design and implementation of the National Registry. The function of MERS e-registry is a system that electronically tracks transferable records, also known as electronic promissory notes, that are created, generated, sent, communicated, received, or stored by electronic means. Due to the limitations of UCC 3 and UCC 9, MERS could not replace the actual land record registry, so only tracks electronic transfers. Transferable records are related only to personal property, not real property. You could say that 10 times until you digest that. These private label secondary obligations called transferable records are not a direct obligation underlining a mortgage loan. E-notes are private labeled secondary electronic obligations called transferable records and governed by UCC, blah, 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 all the boring stuff. So I find it interesting that they're still coming after people with this much knowing of the fraud. And I'm sure, but there's a bigger fraud behind it, and understanding why about all this, which we're not going to address in this training. And we get it why, but it's not fair, it's not lawful, it's not any of that. And so, but being the fact that the United States is in an open bankruptcy, there basically lies your reason. A transfer, well, that's not your exact reason, but the fact that we are under military rule, which we can prove in law, and that the United States citizens are combatants and enemies to literally the state under the Trading with the Enemy Act. We want you guys to realize this, why you're being treated this way in court. And so the only way to deal with them is using their own laws against them to gain favor. And this is the road we're going down, and it's basically the best road I've seen out there by far. In all the years I've been doing this, nobody's offering anything like this that is getting the actual facts and the law and information into the hands of the people. A transferable record is not the same as a written record under UCC 3. It is not the same as a tangible promissory note. They lead you to believe that the electronic equivalents are the same as a paper, but they're not. See, a transferable record is an electronic-oriented obligation governed by 15 U.S.C. and is not a direct obligation of an underlying real property mortgage loan. Okay? E-docs pertain to personal property only. MERS claim that it electronically tracks ownership after it records its is meaningless. It, according to the Uniform Electronic Transactions Act, UETA, and the Electronic Signatures in Global and National Commerce (eSign) Act, no paper mortgage contract can be converted into an electronic contract without destroying the original and violating 15 U.S.C. 96-17003. The function of transferable recorded is an electronic equivalent of the negotiable instrument, but only used in an electronic world of e-mortgages. A transferable record is not a UCC 3 negotiable instrument. So when MERS transfers a note, it is only an e-note and not a tangible promissory note. Nominee is not a lender. The beneficiary of a bifurcated note. I'm so tired, guys. My voice is done. I'm sucking water down in the background like crazy right now, so excuse me. Bifurcated note. Mortgage is valueless. Stop laughing. Electronic notes lack supporting law to exist. All of these transfers are beneath the surface of the iceberg. All of them. A lawful secured indebtedness must occur on paper. So, e-mortgage is a copy of the tangible contract evidences an alternative means of collection where there is a default on the payment in tangible. And a lot of people go, what? To properly negotiate a lawful secured indebtedness up to Wall Street or Fannie Mae and Freddie Mac, you need a paper promissory note, a negotiable instrument, governed by what? Along with a valid perfected paper security instrument naming MERS as the nominee does not meet the definition of lender naming MERS as beneficiary. See, MERS is coming after you as a nominee. They're not the beneficiary. Bifurcated, I got that word again. I hate that word now. I don't like that word. The paper security instrument from the paper negotiable instrument at the moment of conception. We know that the electronic documents lack supporting laws to exist. So, the court says that just because MERS calls itself a beneficiary does not mean anything. But unless you dispute it, you acquiesce. Period. If you say nothing, it's guilt. When it says MERS is the beneficiary under the deed of trust, there is no such thing. There's no such thing when MERS is saying it's a holder of the deed of trust. It can only behold the debt obligation, not the lien, meaning the note. So Bain versus MERS, we answer the first certified question, no, based on plain language of statute. MERS is an ineligible beneficiary within the terms of Washington Deed of Trust Act, and it never held the promissory note or other debt instrument secured by the deed of trust. In the alternative, MERS suggests that if we find a violation of the Act, MERS should be required to assign its interest in any deed of trust to the holder of the promissory note and have the assignment recorded in the land title records before any non-judicial foreclosure could take place. But if MERS is not the beneficiary as contemplated by Washington law, it is unclear what rights, if any, it has to convey. That's cool. Okay, eSign. eSign does not govern electronic negotiable instruments or any electronic security instrument, therefore cannot legitimize them for purposes of memorializing real property transactions. Okay? Any transfers that have been executed without recording with the county recorder are void under Uniform Electronic Transactions, USC 15. Write this down. Okay, 7003, specific exemptions. Except requirements, the provision of 7001 of this title shall not apply to any contract or other record to the extent it is governed by the Uniform Commercial Code as in effect in any state, other than sections 1 through 107 and 1 through 206 in Articles 2 and 2A. The above noted exception clearly states e-sign does not govern electronic negotiable instruments or an electronic security instrument. The fact is that UCC 3, sorry about the mistake there, governs paper negotiable instruments and paper security instruments, and the UCC does not provide supporting law for the use of an electronic negotiable instrument or any other electronic security instrument. Therefore, any attempt by the banks to utilize the UCC as a legal authority, therefore, any attempt by the banks to utilize the UCC as a legal authority before the courts in an attempt to show the UCC has legal governance over an electronic negotiable instrument or electronic security instrument is misplaced. MERS, the greatest role is in that of the security instrument. At the Mortgage Bankers Association, we define an e-mortgage as a mortgage where the critical loan documentation, at a minimum the promissory note, and preferably also the security instrument known as the mortgage or the deed of trust, and other closing documents are created electronically, executed electronically, transferred electronically, and stored electronically, aka the paper mortgage. These electronic documents are not documents that you signed. E-documents are created by a third party known as the account debtor. So this is Freddie Mac's get-out-of-jail-free card. That's what they use. They tell the servicer that the servicer must tell the borrowers that e-notes sold to Fannie Mae are enforceable. E-records are involved, and they must comply with all the applicable state and federal laws. Of course, servicers don't do any of this, and the whole e-note enforceability violates the UETA and UCC and state equivalents. So as stated on page 12 of the Freddie Mac e-mortgage guide version 2.0, the servicer, the seller, must also comply with the applicable purchase documents and make the representations and warranties in the e-mortgage guide, including without limitation that any e-note sold to Freddie Mac will be valid and enforceable, and that other electronic records created, provided, signed, or otherwise processed using the e-closing system were so created, provided, signed, or processed in compliance with applicable state and federal laws. MERS basics, registration versus recording. The MERS system is not a system of record, nor a replacement for public land records. Mortgages must be recorded in the public land records, tracking versus transfer. The MERS system is a tracking system. No interests are transferred on that system, only tracked. Don't forget that. See, in a paper world, we have possession, original note, investor, custodian, endorsement, holder, in due course, servicer. In an electronic record, we have a control, authoritative copy of the e-note, controller, location, the e-vault, the transfer of control, transferable record of audit trail, controllers. Think about this for a second. How are they able to be the nominee to take your home? Think about that. They don't have anything, any proof, and are not acting as the beneficial interest. They can't do anything as a nominee. So we're going to get into a lot of court cases tomorrow to help you understand how to deal with this. So key assumptions used in development pertaining to MERS. Industry investors will require e-note registration. E-note must refer specifically to MERS e-registry. Participants must be members of MERS. Registry does not store e-notes. Multiple e-vaults will be created to store e-notes. Funding of loans occurs outside of the registry. There is a right and a day difference between what MERS does in its e-world and what occurs in the paper world. Yet the e-world is masked to look like it functions in and complies with the law of the paper world. This may be legal to them, but it is not lawful. This is a big thing we've been trying to teach HISAdvocates members. Legal versus lawful. Acquiring of rights must be done in accordance with the law. So what's different? They create an e-note in a smart doc format. They execute an e-note with digital signatures. They e-store in a compliant e-vault. They deliver an e-note to investor. They transfer the e-note from one e-vault to another. They service e-notes. They interface with MERS e-registry to record these steps. Where's my note? Who has my note? MERS is not a party to the note, is conferred no rights, cannot assign what it does not have. Okay? If you look at here how an origination is done and the flow, this helps you understand what I did to a point of, in my job before, in helping, unfortunately, this unknown fraud at this time that I did through 2008. But there was a opportunity to help people get into a home. We just didn't understand how they were actually getting in it. I thought they were loaning money. I had no idea. Again, you'll get a record copy of this. I'll clean up the way that it's laid out here. For some reason, it's not laid out very well. But you'll get a copy of this for your purview later so that you can make a determination on how the process flow happens. So in MERS versus Nebraska Department of Banking and Finance, MERS denied being a lender. Okay? MERS claims to be or denies to be whatever is convenient for them when it is convenient for them. MERS appears on the mortgage but actually represents MERS Corp. This can be used to invalidate the mortgage for wrong party named. MERS Corp members don't have to keep MERS rules, including filling out MERS milestone reports, making them pointless. So many MERS assignments are self-assignments and self-appointments with switching on foreclosure mill hats. Agency relationships have to be verified, people. Power of attorney may be recorded. Delineating scope of authority. Powers of attorney must be recorded in county land records. Powers of attorney have to be recorded at the beginning or before the document beginning authorized for executing by the power. If not, it is an issue of failed standing to execute. MERS can claim no interest in property because it is not a lender. It has no assets and therefore no point in suing it. It's what's called referred to a bank. I think it's a bankrupt transmitting utility. MERS has no direct covenants that give it season. Remember that word? However, if MERS is involved in the previous owner's dealing, it needs to be discovered, as it could affect the present interest by way of encumbrance. We search the previous owner's records and we see if interest was given to MERS at all. Once standing is defeated and the case is dismissed, the next step is quiet title, but you cannot do quiet title until you resolve standing issue and prove that Pete is not present. Pete is never present, guys. Hardly ever. Berry versus MERS, Tennessee, Appellate 2013, allows for charges of fraud against MERS. In most states, it has now been ruled that MERS cannot convey something that they do not have an interest in. So disconnect the agency of MERS and the whole game stops there. It disconnects all the players. The whole chain of custody of the note stops. The chain of title to the note has gone in so many different directions that the true boss of the note is not identifiable. Isn't that interesting? Okay, what we're going to do right now is take a 10-minute break. I got to get something for my throat here, and I will see you guys in about 10 minutes. Okay, so we're back in business, and let me get my stuff put in effect. Here we go. Okay. MERS is a fictitious entity with a laptop claiming to be a beneficiary. By what right? But they claim it is because they are written into the deed of trust. But the deed of trust refers to MERS by a way of acting as, not authorized as. That is powerful. In the Salazar case, U.S. Bankruptcy Court Judge Margaret Mann declared MERS is not a beneficiary. They do not own or control the power of sale. We request judicial notice of this case. MERS assigns itself as beneficiary but without authority from the lender. They're acting as, not authorized as. So its beneficial status is null. This is the thrust of MERS versus Robinson case. MERS as an agent has no standing to be noticed specifically in a quiet title action. MERS claims to have standing with respect to the deed of trust but has no standing with respect to the obligation, the note. So any other standing is meaningless. The word acting for does not equal authorized to. A borrower acknowledging that MERS is acting as an agent does not mean the borrower acknowledges that MERS isn't authorized, nor is it a claim against authorization to be an agent by power of attorney or any other means. At the point of the signing of the deed of trust, you are the only one who has authorized anything. To be authorized, there must be a demonstration that authorization in the chain by way of endorsements holder in due course. Salazar case hits on this, saying MERS says it will do whatever is necessary to comply with the law and custom. When was it never necessary to do so is the question. So comparing recording procedures. The county recorder's office, MERS is not a party to the note and has conferred no rights. One cannot assign what has never been received. This is heavy. This is the way it was before MERS, pre-1997. Look at all end up where? Look at the bottom, in the middle, county recorder's office, all of them. That's where they go. Why? That's the constructive notice to the public. So the parties are in light blue. The note is in green, so you can track the note. Just pick one, track it. This is one of the killer maps that I've ever seen. Security instrument is in gray, the assignment is in purple, and so on and so forth. The average time from Party A to Party D and F was 120 to 180 days. Crazy, huh? And you can sit on this one for hours. Look at this one. Banks saw that the paper system as a waste of time and money, where electronically they could make it more faster. So look at what they wiped out. All the X's are the previous map that were wiped out. What was left? The green, the note, electronically being pushed everywhere. Isn't that crazy? What a difference. So what the banks often actually do, to do things this electronic way, the banks are sidestepping statutory requirements of law. Questions to be asked always: what are they transferring? How are they transferring it? What is the purpose of the transfer? This is mind-boggling, where all this stuff goes to keep a mindset around what's really going on. So if the chain of title is lost for a foreclosed property, any property that shares a common property boundary line with that foreclosed property, now listen to me carefully, may also have lost its senior rights in a boundary dispute. Boundary disputes between neighbors are very common. However, they are historically not well publicized. This is simply because these boundary disputes were previously resolved by searching chain of title records and dividing property according to the principles listed above. Now that the chain of title is destroyed, severely diluted, these same boundary disputes will require court intervention to set boundary lines. Additionally, because of clouded titles, both foreclosed property owners and their neighbors may not be able to sell their properties because buyers will not be able to obtain title insurance or provide same warranty deed issued by a lender, and consequently, buyers will not be able to obtain financing. Now, title insurance companies, knowing the bank's chains are bad, require the banks to indemnify them from harm against these bad chains. People who buy foreclosures are now not in good shape, because in the days to come, when they find out the chain has affected them, they will learn that the title insurance companies don't really insure good title, but only say that they will pay out in the event that they find that title chain is bad. Remember the lawsuits against the 5 major banks from multiple county recorders across this country? One recently came to a head saying 90% of all loan documents are fraud. All recorded documents are fraud. Only it is the bank that will pay out because the title company is indemnified. What does that matter, the bank pay out? The bank made 30 times on this. This whole thing is a scam. So if you did not really buy title insurance but an indemnification agreement, that kicks in when you discover the fraud. That is fine. But when you are ready to sell, you won't be able to get title insurance. So the union of all elements constituting the legal right to control and dispose of property, the legal link between the persons who own property and the property itself, the legal evidence of a person's ownership rights and interests in property. Title is the manner in which the right to real property is acquired and conditions necessary to acquire a valid claim to land. Title is the right itself, the legal consequences of such conditions. That's a same slide that needs to be reviewed over and over. So, the MERS registry holds a list of parties who should have been in the chain of title as secured parties, but the first subsequent intervening party failed to permanently perfect their interest of record. As these intervening parties bought and sold the interest, often within a day's time, all were under the belief that they had a perfected interest. Just because it was a MERS registry, the registry is not a recordation. This is failure to perfect pursuant to 9-312 USC, or UCC, excuse me. So we do Freddie Mac, Fannie Mae, where do Freddie Mac and Fannie Mae and MERS and MIN searches? We do right out of the gate. Right from that initial 1003, 1008, the transmitting summary and the residential loan agreement, right when we go and apply for a loan, we do those numbers. If dealing with either Fannie Mae, there will be unrecorded assignments. They don't record those till the very last minute. So just because you don't see MERS in the chain of title doesn't mean they're not there. So how do they become engaged in the system? MERS appears on the original loan paperwork, generally, right on the top. They call it a MOM loan, mortgage originated loan. MERS is assigned into it later as well. If MERS involvement on the property shows up earlier than the warranty deed date, the former owner was involved with MERS. This becomes a basis for checking with the nature of what the former owner gave as grantor. To whom has a lien and could affect quiet title. Grantor could be liable under common law tort for unclean title under a warranty deed. If MERS does not appear in the land records or in the MIN search, it does not appear in MERS that MERS is involved at all. Sometimes on old records, after MERS has transferred to the final entity, it will delete the record and therefore it will not show on the record. About 60% of loans are MERS, about 72 million loans. So we do the MIN search using the property address only. Selection to determine whether MERS is involved anywhere in the chain. And right there you can find the MIN search. Tom Fox, foreclosure defense attorney, discovered that Fannie Mae instructed the originating lender to draft an assignment to Fannie Mae. And Fannie Mae did not record it, but put both it into the collateral loan file. This is probably because FM does not want to pay transfer taxes. Fannie Mae pays the originating lender who loans more money in theory while Fannie Mae derives their money from the investor pools. IRS Publication 938 since 2009 reveals dozens and dozens of Fannie Mae trusts. The Fannie Mae, the FMs are administrators, trustees of and for these trusts. If the Fannie Mae's do not cooperate with FOIA, a lawsuit can be filed naming Fannie Mae as a known party and subpoena in discovery to produce the file. Ginnie Mae, FOIA requests have to go through HUD. So looking for Fannie and Freddie and Fannie, 2 other systems mandatory to search the requiring property address and the Social Security number. The last 4 are required, meaning to look in their sites and to determine whether it's a Fannie or Freddie. We check the date of the Fannie Mae acquisition with the chain once either Fannie Mae claims to own the loan. We use a FOIA to obtain ancillary docs from the Fannie Mae to discover the collateralized loan file. This produces your known chain of title assessment, which we use to sue for declaratory relief. So what we're going to do now, guys, is I'm going to get my voice recovered. I'm losing it. And I'm going to quiet it down, and we're going to take a break. We're going to take a full hour. I am done on my slides for the day. We have multiple a long and arduous slideshow presentation tomorrow, but it's going to be very impactful, very good. Excuse me. I will see you at 4 p.m. Pacific, exactly in 1 hour and 10 minutes. I appreciate it, and God bless. All right, guys, we're coming back from a nice long break, and we've had a lot of time to ponder on the information that was brought forth. We have Mr. Joe Esquivel on the phone with us. He actually writes our codas for us at HISAdvocates. He's been a purported expert witness in many cases. He's flying out tomorrow to do another case in Florida, I believe, and he'll be flying out again next week. This has kind of been his life and his blood and his passion for the last several years. We're proud to have him as a part of the team here, and he's going to work with me on getting some of these questions answered. If I could ask Chris if you can go into the live chat room on the HISAdvocates site, and if all you can, because I don't really see any questions. I see one question on the wrong chat room. And Joe, it says, at what point in a case do you need an expert witness?
Every case is different. Some cases there are no expert witnesses. It depends on where you're at in your case. I mean, are you in front of a jury? Usually it's when you're at trial. So when you're at the trial, when you're at the very end, when you're having a trial, whether it be in a bench trial or a jury trial, that's when both sides show up and have their witnesses, whether it be a fact witness, rebuttal witness, expert witness, whatever. So when you're in trial, that's when the witnesses come forth for both sides.
Does an evidentiary hearing call for an expert witness?
Not really, no. I mean, it's just an evidentiary hearing. It depends. There are some hearings. I mean, I've been at Rule 120 hearings where, I've come in as a witness. So it just depends on what the civil rules of procedure are for that particular hearing. I've had people try to bring me in for all different sorts of hearings, but they need to look at their civil rules of procedure for that hearing pertaining to their jurisdiction for that court.
Mm-hmm.
If you're in there getting summary judgment, I've had a couple of cases where I've been asked to come in, and because when they've been given summary judgment and then they file their opposition to summary judgment, say they've had summary judgment and then they have to respond, they've got 30 days to respond to it. Well, if they can show genuine issues of material fact, all right, then they can overturn that summary judgment. So, occasionally I've been asked to come out to that. So, again, it just depends. There is no formal other than, usually it's for trial.
Gotcha. We do have a question. And, guys, I'm going to ask that you now please go into the Q&A over on the HISAdvocates chat room. I notice there's very few participants on that side over there, but we have a lot of people over on the call side. If you got questions, this is the time. You need to be asking them. We want you to get into that Q&A immediately and get that done. do have a question. If I bought my home as an REO, as is, from Wells Fargo, does that agreement supersede any MERS or potential fraudulent behavior with the note, et cetera?
If you bought an REO property as an investor, I would do my due diligence and have that title checked before you buy anything. Did you get title insurance for a clear title? There's a couple of companies out there that are not issuing title insurance for anything that's got MERS on it that's been in foreclosure. Be wary if you're going to be an investor. That's all I'm going to say, is because you don't know what you are getting. If you buy a property thinking that you had a $500,000 property, you picked it up for $100,000 or $80,000, and you got a deal, and you move into this house and you put another $100,000 into it, and suddenly you get served with a former owner that's naming you in a lawsuit.
That's going to happen a lot.
Exactly. It is happening right now.
Yeah.
It's happening every single day, I'm telling you. And I know, a particular couple of cases in California where the purchaser of the house is now paying thousands of dollars out of his pocket. And in one case in particular, he's been kicked out of the house and the homeowner moved back in. So, buyer beware.
It's pretty interesting to me that we have such fraud on the table with everything that's going on in this country, and we understand that, there isn't money being transferred. We understand that there's really truly not a loan being made, that it's really the credit from the people, their signature, that creates the digits within the system. And then you look at the notes and you look at, everything and how it runs. Honestly, Joe, do you see, what I see is we got an issue on title for 50 to 100 years to come. We have lawsuit galore. If this country can, tarry, a potential financial collapse, we have lawsuits galore that is going to happen. How do you recommend somebody purchase a house? What would you do personally to purchase a house to make sure you're free and clear of encumbrances of a previous set of owners?
Purchase a new house?
Yeah.
And if I was purchasing, say I was purchasing a used house, that was on the market,
right.
I'd do a title search and see what's this house in foreclosure. If it was in foreclosure, I would definitely think twice about, doing a quiet title complaint against all parties, but doing a declaratory judgment complaint first to make sure that there are no parties that come to this quiet title party, I would definitely make sure that the title was free and clear.
Mm-hmm.
It's going to cost you a little bit of money, but if you're spending hundreds of thousands of dollars on this property, I would definitely want, to do my due diligence.
Mm-hmm.
Do a voluntary liens report. Identify, was this property in foreclosure? If it was, it's going to raise red flags. And then if it was in foreclosure, I would definitely check and see, is there any litigation? Is there lis pendens on the property? Who are the parties involved? Get hold of the title company. Make sure you have title insurance on it, to cover your ass.
Do you know of any title insurance companies that are paying out on claims?
As far as having
anything. I've just never even heard of a title insurance company being gone after on a claim on title.
No, I haven't heard of anybody paying on it, but that's what they're supposed to do. I know a couple of title companies that are getting sued by the new homeowner, because, they were supposed to issue clear, title insurance for the property when they bought it. And suddenly you got, a former homeowner in there that's suing everybody and their mother.
So, real quick, back to the back to the question on the REO as is with Wells Fargo. I'm just trying to make sure, did we get that properly answered? If they bought it from, where the previous agreement potentially had MERS on it, as an as-is real estate owned, which is a foreclosed property. I mean, that's basically what it is.
Do your due diligence, go in a public record, and see, was there any litigation on that property? Is there any litigation on that property?
So does he have the ability to use anything that happened with MERS prior to his purchase, or no?
No, it'd go back to the other party,
Gotcha.
That had it on there. Remember, all MERS is an electronic registry for private members. It's like a PMA, Private Member Association.
We do have another question. Instead of waiting for a notice of default and playing defense all the time, what can we do to go on the offense after these pretender lenders? And I think we're pretty much addressing that within the declaratory relief package. And this is probably one of the best packages that we know of out there, where it consists of starting with getting the chain of title produced, moving towards suing for declaratory relief based on the assignments. And what I'll do for the gentleman that asked that question, off this call, I'll be more than happy to call you personally and go over that and how that's working and what can be done in order to be on the offensive. You always want to be on the offensive. You want to put them in a position of a defendant. Next question. Chase, in a motion to dismiss claims, Texas law does not require the party to establish holder status to foreclose. How do you respond?
No. Again, holder status, I mean, the mailman can be a holder. You've got states where in order to foreclose, all one needs to do is to just be a holder of the instrument. But understand that just because you're a holder of the instrument, right, you have not acquired rights, of the note. All right, so you're the bearer. All right, they say, Joe, under 3205B, all right, if an endorsement is not a special endorsement, it is a bearer instrument. Okay, fine, so it's a bearer instrument. All right, but that bearer instrument, you have not acquired rights to that bearer instrument. You're just holder of that instrument. That's all you are. You're not a holder in due course. Go look under 3501, all right, for holder in due course. That will tell you the definition of a holder. But nobody goes there. They give partial arguments. So yes, you're correct. There's a number of states where one only needs to be a holder to start the foreclosure process. But again, just because the state's requirements for acting on this foreclosure process, all right, they still have not acquired rights to the note. They have not acquired the right to foreclose because there is no properly secured party. But it's up to the homeowner to show that they have not acquired rights to the note. All right? Because your deed of trust in California, the only thing that deed of trust does is it is an alternate means of collection. That's what it is. They can either collect on the note, all right, but they never do. Why? Because they're not identified to the note. So they come and they use this alternate means of collection. But that alternate means of collection needs to be attached to the debt that is evidenced by the note. But when it says paid to the order of with an as of yet unnamed payee, the party has not been identified yet. So even though there may be an assignment of deed of trust from MERS to any RMBS, okay, or to a GSE, government-sponsored enterprise such as Fannie Mae, Ginnie Mae, or Freddie Mac, all right, what was the purpose of that assignment? The purpose of that assignment was to memorialize the sale and the acquiring of rights of a negotiable instrument. It did not cause the sale. The sale was caused pursuant to statutory requirements of law, and that never happened. All right? Fannie Mae is never named into public record. Fannie Mae is never named to the note. And yet you've got Wells Fargo, you've got J.P. Morgan Chase claiming, hey, I'm acting on behalf of the owner. What owner? They're not named to the note. They're not public record. How do we know who the hell the owner is? Pursuant to 3203, that is the only statute in which one can acquire rights. That is it. A defines what is to be done. B, C, and D place restrictions on how it is to be done.
So you're saying Uniform Commercial Code 3 dash.
Yes. So for California, it'd be California Civil Code.
Right.
So, when you understand everything that we argue, all right, we don't argue citation. We don't argue common law. Right? We argue statutory law, black letter law. And no, the judges aren't listening, so this is why we have to beat them over the head with it. You have to understand that you're setting you up for appeal at the appellate level from day one, because you don't know if the judge had a bad night, if his wife yelled at him, if his mistress is giving him heck. You don't know. Sometimes in the courts you get a grumpy old raisin showing up that's 70 years old, and you're not going to change his mind no matter how right you are. I was just on a call on Thursday for a case that was in Florida, and they were just stepped outside the courtroom, and I was talking to the attorney and giving them all the information. Wells Fargo came forth, and they said that they were acting on behalf of Fannie Mae, and this is an FHA loan. FHA is Federal Housing Authority, all right, Ginnie Mae. And yet Wells Fargo is claiming, no, we've got power of attorney from Fannie Mae. Well, while the attorney was on the phone with me, I pulled Fannie Mae website and a few other databases I have. Nope, they're not. They're lying. And blatantly, in the courtroom, they're telling the judge they have power of attorney. But yet they have nothing with Fannie Mae's name on any part of this member's loan. You don't see Fannie Mae anywhere. The court is just saying, you know what? We're going to side with the bankers because they don't lie. And this is why we need to step it up a little bit.
That's where you disqualify the judge.
Exactly. You're going to have to go hit him with the Title 42, Kelby.
I wouldn't do a Title 42. I'd simply remove him from the bench, go get a different judge, show that he's got a pecuniary interest in that particular loan. Form 750. We have another question. Do we stand on DJ paperwork, declaratory judgment paperwork, or do we have to argue with the bank and attorney and judge? So this is from a pro se standpoint, pro per standpoint, where we have a party that is going to have the declaratory judgment paperwork, and they want to know, did they just stand on the pleadings as submitted before the record of the court, or do they play ping pong and make sure that they hit the ball back over into the judge's court and slash down what they're saying and argue with the judge? And what's your answer?
Okay. It depends how comfortable they are. If they're not comfortable at all, okay, stand on your pleadings. Read them out loud. Get them into court record. I've had people just stand there and, excuse me, Your Honor, I'd like to put this on record, and they just start reading. And they put it on the record. All right? If you don't feel comfortable in your arguments, all right, not everyone can argue like I can, I just filed a complaint to my court in Las Vegas 2 weeks ago, and I had someone ask me, I had an attorney, as a matter of fact, asked me, Joe, why don't I take a look at your arguments, and I'll, give me $1,500. I'll look at them, and I'll make sure everything's cool. I'm like telling myself, who the hell is this guy, I'm going to let this mouthpiece answer for me? No. I can argue my arguments better than anyone. I can back all my stuff up. But, the attorneys are just mouthpieces. If your pro se litigant member feels comfortable, let him argue. We can help him and educate him, and you can do a mock jury trial. There's all sorts of things that can be done. He can watch webinars over and over again until he's comfortable. insane, or he can just stand on his pleadings.
Mm-hmm. Next question. This is from Vital. Will there be any help with documents, templates, et cetera, for the declaratory judgment? The answer is absolutely. You're helped 100% through the process. You, I believe, purchased the entire mini-ARC process. You don't really need samples because you're going to get a completed CODA and a completed declaratory
There is no
package.
sample because, Kelby, as you know, and you and I both discussed this, everyone is different.
Oh, yeah.
While you're all similar, okay, everyone is different. I don't care if you tell me, well, Joe, you know what, my nephew had Fannie Mae and I've got Fannie Mae, and I don't care. Everyone is different, all right? The interest rate you paid, the maturity date, everything, and it's these little things that change. I mean, I just had two clients, father and son. They signed closing the same day, all right? Their loan amounts were almost identical. They're both in Fannie Mae, except one's in one Fannie Mae, one's in another Fannie Mae. They were at the title office the same day, same office, closing within 30 minutes of each other. But yet there's little nuances that distinguish the difference.
We have another question. The property was assigned by MERS on 6/12, and then another assignment was recorded by MERS, who has no authority to, on 6/14. And the assistant secretary works in the bankruptcy department of Wells Fargo, who now is foreclosing, and they recorded it. Meaning it's a little gray, Shelley, if you could restate that a little bit, but I believe what you're saying.
She was in bankruptcy, and while she was in bankruptcy, they did an assignment. Is that what she's saying?
I'm not exactly sure. I'm going to let her clarify that, but she said the second part to her question. What do you do if you got a reconveyance and then 7 months later it was assigned by MERS to someone else, and now they are doing a judicial foreclosure in California? You got a reconveyance from the lender, and then 7 months later it sounded like, what do you do?
Who reconveyed what?
Yeah, Kelly, you got to ask that question a little more clearly. Who got the reconveyance? Did you get a reconveyance, or from who to whom? And then
if it was reconveyed, it wasn't from the homeowner. I mean,
well, there's
or
some
it was
people
sold.
that join our website and get reconveyances using, discharge debt instruments, and then 2 years. I got one right now specifically. I'm absolutely amazed. She did an instrument based on that theoretic birth bond account, got a full reconveyance, got the letter that her debt was satisfied and paid in full.
Did she get a release?
Got a release. 2 years later, they're coming back after her for the debt. 2 years, they're saying that instrument was not good, and they're coming back after her for the debt. And
did they create the instrument? Did the bank create it?
No. She sent them the instrument that discharged and settled the debt.
Okay, so I know what they're saying.
Whether it's an EFT or whatever, but the point being, their books said that this was paid for 2 years. And it was in their system, and they realized it was done with a set-off instrument. They went back and said, let's go after the property because there's no way that she's going to be able to defend it, bottom line.
I know what she did. Yeah. I know why they're coming after her, and the reason is because they didn't. She took it off their books. They didn't take it off their books. Meaning that by the actions that she took, she got it removed. It wasn't something that they did, that they initiated to remove it, whether it was ACH, A for V, EHC, whatever.
Right.
No, I know exactly. I mean, personally, I know exactly what she's going through. But she's just going to have to fight him like everyone else. I mean, because the courts are not going to recognize what she did. And I'm just being right up front and honest.
Yeah.
All right? They're not going to recognize it. They're going to say, listen, this is an administrative thing that you did, all right? Show me judicially, statutorily, that what you did was within the guidelines, statutorily.
Right.
Not administratively, statutorily. And I'm telling everybody, okay, I have done everything. I've tried everything. You know, you name it, Joe's done it. From negative averments all the way through everything that Kelby has named. So, but the only true way that I see of anything being cleared, Kelby, is judicially.
Yeah. No, and I agree with that statement on this regard. I'm going to be helping this person in this particular issue. I think she has an excellent.
It's going to be fun, though. I guarantee you. I mean, you can have some fun with it.
I've never heard of anybody making the lender go away, get a full reconveyance for 2 years, and then now they're trying to foreclose on her? Are you kidding me?
The reason is she reconveyed the property.
No.
They did not.
They reconveyed the property.
To whom? Did she?
To her. They gave her the property and gave her the release letter. And for 2 years, they were gone.
Okay, so did she file this release letter and put it in public record?
That I don't know.
Because then she would have given constructive notice to the world.
Yeah.
There, if she has not, I would do that. Give constructive notice to the world, hey, you've released it, here it is.
Okay.
Because then if you're going to do any judicial action, now you can say this is a public record, and then you can exhibit that into your complaint. It'll be public record.
Looking for the next question, Joe. Give me a sec.
Mm-hmm.
If the originator is out of business and now PNC Servicer is in default with MERS in the transaction, what would you do? Same thing.
Mm-hmm.
Same thing. Get a chain of title assessment. Go and look for the like in talking with you, Joe, and everybody else I talked to, I have yet to see a perfected chain of title. So the best way to go after it is declaratory relief against the assignments or deed of trust.
No, you need to get the declaratory relief, because once you get the declaratory relief, then you take that order, file it in a public record, give constructive notice to the world, all right? Now you've got preclusion. Now you've got res judicata, where, you know, you have that declaratory judgment that is separate from any action other than itself.
Mm-hmm.
It's a determination of the courts of a status quo of parties. All right? Now you've determination their status, and now, you know, pursuant to preclusion, issue the preclusion and res judicata, they can't come forth. And you've quieted the cloud on title without filing a quiet title complaint.
Okay, next question. How is a HELOC different? She checked your partner's old boss's website, and they couldn't find anything. They said it was a private security trust. The HELOC was larger than the original loan. It was reconveyed, but they are still billing. How do you get them to stop billing? It'll be 2 years in June.
They have a HELOC, okay, and then what do you mean they're still billing?
I don't know. These questions are vague, Shelley. We've got to get clarity on some of these questions.
All right, so many times HELOCs, home equity lines of credit,
right.
There's a 50-50 chance whether or not it has been securitized, and I'll tell you why. One, if the revolving line of credit, the odds are that it has not been securitized. Why? Because it has changed. There was no given set amount. They said, Kelby, you've got a $200,000 line of revolving credit. It's yours to use. Here's your card. All right. So, you know, the first year you use it for $20,000. Next year you use $30,000.
Right.
But there was no set amount. Now, other parties go in and they say, okay, I need a line of home equity line of credit. You know, they say, okay, Kelby, here's $300,000. You say, okay, I'm going to take the whole $300,000, and it's done. All right. Now, when you've taken that set amount, now they can securitize that set amount, should they wish to, and it could go into a trust, a home equity line of, you know, home equity trust. But it just depends on what type of loan it is. Not all of them are securitized. It's a 50-50 shot.
You know, Joe, I do have a question. Why do you think they, when you get a HELOC, I know that when I do HELOCs for people a long time ago, I'd get paid more if I got them to fund out the entire amount of the HELOC up front. So
Simple. The reason
those are the monetized ones.
Yes.
Yeah, those
I
are
can
the monetized
sell it.
ones.
Right, because otherwise I got to keep it on my books. Because
I got you.
contrary to what everybody thinks, a loan is not an asset. A loan is a liability for the bank. You know, it's a liability. But, yeah, if you pay it off, now I can go sell it.
We have another question. How do you FOIA request to find out if they're paying on the interest on their profits? What profits? Shelley,
all a FOIA request is a Freedom of Information Act request. Right. And usually, how do you know if you're paying the interest? Well, of course you're paying interest. Read your note. It says what you're paying. Read the writers. I mean, everything is spelled out black and white.
Next question. If your originator was WAMU and then it went to Chase and it was transferred by FDIC, and I know that Schedule 5 was never transferred, how do you do it? Also, first the declaratory and then the quiet
right.
attorney.
Right. The biggest thing on those WAMU loans is, one, first determining, with WAMU, it's like, again, if you had a WAMU 301 loan, and what a WAMU 301 loan is up in the upper right-hand corner, there's a 10-digit number. It starts out with the numbers 301. And a large majority of those 301 loans, one, they're all over $500,000, and the borrower had a credit score of over 700. Mm-hmm. Those were used to collateralize junk loans. So they were put in many times CDOs, collateralized debt obligations, which were private LLCs. So they did not make it to many trusts. And for a number of years, we even were using, had another party with me, and we were using a Fitch platform to see if we could locate them.
Right.
And we were unable to locate them, and then a good friend of mine passed on. He had gotten a list of these CDOs, but he had passed on, before I could get my hands on it. But you have to understand, the question I ask everyone is, what did J.P. Morgan purchase? If you had a WAMU loan, and let's say it was put into a WAMU trust, all right, that your promise to pay the debt obligation has been sold. WAMU purchased servicing rights. They purchased personal property, not real property, just like Bank of America. They purchased hundreds of thousands of boxes containing millions of pieces of paper that at one time evidenced debt. Okay, but today what they have is they've acquired simple possession, not legal possession with rights acquired pursuant to statutory requirements of law. So they come into court and say, Your Honor, I've got the wet ink original notes. Well, of course you do, rummy. You have the same piece of paper. It never left the servicer. If anyone reads the pooling and servicing agreements, it said, these servicers shall hold on to these. They never let go of them. They never sent them to the trustee. And in many of these WAMU prospectuses, it tells them to the investor, beware, a third party may come forth with a claim that will supersede your claim. But nobody ever reads the prospectuses of the pool and servicing agreements. This is how come many, many times PMC, PHH, all right, all these servicers that have taken over these other banks, this is how they have the documents. Your servicer never gave the documents up, period. Look at Kent versus Countrywide, all right? That was Linda DiMartini, page 14 of her deposition, she states, Countrywide is not in the business of selling notes. Countrywide is in the business of selling beneficial interest. That's why it's stamped page to the order of without recourse with an as of yet unnamed payee. They're not selling the note. They're selling your promise as a transferable Article 8 transferable record. An e-note is created. It's created electronically, stored electronically, sold electronically. And that's good. You can do that. But you can't do that to the tangible. And when you sell the intangible, it's like having a strip shopping center in LA, okay? Kelby's got a strip shopping center in LA, and Kelby's got 10 stores. And Kelby, you come upon hard times and you have bills to pay and you can't pay, and suddenly one night you have an epiphany. You wake up and you're like, wait a minute. I've got 9 leases under those 10 stores. I got money coming in for the next 10 years. So then you wake up and you go down and you call the creditor and say, hey, listen, I'm going to sell you the rights, all right, to these leases. And that's legal. So you still own the building, all right? Same thing with the note. They strip out that promise to pay. I, Joe Escobar, promise to pay for the next 360 months. It's your promise, which is valuable. That's the right to collect future financial obligations. Your blood and sweat. That's what is bought and sold every day. That piece of paper evidences the debt.
So, for a pro se litigant, how do you beat the lender, being that most courts or judges are biased to the pro se litigant? We as his advocates literally are working on a file-to-file basis to make a determination of the best approach in that regard by getting a assistance of counsel for the day and or just plain somebody that can hire an attorney and or have an attorney go in with you and assist you, not necessarily retaining, but there is that level of support for people. Do you, Joe, do you have any services that you recommend specifically that do that?
No, as you said, Kelby, it's a case by case, but many of the parties that I work with today, they'll hire an attorney and pay him X number of dollars to show up in court and say, listen, here's what I want you to argue. And, he's got it before he goes in there, and he's paid whatever, $300, $500 for the day. And you tell him, listen, okay, here's what I want you to argue. I don't want you to go off into a tangent here. You argue this. Because many times the attorneys will say, that's not a good argument. Here's what I would do. Well, wait a minute. That's not what the complaint says. Mm-hmm. Remember that the attorneys are our mouthpiece. So you need to mold them and shape them into what you want them to be. Amen.
I hear you. That's actually a really good way to put it. Next question there. I have a relative who's being solicited to contact the banks and begin a loan modification process to stall the foreclosure. The relative is just getting out of a Chapter 13 after a year because the banks increased his 13 payment from $2,000 a month to $3,900 a month to force him out of the house. I don't really see a question in there, but in any regards to helping somebody stay the sale, we're going to be talking about a program that we have come up with tomorrow late afternoon with Damien coming on the call that will outline what we are now doing to help assist people on the documents and receiving the help and support that they really need. So we do have an answer for you, and we'll be releasing that tomorrow. Next question. In the mini-arc, where do you go for help on how to upload correctly? Just go to your profile and that we created for you to upload the documents and say that you need a little bit more help, and they will advise you with a more detailed description of how to upload. Next question. I have a securitization on that A for V AFV, that they are now coming after me, that they have made a fortune, and on the Bloomberg it says paid in full.
All right, I can explain that. I already know where it's going.
Okay.
All right, so basically it looks like somebody had a securitization, they had an audit done, and somebody said, hey, listen, Kelby, I've noticed your loan is in Group 3. Group 3 has 23 classes. Guess what? You were in 20 of them, and 15 of them are paid off. Oh, my God, can you believe that? Your loan is paid off. But that's an untruth, all right? The truth is that there's multiple groups in these trusts, and within each group, there's multiple classes or tranches. Now, the purpose of these different groups and these different classes was that they were created so that they could go out to multiple types of investors. So based on your risk of loss is what the investor would purchase. If you're conservative, you're going to go for Group 1. All right? You're going to get a lower rate of return, but it's going to be a guaranteed rate. All right?
Mm-hmm.
When you're going to go to, say, Group 2, all right, you're not as conservative. You're a little more moderate. You're willing to take some risk. All right? But those risks mean that, all right, you're going to make a little more money. Now, Group 3, all right, that's for the cowboy, the guy that's 30 years old that's got family money to burn. He wants to make as much as possible, but he's willing to wait, all right, and he's willing to take some chances. Now, he has a chance of making a lot of money. However, what we have to understand is when these payouts are made to the trust, they pay from the top down, top being senior, the bottom being, all right, the junk. All right, so last man on the totem pole gets paid last because the junior loans, all right, and the junk loans collateralize the senior loans. So even though that these trusts are over-collateralized 15 to 20% to start, every single one of them, you know, there is a lot of dropping off. Now, many times, depending on what group you're in, okay, there's tranches that get paid off early. Mm-hmm. And the reason is because not every tranche has a shelf life of 30 years or 40 years. Mm-hmm. So you need to look at the underwriting prospectus and look in the underwriting, and it states, you know, Group 3, Trust X, Y, and Z has a shelf life of 3 years or, you know, 12.5% of interest only. So based on what is said in the underwriting standards will determine if this trust lives or, you know, how long this trust is going to stay in place. So when the trust gets paid off or when the time expires, that trust no longer ceases to exist, or that tranche, that class. All right? Now, your asset, all right, being your intangible payment obligation in any of those classes within that trust, all right, so if you were in 15 classes and 19 were paid off, right, you're still in one class, all right? Your obligation is still there. It's still being paid to the certificate holders.
Got it.
So,
that's a good point.
Yeah, there were a lot of auditors that misrepresented, and they didn't know what was actually going on. I've been down in Bloomberg. I've talked to people on the mortgage platform. I said, listen, is this what happens? They said, yes, Joe, that's what happens. Pays from the boat.
Next question. Samuel, you're confused about the CODA. You already have the CODA. You already have the declaratory package. You're good to go. If you have any more questions on it, just call me tomorrow. We'll deal with it. Dan, when you go in as a plaintiff, your question is, do you deal with jurisdictional issues? The answer is only because you're picking as the plaintiff your jurisdiction. You're filling out your summons and complaint. You're filling out your civil cover sheet, whether it's a state court or federal court. So you're picking the jurisdiction as a plaintiff. But the jurisdictional issue possibly that you could have is if they're going to try to pull it out of state court into federal court and do a 12B6 to try to get it dismissed. That's the one thing that you would have to deal with, that we assist you on as well. Question, since they have their note and the letter of discharge, and filed publicly at their county recorder, how can MERS rescind the discharge?
Again, MERS is just a registry. It's an electronic database. That's all MERS is. They only survive based on the powers that you give them. That's why you have complaints and lawsuits. That's why you have deck actions.
Mm-hmm.
Do not go down quietly into the night.
I think you just nailed the motto for the program. We will not go down quietly into the night. Next question. That HELOC that Shelley was asking about before also has a full reconveyance, and they now have rescinded it, and they not have rescinded it, but they just continue to bill.
Of course, because it was not an action that they initiated. It was one that Shelley did.
No. They initiated a full reconveyance to
I
Shelley.
understand. Based on the actions that Shelley took. Shelley did an administrative process, and they did a reconveyance.
Whatever.
I think that's what she's saying.
Right.
So that is different, all right, than the bank doing it on an action they initiated. Shelley initiated the action by whatever administrative process she did, and based on that process, these are the results. All right? They don't like the results, all right, that they did because Shelley initiated something that somebody finally woke up on.
Mm-hmm.
All right? That's different than if the bank had just done it out of the clear blue sky, initiated this.
But if all the requesting is a payment stream at this point and she refuses to do the payment stream, technically, do they have any right to go after her other than the only right they could is judicially? They couldn't non-judicially take a house that she has ownership of, being the fact that they reconveyed it to her.
Like, again, you're going to have to go to, California Commercial Code 3203, transfer of instrument rights acquired. That is the only statute in the California Commercial Code in which one can acquire rights, period. 3203. That is the only way you acquire a right.
So even though she did a discharge instrument or whatever, and they haven't sent her back her instrument, they've used it, they've monetized it, they sent her the full reconveyance, they have not rescinded the reconveyance, you're basically stating that is why they will continue to bill.
Yeah.
And if she doesn't make the payment, probably come after her in a foreclosure.
They will.
And then they have to. And then you're saying she's going to have to argue the payment anyway, whether she's
exactly
did that payoff. Okay. Next question. I have a trustee for a trust with an old mortgage that was refinanced and discharged. But they filed a quiet title action against me. How do I defend against this attack?
Who filed the quiet title?
Vital.
The bank?
The bank, I'm guessing, is the one that filed the quiet title against him. Okay,
and did he dispute it?
I have a trustee for a trust with an old mortgage that was refinanced and discharged.
That was refinanced.
That was refinanced and discharged. But they filed a quiet title action against me. Vital, if you can just clean that up a little bit. The action is being brought by an old mortgage that has been refinanced.
So if he got discharged, did he
So an old mortgage is coming after him based on the refinance. I mean, weren't they paid through the
what I'm saying is if he refied, that means he re-signed some papers,
right?
Okay, to reestablish the debt. If the debt was discharged, okay, through a 7, 13, or an 11, and you reaffirm that debt, okay, then you reaffirm the debt.
I have a trustee for a trust with an old mortgage that was refinanced and discharged. They refinanced it and then discharged it, but they filed a quiet title against it. It is.
I'm confused.
Vital, if you can clean up that question just a little bit for us, we'll get it answered. Next question. Do you have to have Joseph under contract before we file our declaratory relief, or in order to secure him as an expert witness? That is no, but you would want to give him some time, obviously, to do that. Next question, Shelley, the paid off in full was done the exact date that they gave the reconveyance. Paid off date in full, going back to Shelley's question, the HELOC also has a full reconveyance, and they have not rescinded it. They are just continuing to bill. Also, California real estate laws say after the trustee mistakenly reconveys the property, the California law says that the trustee is responsible to the bank, not the borrower. 25-10. Also, that's interesting to me, Shelley. That's cool. Also, what 3-501 rule about 4-day of receipt? Also, what about 3-603B, refusal is discharged? Any comment on that?
There was a lot of...
I have so much discharge law under that. I don't. We're asking off-topic questions.
Yeah, just make it simple. The reason they're coming after you, Shelley, okay, is because of an administrative process that you did. Regardless of the fact whether or not that you got a reconveyance, okay, is irrelevant in their eyes. All right, you hoodwinked them. They don't like being hoodwinked, so now they're coming after you. So you're going to have to fight.
So, and we got a couple similar guests on the webinar tonight. This is the second one. So, SunTrust can come after the payment even though she has a discharge paperwork that she's filed into the public and a copy, quote unquote, of the original note. This is why to me this one's the most interesting. She discharged the debt for 2 years, right, and she's holding the quote unquote the original note.
Right. So she is going to have to, again, judicially solve this.
So in other words, if she's walking into court, I'm the holder of the note. What do they got is my point.
Right. There's a few things that I'll talk to you. It'll take some time, Kelby, but I believe I've got some things that'll really help her on that. But, you know, we're looking right now, it's 5 to 5. So it'll take like another 20 minutes, and, you know, we can talk off, you know, like next week or when I'm at the airport tomorrow.
That's not a problem.
But I can give her a little push, give you a push in the direction where I would push her.
Yeah, absolutely. Let's do 2 more questions, and then I know you got to get off. The old mortgage was refinanced years ago, and they are coming saying that the one who discharged didn't have a right to discharge. I have another mortgage now, and they are not going after the new mortgage company or the attorneys or the old holder that discharged. They are coming after me and had Old Republic title, which they just released as a defendant, and now only coming after me. So, Vital, is this somebody... Were you the owner of the house when this original mortgage was, quote unquote, saying they didn't discharge the debt? Or I don't understand. Vital, I'm going to call you on it. Yes, my other house. Okay, Vital, I'm going to call you on this because I don't understand necessarily the question. But I'll call you on this tonight. Last question. I also did an administrative process asking for proof of claim, and they defaulted the lender. They never answered anything. I wish I could talk. Shelley, you're okay. Shelley, administrative processes are the foundation, basically, of everything you need when you go into court. If you've done your process properly, and you go into court, you have your paperwork, your everything is in order. The judge generally looks at you in a different class necessarily than somebody who hasn't done anything or jack. But a lot of times people, what they think of as an administrative process is not an administrative process, meaning you've defaulted all administrative options, and now you've sued. So we're going to be talking about that administrative aspect a lot in the coming weeks as to what you need to do to properly try to get the information that you need out of the lender prior to going into quote-unquote mini-ARC package with HISadvocates. But, all the people on the call today, and Joe, you can cut out at any time. We're done. I really appreciate you coming on the call. I know we didn't get a whole lot of time to talk, but we are going to be doing a Q&A tomorrow again with Damien, and Damien is very well qualified as well. Joe, do you have any closing comments or statements you want to tell people?
No, other than, continue to educate yourselves again and again and again. Shelley's got some interesting things that I think we can have fun with. So I'm looking forward, to helping you out on that, Kelby. So other than that, I've got to get ready. I've got to pack. So I've got 8 planes to catch in the next 5 days.
Excellent. You be blessed, and I appreciate you. We'll chat next week. Have a good weekend.
Thank you, sir.
Yeah, not a problem. So, Shelley, don't worry about how well you're typing or not typing in this particular regard. We work in your process with you to make sure that you understand how to properly approach within the mini-ARC program and how to make it work for you. Guys, and there's a lot of questions, and unfortunately all of you guys are in different positions, especially when it comes to administrative discharge instruments or what have you. I'm finding it very interesting that many of you have full reconveyances and full, but this is indicative. Think about this. What if in 15 years a lender comes out of nowhere and you've purchased a new property and you've got title insurance and they sue you, just like they're doing with Vital, just like they're doing with Shelley, just like they're doing with Margaret, just like, all these people out of nowhere who they're coming after when the matter has been settled. This is kind of why you need to understand about how to deal with the lawsuit structure from a declaratory relief process standpoint. That is the most important thing, and I keep on saying this, but after today and tomorrow, you're going to really get it, how important it is to have this knowledge and to understand what you're going to need to do. But that's going to conclude today. We're going to be hitting it tomorrow from 9:30 again to about 5. We will turn the screens on at 9:30. At 10 o'clock, we will actually go live. I'm really sorry about my voice today. My voice has just been up and down all week long. I've been really tired and trying to get this all put together. But we appreciate you guys. We bless you guys. You guys are the core of everything. We're going to send out another email again tonight with the information. Tomorrow will be a different code to get logged in. Just doing it because we've had, even today, more participants than we expected. And so please, if you can, don't have your family and friends come on. It isn't cumbersome, and we also have a maximum of so many members that can get onto this webinar. So blessings to you. Good night. We'll see you tomorrow morning at 9:30. Bye-bye. All right, guys. Welcome back to day 2 of HISadvocates Advanced Chain of Title training seminar. Today is going to be a very cool day. There's a lot of information we're going to be presenting to you today, so just bear with me. We do normally what I've been doing in the last several years, I open up the seminar on Sunday mornings with basically because it's my day for church, and so it was something that I promised the Lord I would do, and where I would talk about the light and dark nature of what's going on in this world. Today I'm not going to be doing that. Today is a full day of information, and we're going to be going through a lot of details, a lot of formal kind of stuff. Don't worry about it if you don't get it. There's information at the end of the seminar that'll be delightful to hear pertaining to stuff that Damien and we have been working on. And just in this last several weeks, there's been a lot of great news coming out from what we're presenting to you today. And by the way, I will say this, and I'm going to say this firmly. I don't know of anybody in the country that is taking this approach and having any degree of success at all. There's some people that are doing bankruptcy training, having success there. Few people doing it on the private side, never really getting a judicial determination, but sitting in their house for a long time. This is getting judicial determination and putting permanent clouds on title. I don't really know anybody there in the country doing this. So we're really proud to be the first to really push this out there and get the people familiar with it and trained up on it. So just as normal, we have a disclosure statement in a nutshell. We are not issuing or giving legal advice. Again, this is not a legal, we're not a legal entity. We're a private entity, and I'm a private presenter in this context of what we're doing. So just understand that first and foremost. What I'm going to do before I open up this seminar is I'm going to open it up in prayer. I didn't put a prayer slide here, so I apologize. So bow your heads with me if you would. Lord God, so many people are coming on to the line here today, and Lord, have reservations. Maybe they're excited. Maybe the information is sinking in. And Lord, this is a lot of heavy, good, solid information based on years of experience of many minds coming forward and culminating together to put forward this seminar. Lord, we just ask that you protect the computers, you protect the technology, protect the internet, the lines that are being used upon, and grant us the ability to have a complete seminar, something, Lord, that honors you, but at the same time gives us the ability to have a game plan that we need personally for our own houses and for our land. So God, just bless this day and bless my voice. God, keep my voice all the way throughout the day. Give me strength. Bless every person in their mind and their ability to think clearly. Just let them receive. And we pray this in your Son's name. Amen. All right. Analyzing documents to discover probative issues within a court, issues that can be debated. Analyzing the PSA and the prospectus. The entity that creates the trust, a PSA, known as a pool servicing agreement, is a legally binding and setting the rules that the trust must follow. It is also governed by prospectus 24B5 pursuant to the Securities Act of 1933. Okay? This basically is a prospectus. It contains the name of the parties. It includes the depositor, the sponsor, the seller, the pass-through certificates, and this is what they're selling off of that trust. Okay? The pool servicing agreement, the PSA, is the contract that governs the relationship between various parties in the securitization process and controls what can and cannot be done within the trust, meaning the mortgage-backed securities, that block that you've always heard of. That's the trust. PSA will state, among other things, the exact steps needed to create a trust, how bundled mortgage loans are transferred into the trust, how securities are issued, and the duties, rights, and obligations of each party. For example, the PSA will describe the servicer's compensation. Often, the servicer is entitled to retain the late charges, NSF fees, reconveyance fees. This is what we're talking about all throughout the seminar. Assumption fees or other fees that it collects. The PSA will also carefully describe the loan servicer's responsibilities pertaining to collecting payments, handling loss mitigation or foreclosure issues, including the authority to modify loans and foreclosure. Now that's the key, because people don't understand that within the PSA, they could be violating the PSA under contract, depending on what their terms are for modification. So the prospectus contains key information. We've highlighted a few areas for you here. The mortgage pool, general assignments of the mortgage loans, reports to certificate holders, events of default and the remedies, what they're willing to do on a person that defaults and what they're willing to do to resolve, like we were just talking in the previous slide. Servicer, the depositor and the sellers, the trustee, and the voting rights. So the info highlighted above us is, for example, to tell us that this particular trust is governed through this PSA under the laws of New York. Okay, and I don't want to necessarily read all that to you, but it outlines jurisdiction within the PSA. This trust particular started February 1 and closed February 28, 2007. Now I want you to go back a few slides in your mind and remember what we talked about, how this tranche, this pool, is like a pool of cement that hardened in 2nd of February or 28th of February 2007. So to try to take something out of this pool is not possible. And they can't change it 8 years later by affidavit or whatever they're trying to get accomplished. One would have to analyze the key sections of the prospectus into a bullet point form, then provide a set of instructions on how to print out this form from the prospectus. Hold on. Now, at sec.gov, one can order their prospectus, and you can order a copy of the trust, the PSA. You can depose SEC attorneys to certify and explain what the prospectus means. They are going to claim that you are not the party to the PSA. That is true. But they do claim to be the party to it, and therefore you have every right to prove their standing with respect to it to be able to claim to be Pete, the person entitled to enforce. So we line up and we look at the sample index against the prospectus and then create our own index, knowing what to look at for in our new prospectus of interest. We become familiar with the structure of the PSA and 424B5 prospectus. Just training yourself up on this stuff. You got to ask yourself, how deep do you want to go? How far do you want to argue this? How important is this to you from an information standpoint to get in front of counsel or in front of the judge? Give me just a second. I got to close an item real quick. Having a glitch here. Give me just a second. Okay. Now, this brochure came out last year. Many of you probably remember this. It's the role, it says, and this is from U.S. Bank, it's the role of the corporate trustee from U.S. Bank, September 2013. It cites the borrower as one of the parties in a mortgage-backed security. All right? So a big attorney, he's got a lot of offices across this country. He submitted this in one of his cases in the name of Jeff Barnes. And it was pretty interesting because he points out right there, where up there on the left, distinct party roles, he points out that it includes the borrower. An admission, from the bank. Admissible evidence. So to verify this brochure is accurate, and represents what the bank actually says. One does a 30B6 motion for deposition of a corporate officer. 30B6 motion for a deposition of a corporate officer. The opposition will try to say that the borrower is not a part of the MBS transaction, the mortgage-backed securities transaction, the trust, the PSA, that governing thing or document or tranche. What is, you have a mortgage-backed security gets split up into, like a pie, and it becomes these tranches. And these documents are what governs that whole thing. And they're saying that you're not a party to it. Well, this document says you are. Okay, and this is from the banks. So key probative issues in securitization. The fact that an assignment came years after the closing date of the pool, of the trust pool. Remember, talking about that cement pool, it gets sealed up in 2007. You can't break it out unless you got a sledgehammer, and that ain't going to work. It's not. You got to keep the pool because the pool is governed by a contract, and the pool can't be split apart. The startup date of the trust, according to IRS Publication 938. Go look. Publication 938 tells you when it started up, and it's going to close within probably 45 to 90 days. The lack of evidence that would bear out three true sales from A, the originating lender to the sponsor, seller of the trust, B, the sponsor, seller of the trust to the depositor of the trust, and C, the depositor of the trust to the trustee for the trust. There's significant language within the PSA Section 2.01 or the assignment to the trust to validate that these transactions had to take place, meaning they have it within their own PSA agreement that would have had to have taken place, meaning not an assignment 7 years after the fact. So we revisit the bank's arguments that the borrower is not a party to the assignment, thus their lack of capacity to challenge the standing or issues within the PSA, noncompliance, or moot. U.S. Bank published a 4-page handout, and it clearly mandates that the borrower is a party to the trust transaction. This appears to be true for the following reasons. A, the borrower had to become the maker of the promissory note for the note to be validly endorsable to any future party. Remember, we're talking about, again, the tangible obligation known as the note, just a little reiteration training, that has the chain of custody between the parties, the banks that it sells to, on the note, and then when you run out of room on that note, you put in a longe. It's got to be hot glued. We're going to talk about that today. And if it doesn't have that, then you've got a broken chain. That's the most important thing. So there is sufficient belief that the loan application form 1003 was used to secure the MERS min, and thus at that point in time an account was created based on the borrower's signature on the form 1003. 1003 is a residential loan service agreement. In my business, I probably filled 25,000 of them out. And not the borrower signed the note, becoming a maker of the note at the closing table. The U.S. Bank brochure declares that the borrower is a party to the transaction because without the borrower's agreement to obtain a loan, by virtue of the application and signature, all transfers to the trust would be ineffective. Okay? Thus, the borrower's signature were absent from the note. Then who is the maker of the note? And due to the fact that MERS is involved in the securitization process, there are agency disputes as to MERS' right to convey anything into the trust. Subsequent cases have ruled similarly to such court cases, Bank of New York versus Silverberg, Supreme Court Appellate Division, Second Department, and Bellestri versus Auckland Loan Servicing. Now, this is from a gentleman by the name of Leventhal J. He says, this matter involves the enforcement of the rules that govern real property, meaning talking about the case Bank of New York versus Silverberg. This matter involves the enforcement of the rules that govern real property and whether such rules should be bent to accommodate a system that has taken on a life of its own. The issue presented on this appeal is whether a party has standing to commence a foreclosure action when that party's assigner, in this case MERS, Mortgage Electronic Registration Systems, Inc., was listed as the underlying mortgage instruments as a nominee and mortgagee for the purpose of recording, but was never the actual holder or assignee of the underlying notes. We answer this question in the negative. Period. Now, Bellestry versus Ocwen, MERS never held the promissory note. Thus, its assignment of the deed of trust to Ocwen separate from the note had no force. As Ocwen holds neither of the promissory note nor the deed of trust, Ocwen lacked the legal cognizant. Oh God, I hate that word. Ocwen held a legal cognizable interest. I can't say that word. Sorry. In the property, and therefore it has no standing to seek relief. These are two big cases that we need to be studying, and we're going to be going through a lot of cases today as we are finishing up and dealing with Dakota and dealing with these an understanding of how to deal with your declaratory relief in court. This is a good day. So these conditions precedent for the close of escrow, there has to be instructions to the escrow officer. Now, me doing private capital before, I used to issue what's called lender's instructions to escrow, and they will do exactly what you tell them. And they'll tell you, and they'll even post it to the meaning I would have a servicer collect on the transactions and so forth. So what we would do is we'd issue lender's instructions, and we would say, if one is claiming to be the payee, we would tell them, well, let me back up. When we would issue lender's instructions to the escrow would follow the guideline of the instructions to the T, and they wouldn't stray. And so if we asked them to do a certain thing, like have it go to Foreclosure Consultants, Inc., and it is a foreclosure company, but it's basically a second trust deed company for servicing, they would package the whole file for us, and they would take everything that we had from all the loan applicant, and in every set of loan documents you have the initial application, the 1003, the 1008, all the disclosures, 50, 60, 75 pages, plus the loan documents, another 100 pages. And they would submit the entire package, the original package, to our servicer, because I would first take a complete copy myself and give the copy to the servicer and keep the full originals as the beneficiary, meaning the person that loaned the money. So as a private money, it's different than the monetization aspect, where they're going through, they're taking it and doing all the steps that they do to monetize those transactions. But the reason why I'm telling you this is there are simple conditions both on the private and the public side, and there's people that have private loans that we need to get you answers on that are not going to be addressed in this seminar, because the people that have private loans have a different attack than what we are doing in this particular seminar, because the private loans, you're going after the context of what is going on, meaning was the chain busted? You're not necessarily going after the securitization and the splitting of the note from the deed of trust. You're going after the aspects of what's wrong with the chain of title, is my point. So if one is claiming to be the payee is not the one listed in the escrow instructions, then the escrow could not close because conditions precedent are not met. Is the wrong payee named on the instrument? Is the instrument defective? One or both of these is the case if the payee on the instrument and the payee on the escrow instructions do not match. They require perfection at the point of escrow, and which is one of the things that I used to like. Because if there was anything wrong in my book on the documents, I wanted to get it clear, and they were always dotting my I's and crossing my T's. But I didn't know certain functions and things like, that the grant deed, when granting or conveying a property, must be accepted in law by the grantee, which is an interesting fact, and we're not going to get into that right now, but that's one of the things that was a big surprise to me. And at the time of doing hard money, I did not know why they separated the deed of trust and did not record the notes into the public as well. Now I do. If escrow did not close because it was funded by the wrong source, do you owe a payment back to that alleged party? Do you owe it back to the one who struck the deal with, or anyone? Okay? What is really happening is that they said they gave you a loan. That's not the facts. That's not truth. It's not even reasonably truth. But they really took someone else's money or digits and gave it to you. That's not necessarily the case in every case. In every lending scenario, a tad bit different. But for the most part, it's called table funding, where you fund the transaction and escrow's holding it for the delivery of the funds from the beneficiary, the true beneficiary that you do assignments for after the fact. And that's how we would fund our private transactions. We would fund it, market it, and sell it within 24 hours. So now that they're collecting payments on someone else's money, but they also took out insurance policies. So the supplement probative issue of escrow conditions precedent, follow the money instead of the paper. The origination was their defective mortgages. If the lender used defective instruments to close on the loan, nice, escrow never closed. Conditions precedent were not met. So, did the master servicer pay any of the payments for the borrower into the trust? Did the REMIC get cashed in on and a credit default swap paid out by bailout? And if so, what precedent of the trust tranches were made whole? Goes back to what Joe was saying yesterday, where you see on the Bloomberg it's paid, but they're still asking for money. It's because maybe not all the tranches were paid, but 17 out of 20 of them. Similarly, what if there is is default insurance? See, the mortgage default insurance policy is written into every deed of trust. The lenders are paid when the loan was made by the insurance when they sell the loan on the market. The Fannie Mae mortgage insurance claim form shows up to 4 policies on every entity up the chain of securitization. These policies are paid off. So what trust can ever claim that you're in default? Now, if you knew how to grab all that and you can take that and run with that, that's huge. All right. PSA, summary of probative PSA noncompliance issues. The assignment from the mortgage deed of trust only with MERS involved appears to be a moot conveyance because the note did not transfer with the assignment. The assignment from the mortgage deed of trust occurs years after the closing date of the trust, thus issues involving the PSA statements must be noted. All parties involved in the assignment must be researched as to their agency relationships with the borrower and the broken chain of title due to the unrecorded methny assignees being presented due to MERS involvement. Any allegations of the lack of standing or capacity must be noted. All right, so if securitization and MERS are involved, the issues of probative value, and when I say probative value, let's just say, anytime I say that, I want you to think, what brings your case value, your lawsuit? The issues of what brings your case value would inherently apply to the discussion of agency law relationships between MERS and all of the parties involved in the trust. The fact that MERS, unrelated MERS signers, robo-signers, are more likely involved, the document manufacturing aspects must also be brought out in the discussion of the document itself and referenced in summary, in your summary that you put on your case. Now, if we're doing your case for you, we're going to do that. So, DBNTC versus Holden, 2011, motion to dismiss. Great arguments for PSA non-compliance issues. Again, DBNTC versus Holden. Be reminded, a full copy of this information is going to be given to you, including notes, so you're going to be able to read the whole thing and not have to worry about the cases we're citing here. Comprehensive document analysis issues. All right. So, piercing the veils of secrecy. Corporate departments are compartmentalized from one another so that no one party can be held accountable by mutual knowledge of the collaborative facts. Isn't that interesting? One must be prepared to fight requests for protective orders by demonstrating the criticality of the information sought to the case. Depositions can be used to force evidence of powers of attorney which are non-existent. In all document analysis, we look for season issues of probative value, manufacture, reconveyance, and so forth. So here we have an example of an assignment. You got the notary, Kathy Wickware. You look right there on the bottom, towards the right. She did not sign her full name according to the stamp as required by law. Look at the stamp right below it. You see Kathy Jackal, or whatever her name is, Wickwire. That's how she's to sign her full name. The commission expire date not filled in per MERS. In the MERS agent, Teresa Skinner identified as he. We've got that squared out for you. And this is minor. We're just showing major stuff. We're not showing, this is easy. This is off the top. You got a quick glance. You got rubber stamps. You know, you got all these missing things. This document is a robo-signed document, right? So researching the parties is you get doc preparation law firm stamped at top, atop the assignment not visible in the example, MERS agent Teresa Skinner. You got the notary Kathy Wickwire, so you got the document, you're making your analysis over on the left side. This is what CODA preparers do. So the law firm preparing this assignment located in Delaware is not visible on a sample previous slide. Skinner is also a VP for Bank of America. So there's two VPs. These document manufacturing mills get authorization from banks to be a vice president and do certain things on their forms on their behalf. We're going to show you a list that you can go grab at and look at of every known notary robo-signer in the country. I think HISAdvocates already has it. Wickwire, located in Texas, would appear to be a B of A employee by association. Greenpoint Mortgage went defunct in 2007. The trust closed in 2004, 6 years before the assignment in 2010. The first trust distribution date is also 6 years before the assignment. Form 15D in 2005 indicates that less than 300 investors left in the trust. PSA indicates that depositors are charged with assigning mortgages in the trust, or that the depositor is charged with assigning mortgages into the trust. The key issues are not discovered by the succession of the documents, but how the docs fail to relate to one another, such as here between the assignment and PSA. So researching the entities is important. Greenpoint, they're out of business. Bear's out of business. That trust closed on a certain date. And so therefore, How do we have an assignment 7 years later? So compiling the issues, and we're telling you kind of what the background of a CODA preparer, chain of title assessment preparer is doing. The notary is to be investigated for being compliant regarding that signature. As a matter of fact, on many documents that you see, assignments that you see, you'll see a notary who's licensed in California but signed in Florida. That's just one of the 100 questions that you got to do. And I went to Krager's advanced training for CODA preparers, and I was amazed at how many checkpoints were for one document on assignments, for one document on a deed of trust. Hundreds of things. You would read the line, and then you'd look over to the document and see if that line was on that document. Then you'd circle it in red, and then boom, you'd have to create a one-page summary on all the fraud that document contained. I mean, it's amazing, and it's very work-intense. And the average CODA is about a week to a week and a half to prepare. So people think that, when you're charging anywhere from $1,500 to $2,500, which a lot of people out there doing, attorneys are charging up to $3,000, $3,500 for a chain of title assessment. Depending on who's doing it, it's well worth it because the time involved is very cumbersome. So, secondly, the notary failed to handwrite the date of signing and the date of commission. The assignment uses the wrong gender. The use of rubber stamps indicates the document manufacturing because they're trying to do it quick. How Skinner can be simultaneous a VP. By the way, the rubber stamps don't guarantee document manufacturing. It just indicates it. How can Skinner be simultaneously VP of MERS, B of A, and Wells Fargo and U.S. Bank, and which is what a lot of these people are. They're VP of multiple banks. So CODA will go into their database first, see if they've ever seen that name before. Oh yeah, we got her on 14 other banks too. How can Skinner, a B of A employee, assign as nominal MERS agent for Greenpoint Mortgage in 2010 after Greenpoint went defunct in 2007? Okay, and so on. So guys, we have, a lot of work that we put in these, and compiling the issues is huge, and it just goes on and on and on. So an assignment of mortgage loans pursuant to PSA is nailed, meaning the depositor is supposed to assign to the trust, but instead it is MERS that does so. So this is a PSA compliance issue. This forms the second issue after the fact that the mortgage is assigned years after the trust is closed. Third, endorsements on the note are supposed to match up, and they're supposed to be 3 true sales. They should show 3 endorsements on the note, but they argue that they can assign in blank. But this should be appealed. They cannot. It cannot have effective transfer by doing it. They are trying to apply the rules of UCC 9 non-negotiable instruments to UCC 3 the negotiable instruments. Notes were shredded when converting to the MERS system, but with all the issues that come up, they have to go back and recreate the note. So for these, you have to do a forensic analysis, such as, there's any meaning of the signature. We have a gentleman by the name of James W. Kelly. Again, you're going to get a copy of this, so don't worry about writing it down. Of the paper on which the alleged note is produced. If the paper is newer, it will show up. It will show that is not the original. And if it is pixelated when blown up, it'll show the same. Now remember something. I want you to take a tiny little signature, 2 inches by 4 inches. You're looking at it under a microscope. Now I want you to spread that open and widen it open and blow it up on a thing. And you can do this yourself. You go take your own signature, go to a photocopier, put it on the photocopy, and then take both of those and just your original signature. You can't change that one, but look under a microscope or a magnifying glass on both of them. You're going to see a distinct difference of what a printed blue signature looks like versus the latter. So how can this non-performing loan be assigned in default into the performing trust 6 years later? This is a violation of the PSA terms. So, and it's by a party other than the depositor as required by the PSA. So the whole PSA has been violated. The lateness of the assignment implies the loan is in default, implying further that the master servicer has made at least one late payment to the wholeness of the trust. So, you know, the question is what do you do with this data? What do you do with this knowledge? And we're going to get into that. And you're going to really like how this thing kind of rolls in because we're going to show you lawsuit samples that have used this stuff. The lateness of the assignment after first disbursements and the few remaining investors implies that the trust has been substantially, if not entirely, paid out. So if a trust or all tranches, and we're talking about the main trust, not the tranches. The tranches are broken out from the main trust. If you're talking about that trust being entirely paid out, what does that mean for you? If a note's been paid out, it's been paid, right? Think about that. So absent evidence of endorsement of the note, the singular assigning of the mortgage alone would indicate bifurcation, I got that word today, yes, of the mortgage from the note, nullifying the mortgage. See Carpenter versus Longan again. We talked about that yesterday. Absent evidence of the note, endorsements, and record of corresponding assignments by the required parties, it is implicated that the entry of the loan into the trust by the requisite number of 3 true sales was not perfected. Okay. Electronic signatures and notarial fraud. This is easy. So look at that. Are those real? No. Not at all. You can tell electronic signatures by its neatness and position relatively to the signature line. They're always above the signature line. They use an auto pen to make the signatures. They do this in states that don't require notaries to keep a logbook of whose documents they have notarized. Did you hear that? Just because documents are in the property record does not mean something legitimate took place. Remember the lawsuits we've been talking about where the county recorders are saying their attorneys, government employee attorneys, are saying 90% of everything recorded in their county is fraud. Wow. That's pretty amazing. So the phone number on and the address in Utah notary is an EDOC recording plant. You have to investigate and drill into the information available to surface the issues to light affecting the documents. Critical. This is the satisfaction of mortgage. Okay, I put a list of known robo-signers here. I'm going to hold this up for a couple of minutes. As a matter of fact, it's a good time to take a 5-minute break. It's been about 40, 45 minutes. Let's take a 5-minute break, and I'll see you at about 10:46. All right, thanks. All right, guys, we're going to get going again. Got my 5 minutes going. Yeah, there's like several hundred pages of known robo-signers on that website, on that link. Okay, this is kind of a crappy picture of the machine. You take a look on the left over there, you'll see the signature on the top of the machine on the left. And over on the right, you see the pen. It's a real pen. It's in a clamp, and then you see the machine doing a copy. They have these machines at every document mill company that's out there. There's it's pretty incredible the fraud that's happening, but this is just one aspect of what they're doing. So you must check the notary statutes within each jurisdiction of which it was notarized, and also the jurisdiction which the notary holds their status or their seal. This example in Utah in particular is forbidden. An electronic signature precludes the possibility of live witnessing by the notary. You understand? Where you have, like for an example, a notary of a guy in California, but the notary signature is from a notary in Florida. Okay, notary violated her commission. Notarial seal is affixed without the notary's knowledge. The electronic, and just stay on two just for a sec. The notary must be present when that seal is affixed on the paper. And if it's done without her knowledge, she's in violation of her notarial contract. And there's notaries going to prison right now, and there's also notaries that are suing back. I got one guy. He's on the seminar, a friend of mine. The notary sued him for $400,000 and some odd and won because he didn't respond, saying he defamed her. That was her response, was a counterclaim to him. And I guarantee it was the lender paying for the attorneys to deal with that. So any electronic affixation of signatures is suspect to statutory violations, okay? So if a signer was not present before the notary when the document was executed, the notary allegedly violated her commission but not requiring the signer to be present before her, by not requiring at the signing table. The notary could not have witnessed by hand that the signature was electronically affixed, period. So the notary acknowledged that the signer acted within her authorized capacity without being present to affix her signature to the document, and her notarial seal was affixed to this document without her knowledge. Separation of locations, which we just talked about, of document preparers and signers is a marker of document manufacturing and is notarial fraud. Notarial fraud is a felony, and you will go to prison. Deposition questions can use, floor plans like to force admissions where various officers sit respective to the notaries who allegedly notarized the documents to show that the documents could not have been witnessed by the notary. So you can pull in people around the office, around her. What is her office like? Would she get up, walk down to blah, blah, blah? Oh, she's in Florida. How did she fly out to California? Any affixation of an electronic signature to a mortgage-related document is suspect for statutory violations. The signer was not present. Thus, how could they attest to the validity of the information contained in the document? The signer was not present at the time the document was prepared because the signer was in Logan, Utah, and the preparer was in Chicago, Illinois. What knowledge did the signer have as to where the actual facts were ascertained? If the preparer obtained the information contained in the document from a third-party computer software platform, the signer would be attesting to unverifiable information because the signature was electronically affixed without her knowledge when it was affixed. 3. The notary failed to delineate the notarial execution as to the basis of identification of the signer to delineate the gender of the signer, which constitute markers of document manufacturing. Guys, I'm going to tell you something. I've said it a few times. Document mills, you need to look at. We put a guy on our website who was a foreclosure document mill attorney a long time ago. He was arrested. They slapped him on his hand, disbarred him. He did no jail time, and he foreclosed on tens of thousands of homes in Florida. And here we had pictures of him on his yachts, in his house with his cute girlfriend, and he got all that money from fraudulent activity helping the banks. But he got a slap on his hand. Number 4, if neither the notary nor signer were present at the time of the signing and each signer was applied with a mechanical description device, meaning that machine we just saw, the only party who might possibly be able to attest to any validity of information in the document is the document preparer who accessed the hard data on the payoff transaction, likely from a third-party software platform. So you want to dig a little bit and find out who that may be and bring them in. The term Vice President Loan Documentation is a common title used in RoboSign manufactured documents to describe $10 an hour employees who sign 350 documents an hour. Why didn't they just do it right the first time? You know, I spent a lot of time making sure I did my loan documents right. And I got to tell you something. I went through it, man, where I had to protect investors, where homeowners didn't make their payments, and we had to do it. We had to go through it. And they would allege this and allege that, and I mean, these guys were dirty. They'd take hundreds of thousands of dollars of real private capital, not phony money, money that was hard-earned, hard work for, and paid to them to help them bail them out of a foreclosure, and they never made another payment again. And we would dot our I's and cross our T's and do double the time. And any time we went to court, we laid out everything. And here's the funny thing. When I would go out, when I'd send a notary out, we would record the entire signing, audio recorded. We would ask them, fully disclose their age, their state of mind, and we would run them through the gamut. So when and this one guy, we went through one collection, big collection. This one guy had it was sad, but he alleged all these things, and we knew that our documents were compliant. We knew our documents met all the standards of the state, and the judge sided with us. And then he went into another court. He withdrew. He went to another court and sued. And then he withdrew. He went into another court and sued again. They were playing the game. But there's a difference when you're doing it with private capital against somebody that actually loaned you money versus somebody who didn't. And that's where we don't help it. HISadvocates, I'm going to tell you up front right now, we don't help people when they're dealing with private capital investors where real money was a party to the instrument. And we will argue and show if fraud was done on the transaction. Absolutely. But if the transaction is clean and private capital is involved, there's nothing that really can be done. So in most cases, the title of the signer is impeachable considering the conditions by which the signature is affixed, contrary to statute. Number 6, also note that many states require 2 signatures to release a mortgage lien. And if confronted with the document in court, the signer would be forced to admit that she, A, did not appear before the notary as required by statute. Felony. Had no actual knowledge of the contents of the document because she didn't prepare it, nor did she have any hand in preparing it. Did you have your seal with you? Where do you keep your seal? Does anybody else have access to your seal? Did you give them access to the seal? C, had no actual personal knowledge of the contents of the document because the information could not have ever been given to her to be made aware of due to the circumstances involving the application of her e-signature. Only her employer knew the signing actually took place, which were not within her immediate purview. I wonder how many are out there like that, where you have notaries where they didn't know. I mean, that's got to be a huge one when they're on the stand. I didn't know. Let's go down to E. Customarily physically signs documents in much the same fashion as those signing applications admitted to by and through the depositions of Brian Bly and Crystal Moore and Durata Doko of Nationwide Title Clearing, who has recently settled a lawsuit brought by the Attorney General of Illinois. F, submitted her signature for the use of mechanical reproduction of her signature with her consent, but without her actual knowledge of when the mechanical reproduction of her signature would be utilized. That's sad. Who knows what the truth is, but that's for you to get your questions down and understand, because if you get to that evidentiary hearing or trial, you're going to be bringing this all up. and or you can have an attorney be bringing it up at that time. And what we're working on is relationships nationwide with assistance of counsel attorneys that would be willing to do that. It's work, guys. That's what I just said is not easy, so don't rely on that, because it's work to train somebody to have this knowledge themselves, first off, and then to know how to go into court and affect the knowledge is a whole other thing. So we're working on the people that don't like going to court themselves, getting them something that would help in this scenario. First clue to a manufactured document is that everything is filled in with rubber stamps. The second clue is the scribbled signatures, which you're going to see on the next slide. Stefan is a limited signing officer, GMAC, a servicer for Deutsche Bank. Deutsche Bank is listed as plaintiff trustee, but there is no indication of a trustee for who. Trustee for who? That's something you got to consider. Right at the top there, it says trustee for who. Thus, there is a fictitious plaintiff and assignee. Date discrepancy, remember, scribbled signature. Date discrepancy between the notarization and the amounts due and owing. Notary is 3 months earlier, August 5th, than the computed amount owing as of date August 1st. Blank notary lines. Okay? There's a lot more in that document that's fraud too, by the way. Stefan is now VP of MERS as nominee for Homecoming Financial. The doc, again, is rubber stamped. The assignment, this assignment, is dated September 10th, transferring interest from Homecoming to, it's a hard name for me to say, Deutsche Bank. Sorry. I'm teasing. Yet accompanying the affidavit above was signed August 5th. So how could Stefan, as limited signing officer for GMAC for Deutsche Bank, attest to amounts due and owing to Deutsche Bank when Deutsche Bank did not obtain the alleged assignment until September 10th? So you got to think about this kind of stuff, and this is what the Code of Preparers put together for you. It is impossible that they could claim to still have been in possession of the note on August 5th, but that would have to be proved. This is still a suspect issue. These discrepancies are frequent because of the use of third-party software to generate, form, and fill in its facts in one place, and then it will be assessed, stamped, and witnessed from another location. Taylor versus HBSC, third-party document manufacturing platform, cited in back of Code of Preparer manual, and I'll put a copy of this. You're going to have this. This system is impeachable. Attorney in BK appeal was sanctioned because the law firm was not in control of the case, trusting in third-party platform info that was inaccurate and presenting it to the court. Judges don't like incompetent counsel. Judges may or may not be in knowledge of the fraud. May or may not be. Most judges don't understand any of what we're saying today. Most judges think if a payment is not being made, that obviously the person walking in that room as presenting himself to be the bank, and since there's no other bank in there at the same time, would have to be the party that the debt is owed to, and doesn't understand assignments and doesn't understand all these things. So we've got to really help the judge make that guy, the opposing counsel, look like an idiot. Because when you make them look like an idiot, you are giving the judge something to hang his hat on. And if they're hanging their hat, they're a happy camper, because then they can walk out of this thing and give you declaratory relief against one assignment. I didn't say 10 or 5 or 2. I said 1, or 1 deed of trust. You get that done, you've got a permanent cloud on title. Where are they going to go? Nowhere. Are they going to take your house? No, because they can't. So did the signer have actual personal knowledge of the contents they were attesting to? Did the signer have actual authority to attest to the contents within the affidavit? Was the affidavit properly executed? Are there obvious conflicts between the information contained in the affidavit versus those shown in other recorded documents. Is the affidavit lacking or defective in any way as to alleged impropriety or fraud on the court? The major issue in the affidavit and the assignment with Deutsche Bank, I want to say the other words so bad, but I'm trying to be good. I went to a seminar, somebody called Deutsche Bank, douche bank, and I couldn't stop laughing for 10 minutes. I'm sorry. But they really are that word. But I don't like that word. And every time I see the word Deutsch, I want to call him douche. Forgive me. That's just me being human. The major issue in the affidavit and the assignment with Deutsche Bank is listed as plaintiff trustee, but there is no indication of a trustee for who on that assignment we were looking at. Thus, there is a fictitious plaintiff and assignee. Now, researched further and we did find a single possible trust pool claimant for whom Deutsche Bank could have been the trustee, but that trust pool violated the PSA. So we found this through navigation on secinfo.com, examining the trust acceptance date window that could have aligned with this transaction. We then compared it to a back page of the note the attorney had and found, and that it was the RAL, R-A-L, trust he suspected, but that the depositor was not right. So we're getting information, and we're digging deeper, and we're looking as to how they need to be operating, and they're not operating in accordance to how they should. And we're documenting it, and we're getting it ready and putting it together into the case and going off. This is big, guys. What we're doing is really big, and there's really not a defense to this stuff. They can try to play the games they do in court, but ultimately there's no defense. There is no trust. The plaintiff is fictitious. Remember, we're compiling. Step and signatures are scribbled and different between the documents. We recommend a forensic exam on the signatures. Date discrepancies between affidavit August 5th and the amount due owing to Deutsche Bank October 1st, and between affidavit August 5th and assignment to Deutsche Bank September 10th. Affidavit is made by GMAC and not plaintiff Deutsche Bank. Wait a minute. Affiant's personal knowledge comes from records, books, documents, not first-hand knowledge. Did you just hear me? Which is hearsay. Affiant is not sworn under the penalty of perjury, which every affidavit should say, or is true and correct. The notary paragraph is incomplete. You got to investigate even the affidavits. We have a section on what makes a real affidavit on our website. Question if personally known to me on the paragraph, on the notary paragraph. Rubber stamping, lack of blanks filled in, backdating of the assignment to December 2007. This raises the question anew of what trust, for who. You can question authenticity of the witness, Willie Walton. Who are they? What proof? This is big. About a year and a half ago, notice of sales. And I say, oh my goodness to this. Okay? Read the square, the red. This is going out in California and in a lot of states where, what does it say right there on the notice of sale? You will be bidding on a lien, not on the property itself. Think about the magnitude of that statement, okay? So this started changing, 500 days ago. In an unlawful detainer, check to see what actual interest was bought at the sale. In many cases, the only interest that's sold is the lien and not the actual property. Okay? Now, we are going to be doing a UD training unlawful detainer training in the next few months. I know it's not immediate, and there are people that have a need. But this is going to be a major crux of what we're going to be dealing with in the UD training on how to. Oh, this is only a matter of possession. Oh, okay. Well then, according to the sale, the only possession they got is the lien. Goodbye. Do you need me for anything else? A lien interest does not allow foreclosure, and if the seller of the lien interest was not Pete to begin with, it's even worse. There's no interest at all held by the lien holder. So an act of novation is the replacement without consent of an obligation. Okay, in the same way, you cannot just substitute in someone to pay off your loan. Neither can they substitute in someone other to who your loan should be due. After closing, nothing is supposed to change except by complete informed agreement, but they have changed the loan number. Thus, this new loan number is not secured to your deed of trust. This is why when you see multiple loan numbers from multiple servicers, read that again. Note that on your notice of your trust deed sale that they will never list your loan number. They will list an investor number or a trust deed sale number, but they will never match your loan number. They will only refer to the deed of trust and not the notes secured thereby, but that is not identifying your loan. So the novation, substitute of a new contract, debt, or obligation for an existing one between the same or different parties. The substitution by mutual agreement of one debtor for another or of one creditor for another, whereby the old debt is extinguished. The requisites of a novation are a previous valid obligation and agreement of all parties in a new contract, the extinguishment of the old obligation, and the validity of the new one, Blyther versus Pentagon Federal Credit Union. A novation substitutes the new party. So just for people that don't understand, what I just read is all in Blyther versus Pentagon. A novation substitutes a new party and discharges one of the original parties to a contract by agreement of all three parties. A new contract is created with the same terms as the original one, but only the parties are changed. Restatement of contracts. In civil law, there are three kinds of novation, where the debtor and the creditor remain the same. But the new debt takes the new place of the old one, where the debt remains the same. But the new debtor is substituted where the debt and the debtor remain. But the new creditor is substituted. Confusing. Wheeler versus Wardwell. I know, confusing. You're going to have some time to read this stuff. All right. My son is texting me. They don't care. They don't care. I tell them I'm going to be doing a webinar, and they just text me. Yeah, Dad. Title complication issues. Okay. And I don't have time to text him back, and they get all mad at me. I love my kids, man. So potential issues arising from within the chain of title include the recordation of documents that would constitute potential slander to the chain of title. Not to you, to the chain of title. What is slander to the chain? By the property owner himself or an attempt to, one, substitute himself or someone he knows as a successor trustee. Okay, so what we're saying, look at the top, self-imposed. This is damage you could do to yourself. If you substitute yourself or someone you know with someone you know as successor trustee. Record manufactured liens or UCC-1 finance statements in an effort to place lien on any known claimant who has a recorded interest within the chain of title. Create backdated adverse claimant interests within the chain of title in an effort to thwart the subordinate security instruments already presented in the chain of title, and record false notices of lis pendens and affidavits that purport to carry out non-statutory administrative process. In other words, everything you've ever learned for the last 4 or 5 years could be self-imposed damage if it's not done properly. I'm not saying it's all wrong. Okay, there's a lot of good things that can be done by administrative processes against the chain of title. But you cannot do things frivolous. I want to tell you right now, I have personal friends who filed things against the county recorder, had 35-year jobs with the city, multiple felonies, $1 million bail, $1 million bail, have not been out of jail since the arrest, lost their job, 30 years with the county, never been arrested in their life because they did something wrong, theoretically. But I think the Title 42 lawsuits might have hurt them as well, and they went back after them for anything they could. And under color of law, they went after the documents they filed in the county recorder and gave them higher bail amounts than most murderers. So if you desire yourself to avoid liability for a lien, you do not only remain liable for that note because you signed it, but you also removed yourself from standing pursuant to title. You kill yourself, for the most part, by making such conveyance as to a trust. You have also breached the contract for failing to get lender permission to convey, meaning when you substitute something out to your trust, like Kelby Smith, where you signed it out, you quitclaim everything to Kelby Smith Trust or Kelby Smith SSM or whatever. You've triggered that due on sale clause for the mortgage. Now, look, how many times have we seen attorneys fund a transaction and then put it into their LLC after the fact, and where the due on sale clause does not get imposed? Every day. Every day. Do they attack you on the due on sale clause? No. Does it ever happen? I've never heard of it happening. I've never heard that happening once. Why would they do that to a person who is paying on the intangible obligation? You're doing what you said you were going to do. They just are looking for reasons to secure themselves. Now, I have not heard of that happen, but if you have conveyed it into a trust, you must convey it out back to yourself. Now, that's between you and God personally. If you're making your payments and you have nothing to worry about, I'd leave your home protected. If somebody's going to do a due on sale demand, that leaves you a lot of room for negotiation and quiet title and some other things, because you can attack them from all different directions. We're just saying there are things that you could do to yourself to hurt yourself. And even though the lenders have committed fraud and done everything wrong and did their entire chain of title bad and made a mockery of your house and everything that's associated, you don't need to take that approach. You need to be above reproach is what we're saying, and that's where you get your protection under God. Now, personally, this isn't one of those things that you really need to be, in my opinion, above reproach on. However, what your deed of trust says is it is a violation of contract, and it is something for you to take into consideration as to whether you want to do this yourself or not. Now, the borrower substitution of the trustee is also a breach of contract. Okay? These types of situations create what's called unclean hands. Tax liens are superior liens that must be identified. Now, I'm giving you their point of view, their opinion. We just had somebody make a post to our website this morning, and we don't know what the reason is, so let me just identify that. But he's been dealing with tax issues on recordations against his house for 4 or 5 years, and he had just made notice. We got him we helped him with his application for state citizenship, and I don't know whether he served them with notice. I don't know what he did, but he's making the association in his mind that this is the first time in 4 years they themselves pulled off the tax liens that were recorded against his house. They themselves did. So he's asking us, does it have anything to do with the state citizenship stuff? I don't personally believe it does, unless he served him with some kind of constructive notice, unless he recorded something into the county. I don't think it did, but he did find it interesting. I wanted to share that. And tax liens, in their mind, are superior, and they can foreclose on your property. You know, and unpaid tax liens, people go all the time, and you know, the lender will generally pick up that tax lien and say, nah, I don't think so, pay it. And then instead of offsetting $400,000 that they currently have as the first trustee. And so, point being, borrowers are generally liable for preventing or paying off anything that could become a superior lien ahead of the lender. And hold on, my son has texted me 5 times, you punk. Yes, purchased. Sorry. He's wondering if I purchased his annual pass to Knott's Berry Farm. I owe him. I don't want to get into that with you guys. So, tax records must be researched to identify potential lien claimants. Discovery may be necessary to determine if the liens have been satisfied. All these parties may have been noticed to a quiet title action. I want to say something regarding liens. There's somebody on this call. He's a friend of mine. He's on our prayer calls for HISAdvocates every Saturday. He called me up about 2 months ago, and he was freaked out. His money that comes in was nailed by the Franchise Tax Board in the state of California. And I said, really? And we started talking through it. My first questions were, is there a valid lien in the state? He said, I don't know. And I said, okay. And I said, you do me a favor in a nutshell. I said, write the best letter that you can and give it to me, and I'll pump it up. And I said, and also go to the Secretary of State and pay $5 to get a copy of the fact that there is no liens, because I went online real quick and I paid the $5. Actually, that's what happened. I paid the $5 for him, I think. I'm pretty sure. And I got a copy of his lien report, and it said he had no liens filed. Now, look, only a judge, listen to me very carefully. This is something we learned from previous teachers. Only a judge and or a Secretary of State with a properly filed lien have those two, judgments and liens that are properly filed with the Secretary of State, have a right to go against your bank account or against something that's filed at the county recorder. Meaning an IRS agent or a Franchise Tax Board agent can't just write a lien and go and put it against the county recorder. They have to file due process and procedure like everybody else. So they had all of his funds held at the bank. We wrote a letter, and within 24 hours or even quicker, the bank released all the funds because we just showed them that it was an unlawful lien. It was that simple. So if you got liens that are superior liens, that, you know, don't just accept that, guys. Don't just accept those. We get offers all the time, and they're just taking shortcuts. You know, I had a lien personally hit me at a bank, and I don't ever keep money at the bank, but it was for the Franchise Tax Board, and I think they got $17. And I did the same letter, and this particular bank said, no, we got to honor them. They have no clue what they've done. That simple little thing is going to cost them, because all I got to do is serve them in a small claims court, and I won by default automatically. And so I just need to go do that. I'm going to make $5,000 off this little bank. But I like this bank. It's my favorite bank I've ever had. I'm not going to share it with you guys because they don't charge fees and different things. They're a credit union. But the point being, I'm going to educate them through a lawsuit, a minor one, you know, small claims, because they hit my account without my permission, and I can go after them for much bigger, but you go into small claims, they're not going to argue it. They can't. The law is clear. You either have a lien filed and it's done properly or not. You can't just take the word from a private corporation known as the Franchise Tax Board. All right, so we have 11:21. All right, what we're going to do, we're going to take another break, and I'm going to handle my boy, and I will see in about 5 to 10 minutes, and then we'll go through to 1 o'clock, and we'll have a full lunch. I got 2 more slideshow presentations, and then we got Damien at 4 o'clock Pacific. So we'll see you in about 5 to 10 minutes. Bye-bye. All right, here we go. Again, disclaimer. We are just a bunch of regular guys trying to get some help to the people. We do not provide legal advice. We sure know how, but we don't. The chain of title analysis, the CODA. All right, this is going to be a great part. The advantages of a chain of title assessment, the analysis, call it whatever you want, education package. A CODA must be done before anything else. In doing a CODA, you are doing what needs to be done to prove the title ownership before a judge. The CODA tells the story. That's all it does. It is a witness to facts only and is not a persuader of a case. So this is why the chain of title is so crucial in the event of land disputes. Now, I don't want to go through all this. Basically, MERS has affected 50 million plus chains of title, MERS. And because of how they have functioned and what they do, we're in a bigger than you can ever imagine problem in the next 50 years on getting a determination from a court as to your boundary lines, as to your land. And so this is just a diagram. You can read through it real quick about why. And it could be something as simple as 5 or 10 feet. But the overlaying issue with MERS is that it is clouded title on over 50 plus million properties nationwide. Now, why do you want to get a chain of title report? San Francisco County Recorders they commissioned an independent audit of their land records. 400 randomly selected foreclosure files removed. 99% of all the foreclosures had suspicious documents. They noticed the careful use of words. Why don't they just say fraud? 84% had as many as 4 clear violations of law. Foreclosures are void. Can you imagine if you figured out the steps to move back against that and take a proactive step to challenge the foreclosure and get your home back, or get a remedy against the title company where you can collect that issued clear title on a property that didn't have any? And what would they do? As we've already discovered, they go to the banks who've insured them and get the settlements. What do the banks care? The banks have monetized it 30 times over. You're just a cost of doing business. If people understood how much money is made on your notes worldwide and the fraud that these banks have done worldwide, if people really knew, this country would be in an uproar. These sample statistics you're looking at here show why you want to get a CODA done on your land. The numerous independent audits of county recorders across the country are revealing this kind of fraudulent activity on the documents nationwide. This isn't local to San Francisco. There's 5 major banks, and they're funding in San Francisco and recording in San Francisco the same way they're recording in Idaho and Florida and New York. They're not doing it any different. This is an indication of a nationwide issue. And this is why what we're doing, going after the chain and declaratory relief, saying these assignments are fraud. This deed of trust is fraud. The separation of the note and the deed of trust, the single instrument, is no longer valid. There is no Pete present. That is the issue. So the chain of title, our audits, it basically is set up to present an entire court case. When you get your chain of title, if you read it, most people don't. Honestly, you would have no idea how many people pay for this stuff and just will not read it. They just rely on other people. Guys, I'm so proud of you for coming to this seminar because you're taking the time to understand and read and learn, because you have no idea how many people have are in the mini-ARC program that are not attending the seminar, and they're going to rely on somebody else or hire an attorney or throw in a Hail Mary or buy the DVDs later and whatever. I'm not saying every single one is the same issue, but the point is some do, some don't, some will. Who cares? That's their attitude. You know, we have to get our mindset on learning what's going on and how it's going to affect my ability to stay in the biggest asset that you're going to carry for the rest of your life. Because if you can set up a permanent cloud on title on your property, you're done. You can go quiet title, and you're done. So, certified public records, the public recorder specifically identifies the chain of title, clearly defines assignments for the trust, examines all publicly recorded, meaning this is what is in the CODA, the chain of title assessment, chain of title audit, chain of title analysis, all the same, CODA. Examines all publicly recorded documents, investigates standing and perfected title issues, flow chart that shows impossible transactions. This is what we've done within our chain of title. The CODA will have tons of facts. It will overwhelm you to a degree, but it'll have the plan of attack, which is what we do within the declaratory relief package. We use the education from the CODA to develop the declaratory relief package so that we can go into court and get a permanent cloud on title. The certified documents, now listen to me very carefully, this is why the CODA, this works. The hardest thing in the world is to get admissible evidence in court. And so what is admissible evidence versus unadmissible evidence? County certified government, county recorded documents cannot be refused as evidence. The opposition, meaning the government, had it recorded. So they either believe what they recorded or they admit to the mortgage fraud, Your Honor, which is it? You know, because what they have recorded reflects a break in the chain. Or are they guilty of fraud? Which one do you want? Do you want to give me declaratory relief, or do you want me to go after the fraud a little bit more? Do you want me to expose a little? We could do that. The CODA does provide evidence as such, meaning the fraud, but it is a report that has to be applied properly under the proper venues and codes. A chain of title analysis is really a chain of title obligation analysis and a chain of money analysis. That's really what it is. So CODAs are based on recorded documents which are admissible because they're certified. And the recordings were done by the opponent, not you. So they're not hearsay. They're unlike a securitization audit. You know, securitization audits really are so hard to get quieted title with. And, I mean, you can dismiss them as hearsay all day long. There's multiple people out there, especially all the chain of title experts. I've heard them personally say, I can go into court and dismiss a securitization audit based on hearsay all day long. So we then just use their own testimony to show the breaks in the chain. We can also use what they send us in the response to the verification of, you know, the VODs that we put out there, the demand letters, the QWRs, which we're going to go into today, such as notes, the notes they send as evidence because it's their testimony. Remember, how many times have you guys got a copy of a note from a lender and you've asked for as it exists today, right? And then they send you a copy of the original note that has nothing on it. Raise your hand. Okay, I see you. So the gathering of the evidence, you must begin by obtaining all recorded documents on your home. You don't need to go down and get certified copies immediately, all right? But you can go down and get copies. Your opponent will not provide you with their evidence. They will ignore discovery demands, provide misleading documents to the court. Really? They will play hardball? They will try to deceive the court? Really? A bank? Yeah. Yes. Yes. And yes. The biggest thing, they'll try to get you off point and try to bring them into a court of equity and make it about your payments. That's the biggest thing you need to avoid. and move for summary judgment, which we're going to deal with today. Filing motions to stall or to misdirect the court's focus, I see a misspelling there, I'm sorry, make arguments that they don't need to prove their rights because the deed of trust gives them all of the rights they need. Bull. It does not. Take the initiative and gather as much evidence as you can. Remember, the deed of trust and the note are one instrument. Okay? So the parties recording the documents on your home are the ones trying to take your home. Are they, or is it somebody else? Is it Pete? But we use this evidence against them to show in their own documents they do not line up with each other. So getting original documents. When you signed the mortgage loan documents, those documents became originals. But you don't have them anymore, and your opponent won't just hand them over. Section 1521A of the California Evidence Code states, the content of a writing may be proved by otherwise admissible secondary evidence. QWR and VOD letters generally get a response of a copy of a note with an alleged allonge with endorsements which never match assignments. QWR and VOD are considered informal discovery because they are outside of the court. They never respond properly. I can't tell you how many times I've done a VOD or QWR and not got a response based on what I requested. You know, they'll just send a copy of the note and a copy of the deed of trust and say, here's proof that we are who we say we are. What they send back is never adequate. If it is on if it is on an allonge, it has to say it is an allonge. It has to reference the loan and the property address. And then what they do, you can say, well, they will say that that is not an endorsement page, meaning the allonge. It is just a piece of paper with a bunch of stamps. Most of all, these endorsements don't match what is in the public record, meaning that chain, A, B, C, D, E, F, G. This is where the CODA comes in and it points it all out from the education standpoint. You need to convert that to the court or buy the declaratory relief package, which does that for you. This is where the chain of title, don't do that, sorry. This is where the chain of title comes in and points this out. Some CODAs won't have the note available, so we won't know who has endorsed it. But even without those endorsements, the CODA never connects the dots in the public records. They either connect the dots or they don't. But the CODA shows that the public records are either accurate or inaccurate and what is lawful and what is not. So, how do we analyze the ownership of the note? Okay. Mail a qualified written request, QWR, or request of information, and mail a validation of debt request and dispute of debt letter. They have to answer these within 30 days, sometimes 21 days. They never answer these properly but do give us what we need, which is a copy of the evidence of the debt. You want to mail these certified mail with a return receipt every time. You never just do a first-class mail. Yet, these endorsements or the endorsements never match the assignments, and the endorsements where they are where the money is, meaning the federal law requires recording within 30 days of everything that is like an assignment, like a deed of trust, and like all these things. So the evidence is gained here under a process in which before you're going to court, you're sending this information out and saying, come on, give me this information back. They're going to play the game. They're going to, a lot of times, not give you anything back. A lot of times they'll just send a deed of trust in or a note as it existed when you signed it originally with nothing. So you make a request, you keep a copy of the original letters that are sent back, you're going to be going into court showing that they are out of federal law's guidelines at the administrative level to show that they have done it wrong. So the QWR and VOD letters allow us to peek at the wizard who's behind the curtain, provide evidence of their lack of a perfected interest of who can enforce the note. The VOD letters are used basically to make sure that you're going beyond what's on the recorded information at the county recorder. You're looking for proof of the finances. You need their copies of the notes to show you any of the trail of endorsements. When they show you a note with only one stamp on it, does that make any sense compared to the chain of title? Yet the loan has gone all the way from Fannie Mae through MERS, through U.S. Bank, through Wells, through B of A, through ASC, and now a collection company. It proves the endorsements are not there. So official records, go to your county recorder's office, tell the clerk to provide you copies. Now listen, certified is important for at the time of trial or when you're ready to submit your evidence. Of every document recorded after your deed of trust. Give the clerk your deed of trust document number. In California, you have to base this on the name only, and this is sometimes difficult to find everything associated because California doesn't do it by the address, which is strange. So sometimes you won't find the name on a document that's pertaining to you that's recorded against your house, and you got to do some digging. There are companies out there you can pay between $75, $150, and they'll give you everything. Okay? Organize them in chronological order by date. And use the document number on the top from the clerk up on the top right, and it will show you the chronological order you must do it in. This is going to help you build your understanding of what took place in the chain. Was it A, B, C, D, E, or was it A, C, A, F? Did they do it right? And you're looking, when you're reviewing these documents, we're going to get into this a little more, I'm jumping ahead, but when you're reviewing these documents, you want to see, are there handshakes? Are there handshakes between the documents? Does the document work with the next document? Does that document properly take over? Or what's missing? Who is in between there that it should be there? So we went from A to D. Oh, this is a broken chain. D is a declaratory relief gold mine. Okay? So the PSA pooling and servicing agreement is the contract that created the securitized trust entity. If the securitization was public, these documents must be filed with the SEC. Available at sec.gov, EGGR online. Search for company filings under filings and forms. And the chain of title does all this for you, so you don't need to do all this. But if you want to play, go ahead. Discovery tools. The law provides that a party to a lawsuit is entitled to discovery. The ability to use the law to demand certain documents, statements, and things. Send a Freedom of Information Act request, FOIA. I got to tell you, FOIA, guys, is the most powerful thing that we know of. Now, people, I'm going to tell you something about FOIA a lot of people don't realize. FOIA is for documents only. FOIA is not for information. People will send a request for the government regarding Roswell and all information associated, names, information of people that attended and were there, and the government officers that saw these aliens and this, that, and the other. And the reality is none of it matters because the FOIA is for documents only. Okay? So the Securities and Exchange Commission, SEC, to have them search your pooling and servicing agreement. They'll get it and send it to you. So there's your email if you want to send it to the SEC. When you get into discovery, the banks want to settle because they don't want to expose their nakedness. An RFI is the new name, 2014, for a QWR, the Qualified Written Request. RFI stands for Request for Information. It only requires a bank to answer once. Okay? So if you do your RFI properly and you've got it notarized and you've got it certified and they don't respond, they're in violation of federal law. The autonomy of a chain of title assessment investigation. A CODA must be done before anything else. In doing a CODA, you are doing what needs to be done to prove title ownership before a judge. Now, a coda tells a story. That's all it does. It is a witness to the facts of and evidence, and it is not the persuader. You and your documents submitted before the record of the court are the persuader. So determining the issues of probative value, what brings value to your case, any issue that would imply that the covenant of season or any applicable covenants thereto could have potentially voided possession of the property ab initio. I hate that, but from the beginning, that's what it means. So it's void from the beginning. So any issue that would imply an apparent breach of any implied covenant within or without the contract, which could use or be used to prove that a tort was committed. And by the way, just to stop real quick, you all got to get the Tort Claims book, Torts 5th edition, Prosser and Curtin, or Keaton, Keeton. I got the Torts 5th edition. You'd be amazed at the claims that you could file, tort claims violations, because they're almost never done. So the tort was committed and to further prove the liability of a tortfeasor. So any issue that would imply or any provable element of fraud or misrepresentation committed by any party to a contract which manifests itself in the chain of title, this is more pertinent to the securities instruments and all the documents relating to their filing. And any issue, if known, meaning this is all what brings value to your case, that would indicate the presence of any claimant coming forward and declaring itself to be the holder of a lien may potentially not be the person entitled to enforce, Pete, okay? That lien right, thus disrupting the right of quiet enjoyment of the state. Again, codas only determine issues of probative value, what brings value to your case. So part one of the investigation. This is like peeling an onion. There are multiple layers of investigation. My first coda that I did, I worked on it a month. I'm just saying, when you're not familiar with the processes or where to go, there's over 180 plus individual searches online and or by mail that you must request and or find to determine a properly investigated chain of title. There are people out there that offer chain of titles for $750, and I'm going to tell you right now, I went to these classes and I met many of these people, not discounting them at all. Some are very talented and very thorough. You want to find a detailed party, somebody who is anal, that lives in a box, that can afford to work on your coda alone for 30 days, okay? Because most of the coda preparers that are coming out right now have less than 2 codas per person of experience. I want you to think about that. So you want to find somebody that's been doing this for years that can turn a coda out. Normally, new coda preparers are working on these codas for 2, 3, 4 weeks, and they hate it. But they get down, they develop processes, they make it quicker because we're going from the elements of the mortgage to the land records to the statutes, and we're making the comparisons and the conclusion, and there you have your coda. It's not easy. Trust me. This is why I hire people to do this stuff. Experts that know this and know it inside and out. It's because I don't want to have a joke, you know, and you want somebody who's got even a license, which my guys do. They actually have a private investigator's license. They actually can sit up on a stand and give their expert testimony. But let's discuss expert testimony just for a second. What is expert testimony? It's somebody who has been determined by the courts previously as being an expert. Somebody who's been in courts a lot and by their testimony swayed the opposing counsel and or jury into either settlement or finding. Somebody who has experienced, and that's really the only way to identify an expert. There is no title, meaning somebody in this particular line or field cannot walk up and say, "Hi, I'm Jeff, I'm an expert." And you can't. Really, you're an expert. Who said you're an expert? You? Is there a chain of title assessment badge that you have? Is there a chain of title class that has been sanctioned by the government as being a, what is that, the education requirement? I forget, for colleges, whether their classes or schooling counts. Is the answer is this industry? There's hell no. They do not want people to know about this industry. Why? Because this has been done against this country on purpose for the reasons to steal the land across the board on a nationwide basis, because what they're working on right now is a settlement on a major basis nationwide. The 5 big banks are playing with the federal district attorney, Eric Holder, and this is what they're basically saying. Eric, they're saying, Eric, you can't go after us. If you go after us, number one, we already own you. We are the Federal Reserve, by the way. We fund your country, of which you owe us trillions and trillions and trillions of dollars. And so you can't possibly think you're going to be able to go after us when we can pull the trigger on the United States in one fell swoop. And you can't go after our CEOs, because our CEOs, if they couldn't run the country and literally the country were to fail because the bank wasn't operating properly, let's think about the damage to the United States. That's the game that's being played. Think about that. That's where we're at mentally in this country. The banks will not go down. They've made too much money. Now, there's going to be a perceived collapse, in my opinion, that happens this year, but I don't want to get into that conversation with you right now. And that collapse is going to be designed on purpose for a lot of different reasons. So the people that have judgments or clouds on title prior to these major events or after these major events are the ones that are going to be secure to not have to worry about whether they buy milk or make their house payment and whether the sheriff is going to show up on their house or not. The ones that continue to do these administrative remedies and the ones that continue to go out there and try to figure this out on their own without trying to get support or prove a judge or corner them in a courtroom and get declaratory relief, those are the ones that are going to hang themselves. And they're going to have to buy milk, and they're not going to make their payments, and the sheriffs are going to come knocking. That's what we're trying to avoid here. So the elements, we're going to review mortgage elements, the different layers, the chattel paper documents, intangible documents, and we've been kind of going over that for the last 24 hours. The promissory note, the tangible. Remember, this is tangible. What is the intangible? Say it out loud. All right. I know I can't hear you. The intangible is the payment stream. A writing in tangible form, signed unconditional, and identifying the indebtedness or unsecured promise by one party, the maker of the promisor, to another, the drawer, the payee or the promisee or the tangible obligee. All those names are pretty much the same. Remember we showed that screen yesterday, drawer, drawee, obligor, obligee, trustor, trustee, beneficiary, and different things. We showed the cross, and they're all pretty much the same thing. They just are different terms for you and me. That commits the maker, the debtor, the tangible obligor, meaning the note signer, to pay a specific sum upon demand, or a fixed sum, or a determinable date if the paper promissory note is to be a secured indebtedness. The security instrument is also identified within the paper promissory note. The paper promissory note is governed by Uniform Commercial Code Article 3, not Article 9. Or the state, now we like going into Article 9, and they will even try to bring it into Article 9. But we talked about that as to why yesterday. A signature on the paper promissory note is not governed by the E-Sign Act, 15 U.S.C. 7003, which clearly excludes items governed by Uniform Commercial Code UCC Article 3, or the state equivalent. And as such, the indebtedness can only be in a paper tangible form. Went through all this yesterday. A security instrument, remember, is a writing in a tangible form to memorialize the obligor's or debtor's pledging of an asset or property. It's the deed of trust, it's the mortgage, it's the security deed, those three, as an alternative method to secure payment from a tangible obligation if in accordance with all applicable laws of local jurisdiction, governed by local laws of jurisdiction in which the real property resides. Security interest, pledging of the alternative real property rights for payment. An interest constituting a lien or claim created by a security agreement, mortgage, or deed of trust, or by the operation of law, that, if valid and enforceable, provides the alternative means to fulfill value of an intangible financial obligation between the tangible obligee and the tangible obligor. Thus, if such security interest, mortgage or deed of trust, or security deed is no longer valid or enforceable in accordance to local laws or jurisdiction, then the tangible UCC 3 note is no longer secured by the security interest, governed by Article 9. Promissory note. The intangible E-note, intangible payment obligation, an electronic transferable record creating during securitization and signed in accordance with E-Sign Act that commits the maker, the account debtor, or the intangible obligor to pay a specified sum on demand in accordance with the contract, not governed by UCC Article 3, to an intangible obligee. Transferable records are governed by UCC Article 8, and the security interests securing transferable records are governed by UCC Article 9 and governed under Uniform Commercial Code Article 8, Investment Securities. I know we're getting to the real fun stuff. Oh, it's going to get funner. We're going to have a party in about 2 hours. Oh, yeah, we're going to be reading some real party stuff. Security interest intangible to the UCC Article 8 E-note, intangible obligation created during the securitization by an account debtor are routinely swapped for another intangible obligation certificates, and as being a transferable record, such transaction would fall under governance of UCC 8. For this certificate intangible to be secured by an intangible account debtor's personal property, the negotiation of the intangible obligation must be in compliance with UCC 8 as applies to transferable records. I know I'm boring the crud out of you. As to personal property securing the transferable record, UCC 9 would provide governing law. Guys, in high school and what college I did go to, I would sleep during this kind of stuff because this is boring. But let me tell you something. This is a roadmap to understanding. If you just keep listening a few more times, you're going to get it. The land records provide that the facts, unrecorded documents, provide the basis for issues and for creating a timeline. Documents of transactions being claimed that have been recorded into public record, thus giving constructive notice to the world. They have to record their stuff. Okay? They can't just say they did this 4 years later and then get a judge to say, oh, yeah, we're going to accept that into the evidence. Objection. And don't argue with them. Just go in and strike. Public records provide for presumptive validity. Okay? That the record owner is also the beneficiary entitled to the repayment of money secured by the record deed of trust. So question, Judge, I borrowed money from Frank, $100,000, but Guido is coming to collect, and Guido is threatening my life. Your Honor, Guido is not the person I borrowed the money from, and Frank never introduced Guido to me. I can't see any record of, I've asked Guido for the note. Guido doesn't provide the note. why do I owe the money to Guido? I owe the money to Frank. Guido he's a bully. He's a mafio. He's trying to collect on behalf of Frank. Well, then let me see you. Let me talk to Frank. Frank's gone. Frank's out of business. Frank's down the road. Frank's this and that and the other. How does that make sense, Your Honor, for you to say that they're with no tangible obligation whatsoever to Guido, I am indebted to lose my life over this $100,000 that I owe to Frank? I'm more than willing to pay Frank. Where's Frank? Where's Pete? So establishing the grantor-grantee relationship, this is the priority. Researching the previous owner's change. The first thing that we must do in establishing the grantor-grantee relationship via the warranty deed or the grant deed, before one can become a grantor, they must be a grantee by deed, meaning they had to buy the house or buy the property or built the property. Ownership interest must be established before the chain of title examination can begin. Once you are on title as a grantee owner, you become the grantor or trustor or settlor or mortgagor. I know, don't worry. 4 words. Here's when you know they're talking about the seller or. Okay? Trustor, what is trustee? That's the buyer. Mortgagee, grantee, buyer. Or seller, sellor. With respect to any lien holder to whom they are bestowing ownership rights, we must examine the previous owner's chain to see what might have been affected conveyance, meaning what transfer was not good. We begin with the grantor-grantee index. Now, this is in pretty much every county recorder. But we must also check the tax index to verify the address, discover any possible tax lien. County municipality has superior claim to any lien interest involving multiple liens. The effect of incomplete recordings. The purpose of the county land records is to give us constructive notice to the world, public notice. Okay? When docs, that's not the real reason why they created the registrar or the county recorder's office. That's not the real reason. And by the way, you're talking corporate versus de jure. And I'm going to say this just once. We do talk public versus private, and it's important to understand that in this particular scenario, we in California and in every state, there at one time was a de jure. And in California, the de jure was in 1849, and the Constitution proves the lowercase name state of California. Now, in 1879, it became an all-capital letter state of California, which can be correlated to corporate records found at Delaware.gov and found at DunandBradstreet.com, where state of California is known as a corporation and is owned by the United States Corporation. And so when we are recording information in the county land records, which really means the registrar or the register, those words, register, deposit, the registrar, really you're giving your property to. Look at the Black's Law definition. Look at the case laws pertaining to this. You're giving your land to them. This is why as a broker on my test, it's stipulated that you do not have to record something in the county recorder to have a proper transaction or exchange. Why? Because they want, as the private corporation known as the State of California, County of Orange, Orange County Recorder. It's a corporation. That when you're making a deposit of your asset into their database and or book, it becomes their asset, period. You're literally giving your property to the county recorder in return for a benefit, just like you're giving your rights to the DMV for the return of a benefit, just like you're giving your car to the state for the return of a certificate of title. It's all wordplay. 25, 30 years ago, for anybody old enough to be on this call, if you bought a car at the dealer, you received a manufacturer's statement of origin from the dealer. Now what happens, you go to the dealer and you purchase, and they send the MSO to the state, and the state issues a certificate of title. It's not a title. The MSO is the title. So why, listen to me carefully, why, if you're buying something from a bank as a private corporation or a dealer or a car manufacturing company, why is the state corporation getting involved? It's because they want you to register your vehicle, because it is not your vehicle, it is their vehicle. They are holding the MSO. They have issued you a certificate of title on bonded note paper, in which is monetized, because that's how they do everything. Everything in this country belongs to the United States Corporation, of which you have pledged your life and fortune and sacred honor against the surety of the United States Corporation. Proclamation 2040, Trading with the Enemy Act, and HJR 192, the Buck Act, and Social Security Administrative Act of 1935. All in there. What I just said, it's all in there. You will find that you don't own anything in this country. So why are we playing these games? It's because they have structurally set this up at the bank level. You don't think they haven't set up the courts? You don't think they haven't set the entire thing up? It's all a big smoke and mirrors operation. So I'm saying this because everything that we do, we're playing with light and dark issues. And we need to understand that first and foremost. So everything is coming in through prayer. Everything is coming in through the Lord and the perspectives of eyes of the light and dark nature of what's truly happening in this country. And I have a seminar, guys, that is going to be so exciting. It's probably going to have 500 to 1,000 people. I can't tell you what's going on. But it is the most exciting seminar I've ever done in my life. It's going to be a week-long seminar. And, God, I want to tell you, I can't. But this seminar, guys, is going to expose a lot. And we have a lot of big names going to the seminar, and we're going to expose this in the next 2 weeks. So I really want everybody to understand that what's changing in this world right now, especially in this year, we need to recognize that everything is a light and dark issue. And unfortunately, we're dealing with a corporation or a series of 180 different corporations filed on this land that are mirroring themselves to look like they are the government, but aren't, because the true government was vacated in the 1850s. I can prove everything I just said. I can prove everything I just said. I can prove we are under military rule right now and that these courts are martial courts. I can prove that in law by the flag alone, the gold fringe flag. I can show anybody on this call. So as you're having these mindsets, I'm not off topic, but as you're having these mindsets of dealing with judges and attorneys and these different things, you need to keep in perspective as to who you are. Because when you walk in a martial court, and you argue with them, that's an issue. Now, do they think they're in a real court? I don't know. But you're in California in a state court that is not an Article 6 court. There is no due process. There is no nothing. They don't honor any of their own laws or rules. In an Article 3 court, supposedly a federal court, there is no rules. Those are district courts. That's what they call them. There's 12 districts. You ever see the movie, what's that movie out with Mockingjay or whatever it is? 12 districts. They show you what their intent is and everything they plan on doing. In that movie, it showed the military force. It showed literally the MRAP vehicles. It showed them killing people. It showed the 12 districts being cordoned off, gated. It showed the 13th district. It showed everything that they're trying to do in this country. I'm going to show you something. And one day I'm going to lay it all out. And I'm going to leave this alone after this. They literally have all that I just said in law and are getting ready to clamp down on this nation. This nation has not had a budget in 6 years. This nation is on an unlimited check writing policy. This nation is dead, and we are going to re-inhabit and reactivate this republic together. Because you guys will be told the truth, you will understand the fraud, and you will pull your stuff out and remove the deposit. And we're going to teach you guys how. But you have to deal within their rules. well, and play their games, and that's what this is about. Sorry about the tangent. So, number 2, when docs are recorded with missing pages, constructive notice is also missing. Okay? Meaning they didn't tell the world what went on. This reduces a would-be claimant of record on an incomplete document to the status of an unknown claimant who may only be served notice of an action by public notice. Incomplete disclosure makes constructive notice defective. The resulting documents, weapons of mass destruction. All right, we're going to take about another 2 slides, and we're going to take a break until about for 10 minutes, and then we're going to go on to about 1 o'clock and take an hour. So if you're hungry, just hold on. I forget, you guys are at home. You're not sitting in front of me in an audience. You're probably snacking the crap out of things and drinking everything and saying, honey, go get me this. I'm worried about you whether you're eating. Isn't that funny? I'm sorry. So a resulting document is a paper introduced to prove a point of fact or law, but which instead only raises the question of what caused the paper to be created. Paper recorded, guys, to prove a point, but which only begs examination of its authenticity. All right? So even if it's there, it doesn't mean it's true. Remember, let's go back. Every county recorder is going through land audits right now. Okay? So one of the best books, there's 2 books from this author, and I'm going to talk about it at the end of today. One of the best books, Fighting the Foreclosure Machine by Robert Janes. He also has one on MERS that you can download. And powerful. Robert Janes, Janes. Get the books. Get the books. If your loan is affected by MERS, you want his MERS book. I forget the exact name. Robert Janes. So resulting documents are the assignments of deed of trust, notice of default, notice of substitute trustee, notice of sale, trustee deed upon sale, responses to the QWR and the VOD or the RFI, the request for information, and the cash to keys offer. These are your documents for court. The legal significance of a resulting document can be understood without first examining the agreements. Related documents and questions raised by its use to attempt foreclosure on the home of the trustor. For example, a recorded notice of default is proof that it was created and recorded, but it is not proof that default has actually occurred. Resulting documents can never prove the content of what they say on their face. Resulting documents demand answers for who had authority to create and record, what event caused the creation of, where is the original promissory note, when did this event occur, and why was the substitution of trustee made. So we got to get creative in our minds as to who, what, where, when, why on every single document, or that's what we do in creating the chain of title. All right, guys, we're going to take a 10-minute break, and then let's make it a 7-minute break, and then we're going to come on until 1 o'clock and maybe finish the slideshow, maybe not, but we're going to take a full hour at 1 o'clock. So I'll see you in about 7 minutes. Bye. All right, so documents governing securitization. We're going to be looking through United States Code, federal law, Uniform Commercial Code, state laws, and local law of jurisdiction for the purposes of information pertaining to pooling and servicing agreements, 42, 45B prospectuses, free writing prospectuses, trust agreements, circulation supplements, circular supplements, selling guides, custodian manuals, Freddie Mac document custody procedures, custodial agreements of Fannie Mae. Boring. These 2 are all obtained in the course in the chain of title. So we're going to make some comparisons. Comparing all documents and records of both tangible and intangible to the security requirements of the law pertaining to the sale of the entire mortgage loan instrument, your deed and your note, consisting of a tangible promissory note and a tangible security instrument. I know those, look, why don't you say note and deed? I understand, but they have to, because there's many different terms for a deed of trust. There's not just one. So they use that, and that's the lawful term. Securing the indebtedness and the intangible obligation, which is what? The promise to pay, the payment stream. Comparing all tangible and intangible docs and records pertaining to the entire instrument against statutory law. The chain of title assessment does that. Via all guides and governing docs showing what did not happen so as to void a true sale. Once the record of facts and the unrecorded documents establishing timeline are obtained, the next is to relate the two. So the first sale is what should have happened. The first sale from Party A to B belonging with the first assignment, with Party A releasing its security interest in the security instrument and assigning it to the interest to Party B and recording this transaction into public record. The second sale from B to Party C, along with the assignment, remember we're going A, B, C, D, E. This is what should have happened. With an assignment to Party B releasing its security instrument or interest in the security instrument, getting tongue twisted, assigning the interest to Party C and recording this transaction in the public record. Then the third sale from Party C and Party D, get where we're going. Okay, same thing, A, B, C, D. So from sale from A to B to C to D, with each of its previous parties releasing its security interest and assigning the interest and filing it into the public. Why did this not happen? Or why did it not take place in most every case? According to the statutory requirements of law, as well as the governing documents that were required in order for true sales to take place. What's a true sale? It's not the assignment. The assignment is the record. Okay? So what requirements are violated in regards to keeping tax status as a remic? Were the timelines requirements met? Okay. The coda specifically supposed to denote the issues including but not limited to, number one, the discussion of all pertinent points relative to the chain of title in each of the recorded documents. Okay. The interrelation between each document as to recording dates and times in an effort to establish issues of probative value, what's good for your case, concerning the constructive notice, the public recording, each document provided in the chain of title. So, denoting the value of unrecorded documents as they pertain to the timeline within the chain of title. Number four, the presentation of research relating to any party or entity showing to be stipulated anywhere within the chain of title and what relationship this party or entity has to the lien interest granted by the borrower. And number five, the potential consequences that have arisen within the chain of title, including issues involving A, the seizing or disseizing of any party within the chain of title. Okay? Remember what that word meant. The former owner's potential involvement within messney assignees unknown to the parties within the current owner's tenure within the chain of title. C, the recordation of documents within the chain of title known or suspected to be manufactured, fabricated, or falsely acknowledged. D, the recordation of documents that would constitute potential slander of the chain of title. You know, even mistakes of a lot, where block references in the legal description can be made issues for the slander of title against a neighbor. Okay? You can inform the neighbor and use the neighbor's knowledge of the potential slander of his title in court. This raises the issue to something above the level of a mere scribe's error. Someone has now been injured. Their own property's value has been diminished. The other issue of slander of title by a lender is that the borrower can now not sell the property in order to mitigate the lender's alleged damage. Okay, so the lender's saying you owe him some money, but you can't sell the property because there's a cloud on it from MERS. This is why, if it were me, I'm just going to give you a side opinion and personal note. If it were me, I would sell anything that had MERS name on it as fast as I could, or any REO property, I would sell it. Now, people, they're not going to deal with this in the next couple years, but it's going to be dealt with in the next 5 to 10 years. Okay? There will be an issue, and you might be named in a lawsuit. And what I would do, if I really wanted property, I would wait till the market slams, because it's going to go down just like it did in 29 and worse. And property values will be so low that you'll be picking them up like you wouldn't believe, cheap, cheap, cheap. And then what I would pick up is only a new owned home that's never been lived in before, never had a loan on it. That's what I would buy. Okay? So, just giving you my own personal opinion. But we do not go outside the facts and the documents of record to cite issues, including securitization. Securitization info is unreliable, member securitized security audits, securitization audits, because the info in Bloomberg Terminal is put in there by the lenders themselves. Hearsay. Hearsay. We only run a search on securitization if a recorded document references it. So 10 most common issues found in CODA. Number 1, the borrower was never lawfully seized of the estate and thus could not encumber the subject property with liens. The grantee purchased a foreclosed home or foreclosure that the bank didn't own at the time it sold, and the subject property, when the bank sold the property to them. We got a caller this weekend that made a note of this last night in the chat room. The trustee was a self-appointed or acted ultra vires in a manner that appeared to be self-dealing. Okay? The trustee committed statutory violations against the property owner. The property owner quit-claimed his property away from himself, created a potential issue for breach of contract or alienation of warranty. MERS officers committed errors or suspect infractions against the chain of title. The lender or its agent recorded information that was suspect for perjury. Love that. That's big. Pisses off judges, such as foreclosure mill attorney claiming that he is a vice president of loan document for Wells Fargo Bank, N.A., when the attorney knew this information to be false. Check this out. One time, one of my own cases, where I was involved, I'm not going to get to the merits of the case. I will say that the attorneys were lying to the judge. At the time, I had attorneys. We asked for the documentation. We asked specific for the documentation, what we were looking for. There was over 100 boxes given to us. We had to go down to their office. We were put into a small room. We were given 2 hours to go through 100 boxes, and there was just no way to complete that. So we were not allowed to get and go through the documents as requested. And by the way, guys, think about this, what I just said. That can be done with the bank. You can go through all of their crap if you can get to that point and demand. And they don't want you to go through their crap, and they won't let you go through their crap. They will settle with you so quickly you'll have what you're looking for, a 40-year fixed at 1%, if you don't want to argue this to the point of declaratory relief. Just keep this in mind. Those subpoena powers are big time, okay? Number 8, unsubstantiated documents supported by non-existence powers of attorney, okay? Was there a POA ever in place? Was the POA recorded in the county recorder with the property? No. Subordination issues, including but not limited to reverse recording of documents. What's subordination? Subordination is where a lien holder, let's say I wanted to get a second trustee, and the second trustee didn't want to be in second but wanted to be in first, I'd have to contact the first and say, will you be willing to subordinate to the second, putting them in first position? Normally they wouldn't. That's just the way it was. But sometimes there was enough equity in there, and the first really didn't care, because if that second failed, which was the new first, then they can easily write the check for that first, and they'd be into debt for that one as well, and maybe it made sense from a foreclosure plan against the homeowner standpoint anyway. So that subordination issue is not limited to reverse recording of documents as to affect lien property priority. B, the county HOA or COA tax liens. HOAs, guys, we've got some stuff coming to these guys. HOAs, I don't like them. They don't deserve to be able to take properties because they use attorney's fees, which is not lawful, to foreclose on people's homes. I want you to remember, don't ever forget that. And I know that for the state of California. I'm looking for every state and their statutes and determining that. And so just remember that in the back of your mind. C, second mortgage documents do not denote specific subordination language. And number 10, standing issues by parties not entitled to enforce, not the PEAT, the liens based on the lack of constructive notice as mandated under statute, and or in the alternative based on incomplete pleadings in states where both the security instrument and the promissory note are required to prove claim of lien. All right. Don't you just want to throw up at this sample analysis? 15 minutes, guys. Just give me 15 minutes and we're going to have a full hour refresher. All right. So dig in on your screen. Take a look. Complete owners of record, neither being completing the owners of record, neither being recorded. Advanced research shows that the originator did not actually fund the loan, but was acting as a broker for another funder, not named as a payee on the note. We're talking about analysis of an example chain of title and how it relates and moves around. And this is basically a graphic chart to help you identify what is on this graph. Within 3 weeks of closing, the loan number was switched, an act of invalid novation, which is replaced without consent of on the obligation. In the same way, you cannot just substitute in some way to pay off your loan. Neither can they substitute in someone other than to whom your loan should be due. After closing, nothing is supposed to change, but they have changed the loan number. Thus, this new loan number is not secured to your deed of trust. Do you guys remember that? It's that simple. Is there another loan number? That's not my loan number. I don't have a loan with you. Don't forget those words. Countrywide, the undisclosed funder is next paid off, and the borrower loan was used as security for a non-consented to act as of a novation because they pooled the Smith loan, creating another pool, another security, and another obligation via the act debtor covered by another set of insurance. It's crazy. REMIC status. The trust must become the taxable owner of the record in public records. They must own the asset 90 days after the loan closed. That is the startup date of this trust, yet they never become the owner of record until the assignment after default years after startup. Why? Unsound, unsafe, ineffective securitization attempt is the wording used in the consent order. They won't say unlawful or illegal. Those are the real words. The terms unsound and unsafe afford no legal remedy. Note, the note is scanned in the MERS system. Payee is left unnamed in the blank. Then the original is given to custodian, if at all, but usually destroyed. Guys, if you got no note, there's no evidence of the debt. MERS box shows MERS absorbed the note, and the DOT, deed of trust, then cranked out their own abomination. Okay? Upon entry into MERS, the instrument becomes defective. E-note, this is back to Robert Jane's book on MERS. This is what this is all about. E-note digits are customarily added to the original loan number, which makes that not your loan. They draw on the original number to claim it is still their number, but they are not allowed to e-register paper notes. So we use the change to prove the original has been destroyed. UETA basically says that if paper tangible is converted electronically, the UCC is no longer governs that obligation. Yet the UCC does not control every true obligation. Thus, what it ultimately says is that the obligation is rendered dead by the e-note conversion. It is unenforceable if converted into code. What do I mean by code? When you digitally copy something, it's code now. It's digital. It is not paper. Even though it may print to another piece of paper, it's not an original. The debt obligation has been destroyed. So if the debt obligation has been destroyed, how do you ever get your note back? The graphic shows the stripped obligation passing down through the Fannie Mae Trust with yet another new account number and new insurance to protect against all loss. The e-note is then pledged as perfected collateral to create second intangible obligation and security behind their certificate sold. So there are 2 or 3 players between the loan and the trust, and all guaranteeing payment to the trust. So where's the default? You understand? Boring. Look at this. Smith signed loan on 4/5. Lender records deed of trust. The borrower, Smith, notes intangible obligation stripped and transferred electronically. Freddie Mac received only a scanned image. There's no assignment of record to Countrywide in 07. Never became the beneficiary of record. The borrower loan was paid off by Countrywide on 4/5/2007. MERS, the e-note registration, on title, Countrywide replaced Smith, loan with new Countrywide number, novation. Countrywide as servicer, Bill Smith, for Countrywide account number, loan number, mail fraud. That's what it is. That's what it is, guys. I'm not saying it wrong. Countrywide's account number is not secured with the Smiths by the Smiths deed of trust. Remember, the original deed of trust and the note are one instrument. When split through securitization and new loan numbers are given, there is no loan. You don't owe them anything. New assignment of record to Freddie Mac in 2007 never became the beneficiary of record. Freddie Mac uses Smith e-note to create second debt obligation to pay the trust guarantor. Freddie Mac account number not perfected, not secured by Smith, deed of trust. MERS acts as agent without authority granted by the lender, First Magnus, the very first lender, to transfer the note. The DOT, MERS sold the deed of trust. 2011, the Bank of America, Home Loan Servicing, creating a wild deed. Only the note can be sold for value. The deed of trust is not a legal obligation to pay. B of A alleges merger with BAC Home Loan Servicing without written assignments of record. How much farther are we going to go? B of A sold the deed of trust to Nation Star Mortgage, creating another wild deed. This is ADFGLMPQ. Only the note can be sold for value. Deed of trust is not legal obligation to pay. Nation Star Mortgage replaces Countrywide account number, blah, 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 with new account number. We have another novation. Nation Star Mortgage as servicer Bill Smith for Nation Star's account number, which is, again, mail fraud. Nation Star Mortgage is not secured by Smith's deed of trust. Nation Star Mortgage sold deed of trust to Freddie Mac, another wild deed. Guys, this is all in the law. First point, a wild deed is a deed without any chain of support and thus no effect. Second point, They cannot sell the deed of trust. They can only memorialize the sale of the note. But the note was sold into the trust to Fannie Mae in 2007. So how can they claim to have any note to sell now? Get it? Here's the trust. How the hell did you sell the note? You didn't. So the third point, whenever you get a change in servicer, you get a change in loan number, another novation, which is why we want the record of servicer letters so that you're not being billed for your loan. The loan has been paid off. You're being billed for an account of novation on another loan, on another obligation. Do you get it? Is that hard to get? So Freddie Mac account number gets foreclosed, 9513. Freddie Mac failed to become the beneficiary of record, secured by the deed of trust. Trustee's deed upon sale, void, violation of CCP, subsection 2924, unauthorized trustee. Homeowner, trustor is the legal owner of record, and no debt is secured by the real property. First point. This is the number that appears on the notice of trust deed sale, but it appears as an investor number. Later, in the cash for keys offer, the same number appears as the mortgage number. Last point, in securitization, the alleged owner can't possibly own the note in the way they say they own the note. If 1,000 people own a slice of my note, how can 1,000 people own a slice of my security? I sliced up a dog, and yet every slice gets the whole tail? What? Conclusion. The findings put you into a concise package that consists of a chain of title analysis. All right. So we're going to hold up here. Right here's a good spot. We got about 30 slides left in this presentation, and we're going to take an hour break. Don't sweat it if this screen shuts off. We're going to be fine. But I will see you guys at 2 p.m. Pacific in exactly about an hour and 5 minutes. God bless. All right, guys. Welcome back. We're going to be finish up presentation number 6. This is after lunch on Sunday. We got about 2 hours of solid presentation to go. Confirm Damien for this afternoon for Q&A. Get your questions ready. Little Flock is in both chat rooms working it, and we will get your questions answered. Damien is more on the end of litigation. In these last 2 hours, I am going to say, are going to be where you need your brain food. Go get your organic energy drinks on. Get your coffee going. Get your pens ready. This is going to be good stuff, right? But it's going to stretch you. So work with me. Now, remember that the chain of title analysis, the RMBS, which is the previous slide, loan securitization diagram, it includes information on endorsements, trust agreements, pooling and service agreements, prospectus, supplements, circular supplements, voluntary lien reports, affidavit of fact, laying basically the foundation for the information for declaratory judgment. Hold on. Let me get that off my screen. Here we go. All right, so color of title. This is what the CODA, the chain of title analysis, chain of title assessment. This is what it shows: the appearance of legally enforceable right of possession of ownership. A written instrument that purports to transfer ownership, but due to some defect does not have that effect, meaning there's no PEAT. A document purporting to pass title to land such as a deed that is defective due to a lack of title in the grantor passes only color of title to the grantee, not lawful title, color of title, meaning there's no lawful transfer. There's nothing that's been done according to statute or code. So how to use the CODA? educational analysis. This is basically a picture of a cover sheet of a chain of title analysis, and you got a table of contents that shows you the information within there, and I wonder if I can blow that up for you. Let me see if I can blow that up a little bit for you. Nope, hold on. I'm working on it. Nope, this is old school. All right, so I will have the same kinds of PowerPoint on both computers next time. So as you see, you have intro to conveyance and securitization, mortgage loan, transaction history, and the I'm already blown up and I can't read that third one. So and I'm going to provide you guys a sample, full sample, at the end of the weekend of what a chain of title analysis that we produce and a copy of a declaratory relief package that we produce of a live person with their stuff redacted on somebody that we've been able to help. And you're going to be able to understand and read really what gets included in a chain of title analysis. So it's an 8-page, the first 8 pages outlines in detail the process, okay? The parties to the transaction, everybody, the borrower, the address, and the lender, the servicer, the trustee, closing date, the loan amount, the interest rate, basically the depositor, the REMIC name, the trustee, the master servicer, it's all here. So we include all database search information and criteria and screenshots showing you the classes and the activities that have been paid, everything. The when we looked at these larger RMBS loan securitization diagrams right before we went to break, we were looking at that screen, and you're going to look at kind of like another sample of it on the next one. I'm going to show you real quick. But the blue boxes identify parties to the transaction, okay? The green boxes identify or denote the tangible promissory note and the intangible payment obligation, meaning tracking where it went, how it went, all that, if you take a look, okay? Then the gray boxes indicate the security instrument, okay, which is what? The corresponding deed of trust, security deed, and all that. The brown box indicates the land records entry, okay? Orange County Recorder's Office, and that's about it. So the infographics are specific to the situation at hand, proprietary to us, about 30 of them. Infographics like this one show what did or did not happen within the CODA. Now, the RMBS loan diagram shows actually what happened in the process of the securitization. So this is cool. So you get the detailed breakdown of the transaction process flows within the security, specific, guys, specific to you. This isn't just a diagram that we throw in there as an example to a judge. We show your chain of custody on the securitization aspect for your loan. Okay? So when people are out there looking to try to get a securitization audit, we do that here. I mean, we're showing you right now. We do that as well. But because it shows the stripping of the note from the deed of trust, breaking the instrument. But more importantly, we show you how it breaks the instrument according to the chain of title and the laws that are behind that, and why that they don't have any secure position on title, why they're not PEAT. So past this point, there are no more assignments of the mortgage until ultimately after the fact, meaning the securitization past that R&B trust when it goes in and locks in and it becomes that cement pool and dries up in 2007 because they can't accept more, pull any more out, right? Because that's the pool they're selling. Those are the notes that are paying on the trust, the people within the trust and the certificate holders and so forth. So there's no more assignments until ultimately after the fact, not of the complete instrument, and no endorsement on the note to back up the assignment. So upon loan default, the documents purporting to be assignments are recorded. That's what we see a lot. The purported assignments transferred nothing as to the intangible payment obligation. The debt has already been stripped from the tangible note. These recordings of assignments do not memorialize the sale or negotiation of the tangible note. So it shows what actually happened in the process of the securitization, reveals the stripping of the intangible obligation from the tangible note. This is not only about what they've been doing for years or what policy dictates, it's about did they follow the law. Is it A, B, C, D, or are they committing fraud before the court? Okay? Now, I don't want to get into all that we're doing in negotiating or finding information within the mortgage fraud investigation. If you go back a bunch of slides to where I read to you, so right here around 59, if you go back here, remember I was reading to you right here where we were outlining, and this is a copy of what's on a CODA. If you receive a chain of title, we're outlining for you the chain and the breach right here, and this is why, and the novation and the mail fraud and this and that and the other. So right here, when you're looking back once again, this is where it would be. This is where we outline that information and give it completely to you guys on the chain of title analysis. The discussion more specific on January 10th, I'm not going to read all this to you, but I'll read a little. We break down the documents, okay? And we identify the loan number on such and such date, execute on such and such time, blah, 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 and each one gets broken down. So taking this and breaking it down further. Okay. So the written agreement created by the trust is a PSA dated in 2005 and is a matter of public record available on the website at the Securities and Exchange Commission. Okay? So we're showing within the document where they can go and find the fact that the note was separated from the deed of trust, taking the instrument and making it null. Now, the case law pertaining to state-specific, not necessarily UCC, but state-specific case law pertaining to the trust, the PSA, we give it in the document so that you can outline it. And if we do the declaratory relief package for you, this is all incorporated into the lawsuit. And so you have your complaint. We do the complaint for you, and this information is pulled from there. The state-specific case laws that are cited in the complaint are thrown onto your complaint, and it's where you don't have to do any of that. So voluntary liens report citation available in 95% pretty much of all cases gets included. Internal Revenue Section, again, 860 regulates the activities and requirements of a REMIC trust. And according to 26 CFR, the identification of assets, the formation of the REMIC does not occur until the sponsor identifies the assets of the REMIC, such as through execution and indenture with respect to the asset, and 2, the REMIC issues the regular and residual interest of the REMIC. So this is the code pertaining to the payments to the trust through the REMIC. And guys, if they have been paid, they have been paid, and why are they going after you? I just want you to remember that. So let's talk about absolutes in conclusions. If they say they did not acquire the assets prior to the assignment, or that they acquired the assets prior to the assignment of the mortgage or DOT, the deed of trust, they are lying to the trust, or they are lying to the parties in court. Guys, if you can get an attorney you can prove an attorney lies once in court, you own the court. You run the show. Assignments, because it really pisses off judges that they're dealing with incompetent counsel, that they can't help them. I'm going to do a presumption here a little bit, but when your country is in an open bankruptcy, HJR 192, and all the assets belong to the United States, really the bankruptcy judges are trustees, no matter what. And people want this is not an arguable conclusion. You can't argue this because you can come up with different facts or theories, but this is really what it is about. If you understood the law, you would understand what I'm about to say. So the point is that when judges are dealing with counsel that can't play the game with them, they get pissed. And so, yeah, let's give it to the homeowner once. Let's get that one homeowner happy out of 100 or whatever, and that's what they're doing on these quiet title cases, 1 in 1,000 on quiet title cases, and let that one slip by because this counsel's so incompetent that he is going to make me look so bad that I would have to commit blatant, open fraud upon the court, upon this party, instead of just giving them the house. Well, what are they actually giving them? Let's figure this out really quick. They're not giving them anything because a grant deed doesn't necessarily give you your home. Okay? If you're paying taxes on your home, you don't own your home. I just want to tell you that. So just look at the big picture here. They're just trying to make people think that not everybody can get away with it. But the declaratory package makes a whole different game occur because you're not dealing with a court of equity where you're saying, look, I want to sue for millions and millions of dollars. You're just saying, I want you to tell me whether these docs are fraud. So when you get an attorney caught lying, oh, it's good. It's good. And as Jim Carrey would say, it's good. I forget what movie that was in. I'm sorry, I'm doing my impersonations. Assignments only memorialize transactions. They do not cause transactions. Remember, the transaction is the sale. The one party moving the home to the other party being paid full value. So if they memorialize a transaction by assignment in 2013, but the trust closed in 2005, again, either they lied to the trust that the parties and the parties that asset was never with the trust, or they're lying to the parties today to put it into the trust 8 years, ultimately. Nah. They're lying in court. That's all you got to do is prove. So we compare against the tangible note to prove the truth off the assignment for endorsement, transfers, and delivery through the negotiation. This analysis thus lays the foundation for any action. So the analysis also deals with the substitution of trustee. Okay? Here's a copy of a document that's showing what's being transpired between the parties from the lender to the substitution of trustee because they're going to try to come into a point of foreclosure. The notice of default. So, on the notice of default, the document purporting to be the notice of default and election to sale under the deed of trust dated March 25, 2010 is invalid as a notice of default and election to sell under a deed of trust, and here is why. Again, this is in your CODA. Okay, so California Commercial Code 3203 in your CODA showing necessity of a complete interest. If a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this division and has only rights of partial assignee. Okay, now remember, you're in a tranche. You're in a mortgage-backed security. You're a party to it, according to U.S. Bank's own words. Somebody's coming into court. They're saying, I am the holder in due course. Did they pay full value for it? No. Here's your code. You're nothing. So, lastly, the impossibility of putting Humpty Dumpty back together again inside the trust is identified. And we show the classes of the trust that have rights, and we outline it. Ownership of the Doe intangible obligation cannot be rejoined to ownership of the Doe note or the Doe deed of trust. And why? We tell it to the judge. You tell it to the judge. We tell it to you here. So the sum total of this information lays the complete foundation for obtaining a declaratory judgment regarding the rights acquired by parties. Okay, we're going to go not into a break. I'm going to close out the slide and open up my next one, so hang in there just for 10 seconds. Yeah, we don't provide legal advice. Going to court. All right, here we go. Let's go. Let me get rid of it on my other screen. Give me a second. Time to pull out the 45 of law and smoke them. I used to say that in front of hundreds of people, and they'd just go ballistics. They loved it. Isn't that funny? You're like, no, not really, Kelby. I don't understand. It's metaphor. You're not going to hurt anybody. You're going to hurt them financially. Actually, you're not even going to do that. There's no hurting these people. They've been paid too much. So, using declaratory judgment to get quiet title, what makes quiet title timely? Well, when is it better to take a different action? Many quiet titles are remanded to federal court and go nowhere. I'm going to tell you a quick story. There's a big company out there. I'm not going to say their name. They do securitization audits for people. And in jumping into the foreclosure, quote-unquote, ministry or business, or however you want to look at it, we call it our ministry, we went down that road of securitization audits too. And it was because we didn't know. Remember, we outlined it earlier in this conference today that securitization audits could be construed as hearsay. And why? So we contacted, I made a contract with a large securitization firm, the largest one in the country, I believe, and I started looking at their quiet title package, and I started looking at what they were doing. I thought, wow, this is really cool. And I contacted the attorney. I started doing due diligence, and I started asking the hard numbers, and the attorney literally told me everything, and he probably felt bad after I talked to him about why he's doing what he's doing. Because he was getting ready to go to a Christmas party, and he probably spent a lot of money on a Christmas party as one of the partners, and they think they're doing a really good job. But this is what they were doing. They were giving him a deal, $6,000 retainer, $1,500 a month. And out of the 100 clients that they had history with, they only helped about 50, if that's what you want to call it, into a modification in which 75% of them re-defaulted. Point being, none of them had principal reduction. None of them had true help. And they would go through this process with these law firms for 25 months at $1,500 a month. So when you're done looking at it in hindsight, do the math. $35,000, $40,000 later, you're being told you're still going to go into foreclosure. You've made no money that you can put into the principal of your house. It all went to an attorney. And they did nothing for you. So I backed out of that agreement. Just cold-faced backed out. And we started going elsewhere because quiet title actions is a secondary thing that should be done when you've got the declaratory relief done. The biggest obstacle in a quiet title hearing is the judge. In doing a coda, you are doing what needs to be done to prove title ownership before the judge. You cannot do a quiet title until you resolve the standing issue and prove that Pete is not present. So many quiet title actions are remanded to federal court, 12B6 dismissal. Almost all of them. So getting a declaratory judgment ruling on the merits results in res judicata, the matter having been decided. Okay? Let me explain this. If you go and get a quiet title and you lose, the matter's been decided. What are you going to do again? Nothing. You're screwed. It's over. You have your one shot, and if you blow it, it's over. So anybody in a quiet title, you better restructure your documents because you need to come in with a 1-2 punch, not a 2-punch. So laying the proper foundation is essential before one can begin building upon it. This applies to almost everything in life. It is no different than the issues pertaining to foreclosure. Whether going on the offense or defense, When one desires to start building, they need to make a determination as what ingredients to use. Should I use straw or bricks? I'm not going to read this whole thing to you, but this first paragraph. In a foreclosure action, declaratory relief should be considered a brick, and it's a good start. The declaratory relief judgment is a judgment of a court which determines rights of parties as well as establishing status quo. Unfortunately, it is not used as much as it should be in this writer's opinion. Okay? This is Joe, the gentleman that was on yesterday. So the path to res judicata, put all the cards on the table, setting up for the appellate court. And by the way, appellate court is really where your true victory is. I'm not saying that's going to happen here. But if you properly document the record and you set up for appellate court, they're going to come in with a settlement. They're going to do whatever they can to get you out, because before trial, they don't want to go to trial. Creating collateral estoppel, settling the facts. You need to put all your cards on the table up front, because if you don't, you will not get a chance to use them in the future. Do you understand? Setting up for the appellate court, you can't make any new arguments. The declaratory judgment is good only for the issues actually put on the table for judgment. You are setting up your case to go up to the appellate court if necessary. In the appellate court, you are articulating each and every argument from a lower court. We want an order from the court stating that they have no rights. They're not their assignments are invalid, etc., because of whatever failure in compliance and statute and code and ordinance and law. This then creates the collateral estoppels, preventing them from coming forth with any issue of right to title. Once a fact is settled in the court, parties may not litigate the same issue even if they are using a different cause of action, res judicata. So, what does that mean? The term is heard time and time again. However, I believe that a few have an understanding of what is being said. In layman's terms, it literally means a matter judged. It's already done. Res judicata is the principle that a matter may not generally be relitigated once it has been judged on the merits of the case. So if you have additional issues that were not brought forth prior to the case being adjudicated on the merits, then you will be barred from bringing any additional issues. Holding your cards close and worrying about that the opposing side will get an advantage if they see all of your cards will hurt you more than help you. This is called a claim preclusion. Now, guys, look. This is why it says a double-edged sword, in my opinion. People that throw, and I've seen this time and time again, I have talked to a lot of people who've won their house in this last couple of years. A couple of them are personal to me. And they will say the same thing. Do not throw it all on the table. Where Joe, who wrote this, is saying you may want to if that's going to be an argument in the future in the appellate court. What happens, and I've done and listened to all the Title 42 stuff, I've listened to all the criminal stuff, I've listened to all the different people that are out there, but the ones pertaining to the houses, that's all we're talking about today, okay? And Joe has a great opinion here, and this might be a good opinion and to a lot of people, but you need to realize when you throw the entire set of steak knives at somebody, you don't have any more steak knives, all right? They do. And they can use those steak knives for whatever they want. They can cut a steak or they can cut you. And so when you throw everything in a court, and let's say you have one thing wrong with what you're saying, that is the only argument they need to defeat to get summary judgment. I'm not telling you what to do. I'm telling you that this is something to consider. The people that I have talked to that have won free and clear title have been very precise with their actions. They're not all over the board with the kitchen sink and throwing in all kinds of stuff to try to get. I mean, I've seen him bring in the United States government, fraud, HJR 192. I'm like, are you nuts? You want a judge? And listen to me, this is literally what you're asking a judge to do when you throw in everything. You want a judge to make a ruling or a jury to make a ruling. The judge is never going to let you get to that, to a jury. When you start bringing in different issues like discharge instruments, different issues like you're never going to get to the point where a judge is going to make a determination in your favor. Why? Because it's letting the cat out of the bag and he'd be dead in 24 hours. Think. Remember, we're trying to give somebody a reason to hang their hat, and generally that's a lying attorney that's fraud upon the court, or you've been very precise with your documents and they can't find the fraud of your documents and dismiss the case. They have to proceed forward. Something to consider. Okay? So variant approaches state by state to declaratory judgment. Examples: in California, it includes a rescission of assignment of deed of trust. In Florida, verified answer, affirmative defense, and counterclaim. Don't ever do an affirmative defense. You're just affirming all the stuff in their action against you. Declaratory judgment is done differently depending on the state. California, we do an example of a sample for a declaratory judgment for a suit to quiet cloud on title with a rescission of assignment, a deed of trust, that was ineligible to be recorded. In Florida, we do a verified answer or affirmative defense and a counterclaim for declaratory relief. Now, this is something that me and my back office, we always go back and forth on. And when you're working together towards bringing solutions to people, you have to look at history and you have to look at what works. And when I'm speaking of affirmative defenses, I'm speaking of civil cases, I'm speaking of criminal actions mainly, and I've never looked at it from the standpoint necessarily of going into a foreclosure action. So everybody does things a little bit different, and when you're having victories and or settlements and you just want to proceed forward and make sure that you keep going down that road that is killing it for you. So vetting a quiet title action and eliminating competing equity claims. So you want to be, what quiet title is basically saying you are the superior position in title. That's what quiet title is. Evading remand to federal court, equitable cause of action and equitable remedy, essentially the essentiality of the declaratory judgment, equitable claim versus legal claim, establishing potential claimants through public record research. So quiet title is the valid cause of action, but is usually put as the cart in front of the horse by premature filing without the necessary proof against the opposing standing party. As a cause of action, quiet title must meet certain statutory elements, including that there cannot be a party with an equitable claim of title coming forth to make a claim. So if you got a party in that room, you got to deal with them. So if someone comes forth with such a claim, it gets remanded to federal court, and with the 12b-6, failure to state a cause of action, state a claim, because someone is still claiming title interest, a color of title claim, and it is at all over. You must get rid of the issue of standing before you quiet title. This is step one, declaratory relief. So quiet title is an equitable cause of action homeowners do use to determine the clarification of who may have an enforceable equitable claim to title because they believe that there is a cloud to title on the property. But quiet title is also an equitable remedy. But to receive quiet title as relief, the homeowner must meet the statutory requirements of the states, which say there cannot be an enforceable competing equitable claim to title on the property evidenced by a properly secured mortgage loan instrument. So meaning if there's a deed of trust, a security deed, or any of those brought to the table and they wave it in the air and it hasn't been set off, discharged, paid off, whatever you want to call it, there's an issue. There's an equitable claim to title. And if there is a standing assignment, someone has an equitable claim. So 12b-6 motions screen out those claims based on a wrong for which no claim for remedy can be granted. Therefore, quiet title should not be sought as a remedy until after declaratory judgment comes forth, establishing that there is no one else that has standing to make the claim to title. Now, just as a quick note, there's people out there, attorneys, big ones, that have made quiet title claims, and they get quiet title often, 20, 30 times a year for their clients. Well, the great majority of all those, and or all of them, are current in their mortgage, meaning the bank isn't able to come and waive they're just trying to get out of paying their bills. They're just not bringing it into that court of equity to bring the determination from the judge. You're a deadbeat just trying to get out of paying your bills. Therefore, is legal claims to title and equitable claims to title. Legal claim is a superior claim until dispute arises, at which point settlement of equitable claim becomes superior. What I was just talking about. So before taking any action, then one must first determine what they are trying to achieve in light of federal rules of civil procedure. See, this is why, guys, back when I made the contract with that company, the large securitization audit company, and then they were deferring people to their law firm, which was bringing people into quiet title, not just 100 people at that time, it's probably multiple thousand by now, not just 100 people at that time were doing quiet title actions and going into either a foreclosure loss where the judge ruled against them or a crappy modification, but they lost the right to sue again. So all of these issues, meaning what we are doing, declaratory relief, must be done through our process of relief first, not the QT process, the quiet title process. So a cause for declaratory relief will not stop a foreclosure, but will give a determination as to the rights of the parties in controversy. To determine who to bring the suit for declaratory judgment, go to the public record to determine who has issued some sort of claim through assignment. Now, noticing potential claimants. All potential claimants must be noticed of a quiet title action. All known parties, grantees of record, must be directly noticed, served. Tax records and land records must be researched to uncover potential lien hold claimants. IRS, franchise tax board, mechanics liens, whatever. All unknown claimants of record need to be noticed by public notice. What did I just say? You know what that means? You're putting something on the public record pertaining to that legal description at that address. Here's what's happening. So all known parties, grantees in a chain of title have been noticed in a quiet title action. By the way, there is a guy, there's several people doing this, and I have not pursued it because I don't know what the legal ramification down the road would be, but there is some people where they go and they find a lender that is out of business, okay? They look on the county recorder, MERS was a part of the transaction, lender's out of the business, no assignments have been made. That's a lot of loans out there, okay? They do what's called a public notification, serve the Secretary of State, because that's where states incorporate their businesses, lenders incorporate their business. They serve public notice to the lender, and they serve the Secretary of State, and they do a quiet title based on public notice and serving of the Secretary of State. That's it. These lenders are out of business, so who shows up? Nobody. Quiet title is granted. Why? There's no other claimants on that public recorded parcel. And so literally, they're getting quiet title. So consider that. Not recommending that, but you can find that all over YouTube. Go type quiet title and check that out for yourself. So tax records must be researched to identify the potential lien claimants. Discovery may be necessary to determine if the liens have been satisfied. All these parties have to be noticed in a quiet title action. So where no land records exist, parties are noticed or notified by public notice. This is especially good, like I just talked about, when to do when not in default and loans have been securitized and are passed through MERS without recording, because when not in default and unquestionably in possession of title, and other parties need to be only noticed publicly because they did not enter it into the public records. And a quiet title can be much more easily achieved when you're current on your home. Huh. Pretty cool. So, keeping quiet title in rem. Quiet title is an in rem action. You are suing only pertaining to the property, not toward a person. So you mention only title and never the debt, or you will lose. It is not a quiet title action if you're bringing debt into it. So if you do not sue for quiet title and for damages at the same time, that is called quasi-in rem action. Do not turn a quiet title case into quasi-in rem bringing damages. Don't do it, because you're bringing it into a court of equity and the judge is going to kick you out because you're bullying against your friends, the banks. Quiet title is not about the note and the right to enforce. These standing issues may be bypassed. They must have already been settled. So taking your declaratory judgment case to court. Procedural and substantive defenses. Procedural foreclosure defense relates to the way the home was foreclosed on, California Code, subsection 2920 blah, blah, blah. Substantive foreclosure defense relates to whether the foreclosure entity actually has a right to foreclose. Okay? Usually referred to as standing. The standing issue is the more powerful defense. Who's Pete? Where's Pete? I don't hear Pete. Pete is not in this room. That's a fraudulent assignment. I don't know how that assignment could have been done 7 years after the fact. Constitutional standing equals a standing based in injury. Prudential standing equals a standing based in procedural compliance. Controlling the narrative. Arguing their standing versus your performance. Okay? This is ping pong. Deflect questions, answer questions with questions, follow their game plan, not your logic. Okay? Don't get emotional. Make them ask the right questions before you answer. Focus on the note, not the mortgage. You must control the narrative before the judge. It's called Rick Schramm, who just passed away in this last couple of years from cancer, who won his Title 42 cases in the 90s and early 2000s. He was the best at teaching on point. If you need, go find somebody that has his disc and learn how to stay on point. Rick Schramm was the best at staying on point. Strike everything, guys, that they put in. That's your objection on paper. You must deflect all questions such as, when did you last pay your mortgage? They're trying to bring you into an equity argument as if you owe the money. Okay? They are irrelevant to the standing issue. Objection irrelevant. This is a standing issue on their part as the defendant, not a performance issue on your part as the defendant or plaintiff if you sue them for declaratory relief. It is not a performance issue until the standing issue has been settled. Look, we don't go into court and talk about my payment. We go into court and talk about whether you're the one I'm supposed to be making it to. And according to the public record, it's clearly identifying you're not. And either you're submitting fraud before the court showing that the trust violation is X, and that you are trying to put this back into the trust 7 years after the fact with your stupid assignment, which says it's fraud on its face. So either you're frauding the court, or you've done some phony documents, or these documents are inaccurate. What is it? And so when a judge asks, well, did you pay your mortgage? Your answer, the issue is, Your Honor, it has to be the issue, Your Honor, is, has the plaintiff pled an injury? They can show a note, but what if the note has already been paid off? And how did they get the note? The claim of default is not a claim of injury. It's all about injury. If no loan was made, or no proper assignment done, there is no injury to this party who is not the person entitled to enforce. So if the originator did not make the loan, but an undisclosed warehouse lender did, the originator is not injured. On for the record, I demand that they state if they are injured or not. Are you the true party creditor or not? But if you haven't been paid for a year, Your Honor, I haven't been paid for a year. Are you saying that you made me a loan? They will not answer the question, but will always deflect it back to the default. You must control the narrative. When the judge asks, well, did you get a loan? Your answer would be, Your Honor, don't you believe that the person who made the loan should be repaid on the loan? You have to establish who made the loan before addressing your obligation to repay the loan. When you answer, you've lost ping pong. So you're answering questions with questions. We lose because we follow logic instead of their game. We have to play their game to plan to win, despite how much we hate it. In their game plan, questions are answered by more questions, i.e. answers that beg for questions, such as responsive pleadings. You're asking questions to go through the burden back upon the other party. The worst thing that you could do is answer. Oh, yes, I haven't made my payments in a year. Gosh, I can't tell you, man. I go into court and I hear people do that, and it just bothers me. Dude, I just trained you for 2 days. I told you exactly what they were going to do. And we forget because we get scared or because we look at them and we think they're omnipotent. Their robes are shiny. No, they're black. They're not shiny. They're 10 feet off the ground. They're floating in midair. They look like God. They're treating me like God. No, God is much nicer to you. Okay, they're not God. If anything, they work for the enemy. Stop idolizing them. Okay, they're not even doing their job. They're protecting the interest of the United States corporation, which is operating as a military-industrial complex against the entire world reigning tyranny. I got it. I understand. Just go into court and win at one small game of ping pong. Just relax. Deep breath. Think it through. See, you're asking questions to the that you want to make sure the burden goes upon the other party. The worst thing that you could do is answer. So don't answer them. Answer with a question. As long as you're asking questions, you are in control of the narrative. Even if they are not answering, the judge says, when did you last make your mortgage payment? You ask, what loan are you talking about? The loan you got, he says. Well, what lender would that be? Are you telling me you did not receive any money? From whom did I receive the money are you referring to? Make them ask the right question before you answer them. Your Honor, the one who made the loan should be repaid the loan. Is that right? Well, who is that? Are you telling me that you didn't receive a loan? That's what they do. Ping pong. They're going to repeat themselves. They're going to get mad. He's going to pull his eyeglasses down to his nose. He's going to lean forward, puff up his shoulders. He's going to act like he's going to show he's not impartial. He's not a third-party intervener that's there as an unbiased witness to just be a judge regarding these proceedings. Well, what loan number are you referring to? Is there a loan number that is attached to my property? I'm telling you, there is not. So please ask them what loan number is attached to my property. If the judge says the UCC doesn't apply in here, you ask, well, does the tail control the dog? What controls them, the obligation or the security? On what point of law? Never answer questions. Ask questions. Never. So, here's some tactics. Respond. Level head. Do not get emotional. Relax. Stay in charge. Stay on point. Shift the burden of proof. Oppose everything. Everything. Strike, strike, strike. Object, object, object. Move to get all your evidence on the record. Always refer to the other parties as debt collectors. Remember that to respond does not mean to answer. You do not answer right away. Don't let him push you. Breathe. Look at your paperwork. Take your time. If he pushes you, look up. Say, I'm invoking Haynes versus Kerner, for I'm not learned in law. I need a few minutes to get my notes together. Can I please have a few minutes, sir? Get your head together. Breathe. Because when you answer, you give lawful jurisdiction over you, yourself, to the court. You never want to answer. You want to respond. You're saying, I deny the jurisdiction of this court. I'm making a limited special appearance to the request of the validity of this action. Boom, boom, boom. That's if you're as a defendant. Most lawyers try to win by never even going to court. They do this by filing a motion for summary judgment. And you know what? If you don't respond to it, they get it. You have to stay on point and shift the burden of proof. Again, listen to Rick Schramm. If you ever get a time, he teaches on Title 42. I do not recommend suing the federal government, but he teaches on Title 42. Title 42 is what is used for rights violations lawsuits. If you are a United States citizen, you do not have rights. I'm just saying, I'll show you in the law where the Bill of Rights does not apply to a U.S. citizen. It applies to an American, a state citizen. So stay on point. Rick Schramm teaches you how to do that. If you really want a course on how to stay on point, listen to Rick Schramm. He's dead. Never met him before. He is one of my heroes. If you do this right, the judge will stop being bored and listen up and take notice. Listen, guys, this is cool. When I go in to watch like some of my friends that are really good in court, and I love it because what happens is the judge is bored. All he does is he goes up there every day, all day long, and really he's interacting, doing the same crap. And then sometimes I'll see him wake up. His eyes will open up. He'll look out, and I go, oh, you can tell. He's thinking, oh, we're the opponent. Oh, all right. Today isn't going to be so boring. So it's hilarious to see this happen. But when that happens, trust me, you got two expert ping pong stars that are about ready to go at it. And all we're going to do is try to hit the ball back and forth, respond, not answer, respond, not answer, respond, not answer, respond, keeping them on your point, not what they want to talk about, respond. So regarding evidence, you must get all evidence onto the record. You must say, I move the court to enter my evidence into the record. This is not on the record just because you want to talk about it and refer to it, and say on and for the public record, and if you need to, read your whole case. And when they object and they interrupt you, you say, excuse me, I'm on and for the public record right now. You cannot interrupt me, and do not do it again. And then keep reading. And you could stand there for 2 days, and until you're done, you're not done. And it cannot be interrupted in law. So refer to all the parties as debt collectors again. Debt collector is never looked at as a secured creditor, whether judicially or non-judicially. A debt collector is never an injured party. Did you make the loan or did you buy the loan? If you bought the loan, did you buy it for full value? The answer is no. We just went over that in the California Code. Then you have no authority over this property. Bye-bye. Unwinding the event chain off the assignment. Substitution of trustee, notice of default, notice of trustee sale. Once the assignment is derailed and proven invalid in the suit through the proof of statutory and the PSA, noncompliance, etc., and unwinds everything else. If you bust the chain on link number 3, 4 through 25 fall off. Okay? So it unwinds everything based on that assignment that you attack or that deed of trust or what have you. The substitution of trustee attached to the assignment, the notice of default, and the election to sell attached to the substitute trustee, the notice of trustee sale attached to the notice of default. Once you establish acquisition rights in accordance with the law, not in a court of equity, game over. There's no such thing as a free house, but there is loss of alternative means of collection through lawful non-compliance. If you lose, you will lose procedurally. Hold on one sec. Opposing the motion for summary judgment. Yeah. All right, so here's where it gets interesting. Summary judgment and summary adjudication offer ways for a party to win all or part of their case without having to go to trial. Summary judgment is the whole thing. Basically, if there are no genuine issues of material fact that are in dispute, 10, the court decide the issues without the need for trial. 10, then. Sorry, guys. I did spell check this. It was late. I was tired. At least that is what we think, or they think. You must oppose motion for summary judgment or you will lose automatically. The easiest way to put issues in dispute for opposing a motion for summary judgment is through general denial. Okay? Your answer within general denial is every element in their summary. Better if you can support it with a chain of title assessment. Now, for help in opposing a motion for summary judgment, file your opposition to plaintiff's motion for summary judgment. You got to answer everything, guys. But what they're doing to cheat now is they're actually going into court and having hearings without notice, meaning you don't get served. So include a separate statement of undisputed facts and evidence, declaration, affidavit, depositions, other evidence. See, the defendant who brings a summary judgment motion, in essence, is making a promise to the judge. The promise is that the judge wades through all the papers. He or she will come to see that the plaintiff's case is so flawed, meaning the lender coming to say your declaratory relief judgment or your quiet title judgment is flawed, that there is no need to hold trial and the judge can dispose of the case matter of law. More specifically, the motion promises the judge one of two things. Either the plaintiff cannot establish some critical element of the cause of action, or that regardless of what the plaintiff can establish, the defendant has a defense to the claim. So as a pro se opposing a summary judgment motion, your job is to show that the judge that the promise has been broken. The summary judgment motions involve three different and often interrelated legal burdens: the burden of persuasion, the burden of production, and the burden of proof. Effectively, let me start here. Because one of the best ways to beat the motion is to show that the burden has not been met. So effectively, opposing the summary judgment motions requires an understanding of those burdens. So the burden of production is often the key to winning or losing a summary judgment motion. The moving party bears the initial burden of production to make a prima facie showing that there are no trialable issues of fact, where the plaintiff is required to prove a matter at trial by a preponderance of evidence in order to raise a trialable issue of a fact in opposition to the summary judgment motion. The plaintiff's burden is to introduce admissible evidence showing the matter is more likely than not. Check for procedural problems. Number one, this is you got to look at their documents. Is the motion timely notice? Summary judgment motion requires at least 75 days notice. Number two, is the supporting evidence admissible? If the evidence is used to support the motion is not admissible, it does not count. So it is worth reviewing the evidence carefully, paying particular attention to the critical evidence on which the motion hinges. So make sure that the documents are properly authenticated, that the witnesses have personal knowledge of what they claim to have knowledge of, and that the declarations do not contain inadmissible hearsay. Hearsay is more often what's done in court by attorneys than anything. Raise any evidentiary objections in a separate document titled Plaintiff's Evidentiary Objections, and make sure the court rules on the objections at the hearing of the motion. In is the motion substantively defective? Do the facts in the separate statement establish that the defendant is entitled to judgment? Has the defendant misstated or ignored facts? Has the defendant misstated or ignored law? Hell yeah. They're not even Pete. Tips for an effective opposition. Make sure your factual argument is fully in, well, let me go down here. Hold on. Be forthright, responding to the separate statement. Don't be afraid to admit that the undisputed facts are actually undisputed. And this is kind of an interesting thought process. If the facts are disputed, you must say so. But if they are not disputed, do not be afraid to say so. Defendants will frequently draft an undisputed fact that says something like, defendant's letter to January 15, 2014 says that all payments owed by the defendant under the contract have been timely paid. Remember that you're not trying to determine anything other than if Pete is there. If they are not Pete, then it is a moot argument that payments were undeserved. So make it easy for the trial court to deny the motion. Present your arguments in a way that make it easy for a busy trial judge to grasp quickly. Start your opposition memorandum of points and authorities with an introduction that explains why the motion cannot be granted. Follow this up with a detailed statement of facts. Support every fact with an accurate cite to the record. Do not write 5-sentence paragraph that contains multiple assertions of fact and then put one citation to the record at the end of the last sentence. This does not inspire confidence. It is fine. In fact, it is preferable to rely on the evidence submitted by the moving party rather than to include a duplicate copy in the opposition evidence. So, Rule 56, this is what happens when they're trying to pull the stuff into federal court. Let's do this. I just got something that says my slides are not advancing. I'm looking. I need to make a determination. Let's do this. It's 3 o'clock. Let's take a 10-minute break. I'll be back. All right, guys, this is our last stretch. We got to go 50 solid minutes and get through about 50-plus slides. And this is the tough part. This is where we're going to get into nothing but reading, and so that you can have points of reference later to what to go back to and look. Rule 56 establishes a summary judgment procedure. The very mission of the summary judgment procedure is to pierce the pleadings and to assess the proof in order to see whether there is a genuine need for trial. Okay? Rule 56 is a vehicle to implement the objectives of Federal Rules of Civil Procedure, the just, the speedy, and the inexpensive resolution of litigation. The history of summary judgment, the origins of modern summary judgment procedure are found in the 19th century English law. 1855 Summary Procedure Bills of Exchange Act sanctioned summary decisions on the merits of the actions to collect on bills of exchange and promissory notes. So summary judgment statutes based on the English model came to be enacted in several states in the late 1800s, and they violate every aspect of your rights to a trial by a jury if you are an American or a state citizen. It doesn't violate you if you're a United States citizen, however. Identifying the issues of fact, the principal issues that arise under Rule 56C are whether a factual dispute exists, whether the dispute is material to the outcome of the case, and whether the dispute is genuine. Basically, failure to show acquisition of rights is a material fact to the outcome of the case. So if you're faced with a motion for summary judgment, you need to be able to bring up the material facts in dispute. Once you do this, the burden is not up and upon the movement for the judgment to overcome your facts. You must plead facts and plead code. Half-pled cases produce bad case law. Hold on one second. All right, guys, I just determined we lost the screen. Hold on one sec. I'm working on it. sec. Here we go. Hold on 1 second. All right, guys, sorry about that. Hold on, we're on slide 20. Forgive me. All right. So, somebody confirm, y'all can see, please, and either confirm it on the start meeting side chat. Somebody type that you can see the screen again, please. Give a second for everybody to come back on if they got knocked off. Can't see, not yet, no. Okay, thank you. How about now? All right. You ready? Good. Sorry, guys. Got to do a little bit of editing on that. All right, here we go. So I'm going to start this slide over because we're going to edit that all out. And identifying the issues of fact, the principle rises that under Rule 56C are whether there's a factual dispute exists, whether the dispute is material to the outcome of the case, and whether the dispute is genuine. Now, failure to show acquisition of rights is a material fact to the outcome of the case. So if faced with a motion for summary judgment, you need to be able to bring up material facts in dispute. Once you do this, the burden is not upon the movement for the judgment to overcome your facts. You must plead fact and plead code. Half-pled cases produce bad case law. Okay. Hold on 1 second. Determining genuine disputes. What makes an issue of fact genuine? When the papers in support So the burden is on the non-moving party, okay, defendant. Once the movement makes properly supported motion, the burden shifts to the non-movement to demonstrate the existence of genuine dispute. Under Rule 56E, an adverse party may not rest upon the mere allegations or denials of the adverse party's pleadings, but the adverse party's response by affidavits or as otherwise provided in this rule must be set forth. Specific facts showing that there is a genuine issue for trial, nor is it sufficient for the non-movement simply to attack the credibility of the movement's affairs, i.e. your payments, without supporting factual showing. Okay? All right, here we go. No sound again. Can you guys not hear me? No screen and no sound? Dude, I'm on a 300 megabit T. I still have sound, Skip. What about screen, Dan? I have both. Okay, I want to pause the meeting just for a minute. Larry has both. Okay, here we go. The non-movement Movement may set forth specific facts by submitting affidavits. Now, guys, I'm just going to stop right here. I don't have a lot of time because we got now 30 minutes to get through a lot. Affidavits you need to read. We have a full section, Chris will find it, of where to find them in the law and how to properly prepare an affidavit, and there's cites and examples. This is critical. If you don't have an affidavit properly filled out, properly under the pains and penalties of perjury, with your name on the right-hand side, done the correct way according to law, it's an invalid affidavit and it's meaningless. So you can submit whatever you want. You're not a first-hand material fact witness to the case or whatever you're submitting forth. So the non-movement may set forth specific facts by submitting affidavits or relevant excerpts from depositions, answers, interrogatories, meaning all the crap, all the different things, all the stuff you found, you're putting it back into an affidavit to show why there's a genuine issue for trial. When appropriate, it may simply demonstrate to the court that the record on the motion contains sufficient specific facts to establish the existence of a genuine issue. That may show, for example, that the movement, by ignoring or mischaracterizing relevant facts in the record raising a genuine dispute, failed to meet its initial burden. Okay, Rule 56 requires a party opposing a summary judgment to set forth specific facts establishing the presence of a genuine issue. That can only be done by affidavit. All right. So unless there's a non-movement can show that the jury has a basis to return a verdict favoring the non-movement, there is no issue for trial. That's what this says. Read down below, Anderson versus Liberty. Okay, don't need to read the whole thing. Partial summary judgment, Rule 56 permits a court to grant partial summary judgment. This is where I want to sneeze and say bullcrap, but I really can't, because if you're a United States citizen, I guess it applies to you because you don't have access to the Bill of Rights where a trial by jury would apply. So while Rule 56D is most often used to decide entire claims, it is also available for most modest purposes. The rule enables courts to resolve some factual matters while leaving others for trial. In doing so, the court narrows the issues and focuses on the remaining litigation. They couldn't handle it if everybody went to trial. So I don't want to say I blame them, but at the same time, let's stop pretending we're a country giving rights to people when we're really not. And I don't mean to get off point. In a motion for rem summary judgment, the plaintiff states actions to collect on promissory notes are among the most suitable classes of cases for summary judgment because the elements of proof necessary to recover on a non-negotiable instrument are straightforward. Lloyd versus Lawrence. Number one, the defendant executed and delivered on the note. Number two, the plaintiff entitled to enforce the note. Pete. Defendant has failed to make payments. 3, and the amount is due. Okay, so points 1 and 2 are the points in which we show that there is material fact of dispute for defeating the motion for summary judgment. Did the plaintiff execute on the note pursuant to UCC 7-501? Question mark. Can we show statutorily that they are not entitled to enforce pursuant to UCC 9-312 or 3-203? Point number 3, we make sure of whether the tangible promissory note or the e-note being discussed, because without knowledge of who's Pete, who to pay, you don't know how much to pay. But this point is a gray area that will take you into a court of equity, and you just want to stay away from it. Just because they are a holder does not make them a holder in due course with rights to legal conferred upon them. Just because the company is called Federal Express does not make it a federal agency. Ha ha. To avoid 12b6 dismissal in federal court, the complaint need not contain detailed factual allegations. Rather, it must plead enough facts to state a claim to relief that is plausible on its face. Wrongful foreclosure is not a cause of action, people. It is a complaint. It is not a fact. Most pleadings are not properly code pled. For instance, you cannot just allege fraud. You have to allege the element of fraud and back it up in the pleading statutorily. Okay. Using the quiet title against defunct lender, this is Al West's strategy. He's a kind of a semi-famous attorney out here on the West Coast. Big big retainers, but he gets the job done most of the time. If the lender is defunct, the borrower is current on his payments, and so no one is making assignments. It is a perfect scenario for quiet title. Only the original lender has to be noticed. If one does the public notice, serves the Secretary of State, and the lender does not respond and it comes back non-service, you tell the quiet title court you have done your service. You have fulfilled the publication period and requirement. You get an affidavit of publication from the publisher, and you file it with the clerk. All unknown claimants have been served. You have the evidentiary hearing. No one shows. Judge agrees, quiet title, and do a motion for expungement off the record in the county recorder. And the borrower now stops making payments on the note. An assignment shows up, but it is done against an instrument number which now no longer exists. It was expunged. Next, because the new blatant or belated assignment, I like blatant, due suit to remove a cloud. Bye-bye. Can you say it's gone? It is more profitable to know simply that there is no assignment recorded in the land records than to find out whether a loan is active in a certain trust pool, because you do not have to notice parties who are not of record. You simply have to notice unknown claimants by public record. So other court suits on offense. Stay away from the fraud word. You're not looking for fraud. You are only looking at evidence. Attorneys wait for evidence to build in a case first and then move to amend complaint to include fraud. Once it is clear to the judge, this is where it is headed. Number one, RESPA statutes of limitation are 1 year, TILA statutes of limitation 3 years, FDCPA statutes is 1 year in most cases. I'm not going to try, guys. I've been killed by words this weekend. I'm not even going to try. Sine, quac, non. That sounds like an Asian thing. I'm sorry, I'm not. I've been destroying words all weekend, those legal words. And stop laughing, Lynn. I can tell she's laughing. Besides federal type issues, a CODA will bring up common law tort issues. This is where I want you guys to go get Prosser and Keaton on torts. Remember that book I told you to read. It's a recommended source, and it shows how deep the elements of fraud are to prove. Now, the Fundamentals of Legal Research 6th edition are the best source for paralegal to do research. Fundamentals of Legal Research 6th edition. Judge Philip Gutierrez, in his 13-page Mers versus Robinson decision, used this term above, sine qua non, I think I got it, conditions precedent to remove all claims of MERS. Conditions precedence refers to the conditions that must first have been met before one make an argument or take an action. Pete? Where's Pete? Season and the warranty deed. The primary sine qua non is in the warranty deed to determine if the grantor and grantee are fully seized of the estate. It is the prime condition that must be met to give a borrower rights to possess and dispossession. This is the prime condition that must be met to give borrower rights of possession and disposition. The main issues that develop CODAs is not much in the documents themselves, but how they relate to one another. Remember, I said lay them all out on a table, each document. Look and see, are they relating to one another, or are we going from A to C, A to D? This is why we study the seller as the grantee prior to make sure that he was first seized of the property with the rights to convey it. If the MERS was involved with the seller prior, it could spell trouble with the seller's right to convey. Your research through a MIN search based on the property address only is something everybody should do. Even better is to do a general index search going back to however far you want to go. If you have property in a subdivision, go back when it was planned and go forward. The foundation of a common law tort. These errors at the foundation of the chain creates breaches under common law torts. Okay? In the Lightfoot cases, they neglected to put the legal description in making the deed ineffective. It's that simple, guys. I've seen it. And so anybody looking forward to making their deed ineffective, look at a wrong legal description or a legal description. And this would be a good one for, what's her name up in Oregon? Trying to remember her name. Jody. Chris, get that one to Jody. So making the deed ineffective, because anybody that has a wrong legal description, that's their case reference. This creates a breach of warranty, breach of covenant, and forms a cause of action for negligence. So when the seller is not seized or the borrower is not seized through error, negligence of the seller having pocketed the money when issuing a deed to nowhere. That's what it's called. She got a deed to nowhere. Jody got a deed to nowhere. Becomes subject to a common law tort for unjust enrichment, being that the foundation of the chain was failed condition precedent. The Riley case has similar breach through the negligence of the title company. Thus, she can have no standing herself, creating a bevilaqua, B-E-V-I-L-A-Q-U-A situation. Sorry, guys. Since I switched to the other computer, I'm actually reading on smaller print, so it's making it that much more fun for me right now. All right, guys, we've got about 20 minutes to go before Q&A. I'm going to fly if I can. There is still a way, and by the way, we're about to show you some cases, all the famous cases. We're going to get complete copies of these cases for you guys so that you can review them yourself along with the seminar and notes, and you're going to have a full jam-packed bit of information to study, so don't worry. There is still a way to quiet title when somebody is nevertheless continued to possess and maintain a property demonstrating equitable interest. However, deficient in the legal interest may have become because of a failed season transfer. This is called adverse possession. In this case, while a declaratory ruling would show that Riley was not in possession of the property, the equitable interest establishing through the ruling would also become a basis for suing PHH Mortgage, which sought to assign the property to itself via MERS. We do not recommend using small claims court to get declaratory judgments on property. That's how we started against documents of fraud based on notary. They cannot be remanded or get remanded over or overruled. They can't get remanded or overruled by high courts, which is why we changed. Again, my apologies. Last 20 minutes, I'm trying to read small print, and my eyes are blurry. So, intentional, unprovable claiming of interest upon property, interference with warranty covenant by removing state quiet title action to federal court, filing false lis pendens. This is slander of title as tortious interference. Tortious interference is a tort claim. If someone comes without provable interest in the property, they slander title. That's tortious interference with contractual relations. A tort must be intentional. Standard out of conduct calls degrees of care. They have a duty. The warranty deed says the seller will defend the borrower's right to title. This is a private contract. Thus, when in a state quiet title action, MERS or some other entity comes in to remove quiet title to federal court, this becomes tortious interference with the contractual relation and ability to defend title according to the deed. You can go after them and their attorneys. They can also file a lis pendens that will slander the title. To set this up, you first put your property on the market to try to sell it, knowing the lis pendens will prevent from being sellable, vendable, and it makes the contract more costly to keep. Then you have to prove damages on which to sue for the value of the house. All this without mentioning fraud. Instead, we speak of inducing breach of contract. Attorneys wait for evidence to build a case, and then they move to amend the complaint to include fraud. Once it is clear to the judge, this is where it is headed. Sued to remove cloud. Someone foreign to title has to come and claim an interest. Okay. Key common law torts. Reference processor, Prosser, P-R-O-S-S-E-R-N, Keaton, K-E-A-T-O-N, on torts, 5th edition. I bought it. In general sense, the transfer of property with the intent to defraud creditors, lieners, or other in a particular sense, the act of an administrator who wastes the assets of a state by giving them away or selling at gross undervalue. Challenges of this type upon fraud are seen in the contesting of the low-ball purchase of a property at foreclosure sale, which would leave a huge deficiency upon the borrower. 3 elements must be proven: a benefit conferred upon the defendant by the defendant, and appreciation or knowledge by the defendant or of the benefit, and the acceptance or rejection by the defendant of the benefit under such circumstances as to make it inequitable for the defendant to retain the benefit without the payment of its value. The general principle here is that one person should not be permitted unjustly to enrich himself at the expense of another. When the deed is passed on without season, it creates a bevel. I don't even know how to pronounce this. This is a case, B-E-V-I-L-A, bevilacqua situation. Gosh, it's not my fault. All right. Doctrine of latches. If you wait too long to make your claim over these torts, you may lose some of your contractual torts rights. Tacit behavior through waiting to exercise your rights also sinks your appeal to tort rights. A little confusing. This wrongful act is denoted by the fact that conduct, whether of an act of omission, is such a character as to the subject of the actor of liability under the principles of the law of torts. To establish such acts, the plaintiff must prove not only existence of the actionable wrong, but also that the damages resulted therefrom. In this instant definition, the actor would incur liability by knowingly interfering with the contractual rights of another to that person's detriment. Objecting to the proof of claim in bankruptcy. Max Gardner, famous attorney who teaches attorneys over in boot camps on the East Coast, do not know him. They take the BK proof of claim form, they fill it out in the name of the lender, and they turn around and object to the proof of claim. They just filed because most of the lenders sit on the sidelines and wait for the BK to be discharged before they foreclose. This forces the lender to have to come into court and prove their claim. Sweet. In BK, it is imperative to have your reasons for assigning the lender as unsecured on your forms. As a pro se, just do it. Bankruptcy fraud is prosecutable criminally. But that's not bankruptcy fraud if they're not Pete, right? BK judges tend not to have an agenda and to follow the law, whereas, I don't know who wrote that. I didn't write that one. And that's not necessarily the case. Whereas not so for federal and state judges. They're better. They are. That got added in there. But quite honestly, guys, I've had a lot of BK judges where they dishonor their oath and do a lot of things just like normal and everyday judges. Other court actions pertaining to documents in course of your case. In the course of your case, you will potentially argue over the admissibility of documents. You must be prepared to challenge the authenticity of documents and motions against your documents. Okay? Requiring the original note, getting your original documents. Before asking the court to examine the original note, you must file a pleading, answer, or counterclaim. That pleading must support the right to inspect. You must deny that your original instrument is on the promissory note. Your opponent presents into the court, and your opponent will object and probably point out on a copy of the promissory note that you waived your right to presentment of the original promissory note. Well, this still goes where you can demand to see an original wedding copy, and then we present you a copy. You deny you signed it. You are not denying that you signed. You're only stating that this is not your original signature. Only the original note is the evidence of the debt. A copy is not evidence unless you allow it to be. If the judge allows it, you must object, Your Honor. You've just allowed the creation of a second original for which I am now liable. You must get them to understand that unless the original is in the court, it cannot be accepted into evidence. And, Your Honor, give me just a minute to go down the hall. I'm going to make about 3,000 copies of this $100 bill and bring them back here for payment to this lender, debt collector. We want to see the originals. A copy of the note is not evidence. It is a copy of an autograph. Has the copy been reduced or enlarged? If not, it is a counterfeit. If the note is not a copy of the original, there should be a copy of a staple evident, meaning see the black holes. But if the copy is of staple holes, it is a copy and the original is destroyed by disablement. Once you allow that copy in the evidence, you allow the creation of a second original. Okay? Challenging waiver of presentment. Most promissory notes contain a paragraph that states, I and any other persons who has obligations under this note waive the rights of presentment and notice of dishonor. Presentment means the right to require the note holder to demand payment in the amounts due. Notice of dishonor means the right to require the note holder to give notice to other persons that amounts due have not been paid. In layman's terms, presentment is the physical production of your negotiable instrument, the note, to the drawer, you, for payment. It is the demand for payment upon the maker of the note holder. They cannot say you have waived the right to presentment in USC 3-501B. Presentment pertains to a payment of an instrument, the note and the deed, together, not the proving of an instrument's authenticity. The waiver of presentment is written into a point 9 of the note to fool the borrower into believing he is waiving his right to demand to be able to see the note. If you are not allowed to see the note of which you are the obligor, this is a double jeopardy. Anyone can make the claim that they have the note and are owed the payment. There are at least 4 arguments to counter the bank. First, presentment isn't your right. It's the bank's right to present the promissory note to you and demand payment. California Commercial Code 3501 provides that upon demand by the person whom presentment is made, that's you have the right to inspect the note. You can have the party presenting it identify themselves and have them show you their authority to enforce it, sign a receipt on the promissory note for any payment made, or surrender the note as paid in full. The waiver of presentment, secondly, a waiver of presentment can be made, must be expressed by chapter and verse. Thirdly, a demand for payment does not negate the necessity of the holder to produce the original note on the request so that the drawer of the promissory note can check the proper and necessary endorsements. Fourthly, the promissory note is a non-negotiable instrument and cannot be transferred without signature, otherwise double jeopardy would be imminent. This is a diagram at which you can look later for challenging the claims of a lost note. Perfect. They have to prove that they've owned it before it was lost. Go straight to discovery on any such claim. Okay, lost notes. 3-309, a person not in the possession of an instrument is entitled to enforce the instrument if the person was in possession of the instrument and entitled to enforce it when loss of possession occurred. Revised 3-309A, a person not in possession of an instrument is entitled to enforce the instrument if, 1, the person seeking to enforce the instrument was A, entitled to enforce Pete, the instrument when the instrument was lost, period, or has B, directly acquired ownership of the instrument from the person who was Pete. Okay? Court cases. Now look, I'm not going to go through all these. I put these here for you guys. I could read you all day long. We've got all the best cases in here for your review. And I want you to take your time because you're going to read them all and see everything that we have highlighted that will demonstrate what is pertinent to your case, okay? Now, the important thing for us to realize is that when you understand how the flow of things is to happen, number one, number two, and how to argue, this is the critical thing, guys. Arguing in court is not the way to go. Responding in court is the way to go. And when you get that responding in court down, where you're asking questions, and we're going to have an advanced training with some experts out there that know how to argue in court and win and win and win. And so this is a critical thing. What I'm going to do is the webinar is over. We're going to move into a break and just do some moderate to heavy applause now. Lynn, please, you don't need to stand up, Lynn. It's okay, sit down. And we're going to take a 10-minute break, and 5-minute break, 10-minute break. We're going to come on with Damian M. Holtz for a Q&A for the next hour. Appreciate you guys. Just hang in there for the next 10 minutes. All right, guys, this is the final hour of the Advanced Chain of Title seminar presentation by HISAdvocates. We have a special guest speaker in our back office, Damian M. Holtz. Damian, welcome to the call. We're going to be going through, guys, right now, if you would on the HISA website side, go and make your questions so that we can get through and get whatever you have out on the table pertaining to litigation, preferably. Guys, yesterday we moved ourselves away from discussing the issues regarding CODA, and we moved into issues that had nothing to do with this weekend. Let's talk specifically about what your situation is, and let's see what we can do to get resolved. I know that you guys, some of you have done discharge instruments and different things, but let's get into the litigation aspect of the declaratory relief process, because that's what this whole weekend is about. So, Chris, anything that you know of from a question standpoint that has been thrown up there, if you could throw it into the chat room for me at this point so I can start asking any questions from Damian. Okay, thank you, Chris. So, Damian, can you tell us, what's your history, what you've been doing, so these guys get a roundabout of what you've gone through in the last 10 years of your life and what you're doing right now?
Oh, yeah, absolutely. Well, I started in the residential lending side in early 2004 out of Denver, Colorado. And I worked for a shop that was doing FHA and conventional refinance and purchase programs. So I came up through the ranks as a loan officer, went on to managing teams, went through the underwriting side, really worked on all the aspects on the residential lending side. That's kind of how I got into the industry. When 2009 occurred and the financing froze, the market kind of crashed at that time. The next year is whenever the foreclosure boom started. Mm-hmm. And I got into, just from my knowledge base, working on creating work product in terms of litigation support. And so I've been doing that since 2009. I progressed into the private investigation side so that we could furnish clients with legal instruments such as an affidavit that would be admissible into court. And I just really worked on progressing and helping folks that are challenged with foreclosure issues.
Mm-hmm. We do have our first question. We're going to try to bust through these questions and kind of have a conversation in between. Damian, this is an important question for a lot of people. We've addressed some of this in the seminar, but people are getting some people are getting from the state court pulled into federal court, and they're getting ignored and their motions are getting dismissed. How come they're not getting an opportunity to present their case, and in what regard? I mean, my first statement is if you've done your job properly, you prepared yourself for an appeal, and you should go down that road and appeal it. But why is it that, in your opinion, that they're just pulling it straight into federal court, and is there anything that you can do to keep it in state court that you would suggest?
Well, there's a couple different ways that you can be removed to federal court, and I'll touch on both of them and then address the one that I think most people are challenged with. If it's under a 12b6 ruling, failure to state a claim for which relief can be granted, we'll touch on that. And the other would be diversity, so it'd be specific to whether the banking institution is based there in that state. If they're not, they can remove to federal court on diversity. But in terms of a 12b6 dismissal, what we've found is many times with securitization, and I'll use an example of an error in the intervening assignments based on the securitization transaction, some of the issues in terms of whether or not the assignment was done after the closing date of the trust, if presenting errors in the transaction, specifically to whether or not they followed their own rules of the pooling and servicing agreement. A lot of times if you're identifying an error in the transaction and you're using that error in the transaction to present your cause of action, then it's a challenge for you because you don't have privity of contract. The transactions or the errors in the transactions, the deficiencies in the transactions according to statutory law or federal law, it's outside of you being damaged. And so if you're making all of your allegations for remedy associated with errors in those transactions, then it's stating a claim for which relief cannot be granted. And that's why the banks are removing you to federal court under a 12b6, and many times they're getting dismissed with prejudice.
And so what is your goal from a standpoint of preparing for the appellate court? Are you, do you see, because I know that we've come up with a new program for borrowers or for members, and we're going to be discussing that in just a few minutes, where, because many of these people, Damien, they come into, they buy a chain of title assessment, some of them are buying the chain of title assessment and the declaratory relief package, and where a lawsuit gets filed, and then they kind of sit there and go, okay, what do we do next? There's been an issue in which the member can't get a response to a federal court, but we're coming up with a new action in which people will be able to just use our back office system and platform to respond to everything. So what would be, in your mind, are we just going to deal with it, let the 12b6 happen and go into the appellate court, or do we have a remedy to get that stopped and slammed shut? I'm just trying to get through this because this is going to be the major opposition we're having.
Yeah, I'll kind of start from the top, from where you started. Based on preparing yourself for the appellate level, in what I stated before was the fact pattern around why a lot of people are experiencing the 12b6 removal. The declaratory relief is going to give the baseline understanding of the fact pattern of the transaction and the statutory requirements of law for transfer of enforcement rights over the collateral. And that's statutory, and I'll kind of go a little bit deeper into what that means. So the Article 3 note and the security instrument, in many cases it's a deed of trust if you're in California, are common law contracts. And so the banks are wanting to present to the trial courts that these are, under common law, the security follows the note as a matter of common law. And that statement is accurate, but after common law came statutory law, specifically the Uniform Commercial Code. And the Uniform Commercial Code and statutory law govern specifically the transfer of rights or rights acquired by transfer. And in this case, it's going to be rights acquired by transfer for enforcement over the alternate means of collection. And so it's important to have a declaratory relief that presents the fact pattern of the transactional history, not in a way where you're using the errors in the transaction as a basis for your cause of action, but more to show specific capacity based on how the note was negotiated, whether it was negotiated as a bare instrument in blank, whether it was negotiated by special endorsement and proper launch. There are additional fact patterns in securitization that take place in order to create securities. An Article 3 note is deficient in that capacity. There is a very specific application of law that the banks are required to use in order to convert Article 3 debt into securities. And that fact pattern has a very specific impact to rights to enforce the collateral. And so it's very important in your declaratory relief, in your declaratory judgment, to present the fact pattern of the transactional history to ascertain the capacity of holder that the bank purports to be in based on how the transaction took place. And so it's important that you have those elements in your action so that when you get to the appellate court, all the merits of their case are presented in your pleadings, and you're not left attempting to bring additional information in when you get to the appellate court.
Okay. How often do you think people, because I have always been teaching that that's the appellate court is where you have your remedy, because that's where they have time to hear matters and do it against the law, versus trying to have a court mill where they're running people through and getting them out of the court as quickly as possible through summary default judgments or dismissals. Their question again is: should she file a motion for a rehearing to make to make a better preparation for appellate, or should she, if she's already got the 12B6 was granted, should she just go straight to the appellate court and file her appeal?
No, I would definitely do a motion for consideration to get additional, make sure you go through all the elements of the pretrial motions, really make sure that you get an analysis of some of the things that you felt that you wanted to present a little clearly from whatever legal conclusion you're trying to make. So the motion for reconsideration is definitely a tool that I think she should definitely use prior to the request for the appeal.
Good point. Another question. According to their CODA, it was a CODA that we did, the first assignment of mortgage is invalid as an assignment of mortgage, and the mortgage is contract is a nullity with no properly recorded owner. Where should we begin to bring about remedy? Now, if this is somebody, they're going to, just to answer that question, you're actually going to get a declaratory relief. Let's just start there. Let's answer the question. Where should they begin to bring remedy if they got an assignment? Let's just answer that, because some people are just chain of title. Some people are chain of title along with the declaratory relief package, the full mini arc, and some people are even the new program that we're going to be talking about in a little bit. How would you take somebody that's just got a chain of title, they got a bad assignment, what is their remedy to deal with that one bad assignment?
So specific to remedy, you're going to have to associate that with your cause of action, because the cause of action will dictate what remedy is available to you. I'll give kind of two examples that people may be familiar with. So quiet title as a cause of action is an equitable remedy. A cause of action such as breach of contract is a damages remedy, special damages and monetary damages. So the cause of action that you identify in your when you move the court is going to be specific to your remedy. Is that what the question?
Yeah, and this goes back to what we've been talking about for the last several months. What you state is a response, and it's an opportunity for people to utilize that data and information, but most people don't know how. Basically, in a nutshell, it'd be going after declaratory relief against the assignment, putting within state court your arguments and sticking to your points and everything that we talked about today to get to that declaratory relief standing. We do have another question. Can we use small claims court to get declaratory judgment? The answer is yes. That the party trying to foreclose is a debt collector. This is a process that other people teach, Damien. They just want to get your opinion. And he makes one comment. Seems that this would be a good strategy to get the record by a local judge that the parties are trying to foreclose as a debt collector, and then the Al West quiet title strategy would work because we could be current on the loan with the creditor and not with the debt collector. So what do you think about that?
Yeah, no, absolutely. I think a judgment specific to, and that has to do with standing, foreclosure is a alternate means of collection specifically. And when you're talking about the mortgage loan contract, you're talking about two very specific different contracts. You have your Article 3 note and you have your security instrument. So foreclosure is specific to the security instrument, the collateral itself. And what the basis of what he's saying is if you're getting a declaratory judgment on the capacity of the party that's attempting to assert rights that they haven't properly achieved, that is going to be your focal point. That is going to be the crux of your position in terms of how you're being damaged, specific to the assignment. The assignment is the encumbrance of record, public record. It's constructive notice to the world to memorialize the sale of the Article 3 note and the acquiring of rights. So the declaratory judgment, if it yielded a judgment that the party attempting to foreclose had not acquired rights, then by default the assignment is void. Not by default, it becomes void based on the judgment itself. So if it is a void instrument and they knowingly recorded the assignment without acquiring the proper rights as holder, then that assignment, that act, that method and means of encumbering your property without rights is irreparable harm, and that is slander of title. And that carries with it special damages or monetary damages based on that attempt to harm you.
Well, in small claims court, there quite often is a commissioner. Sometimes you got to demand your judge and go for trial, and who ends up showing up as a debt collector. And there's people out there that are teaching to go after and sue within small claims court to get that declaratory relief against the assignment, against the deed of trust, against the debt collector who's purportedly trying to pretend to be on the note. And I have seen this work. Now, but we've also seen our process, meaning how we're doing it now, work. But what are some of the detriments that could happen from a small claims judge who is a state judge? How hard would, in your opinion, would it be to get that turned around or thrown out?
Turned around or thrown out. So
because he's just asking from a declaratory relief standpoint to note that the party that they're suing in small claims is a debt collector. So once you under the FDCPA show that they're a debt collector, they have no rights against the house. But this isn't getting declaratory relief against assignment. This is getting a judgment against the fact that they are nothing more than a debt collector.
Yeah, no, I understand. You're still okay. So an FDCPA action is different than a title action.
Right.
So it is the same thought process, but it is a separate component.
And it's using the FDCPA and not dealing with the note or dealing with the rights to collect on the note, other than the FDCPA is saying, look, if they are alleging to be a debt collector on their paperwork and they are giving you information saying they're a debt collector and they say they're a debt collector on their phone, then why are they foreclosing on your property? And so some people out there are getting these judgments against their pretender lenders, and the judge is saying that these are debt collectors, and they take that judgment and move against the assignment as being a lender or holder, somebody that has an ability to collect, I'm presuming. Let's just move on and stay on the declaratory relief process. Tell us how we're doing in the back office as of late, and what's any updates you can give people.
All elements are firing, that's for sure. The litigation support side, as far as all the initial claims, all the pretrial motions, all the requests for discovery, all those elements have taken off, and we've been doing really well in supporting everybody. In addition to the bankruptcy department is doing well in terms of extending the bankruptcy stays to the 7s and 13s if needed. So, and then post-foreclosure as well. So, yeah, all elements of the litigation support back in have been fantastic. We've been doing well on the judicial side. We've been getting settlements on the non-judicial side. And in terms of volume, workflow, got a great staff, and we've really been turning things out in a timely manner. So it's been all around. I've been really happy with the progression.
Yeah, thank you, Damien. Any updates on wins or settlements?
We've got a settlement offer in now from a post-foreclosure deal out of Michigan that was a very interesting case. And so it looks like they're going to rescind the sale and do a principal reduction. So they're in the process of doing that now. We had a couple earlier last year, but there are just quite a few right now that we feel that we're doing really well in terms of getting past the initial motions to dismiss and getting to the discovery phase. And that, I think, has been the biggest hurdle for a lot of the non-judicial litigation in terms of getting past the 12B6, getting past the pretrial motions to get into discovery and get on to trial. So there's been a lot of progression there as well.
We have a question from a gentleman by the name of Samuel. He's asking, yes, everything does stem from the CODA, and it is correct to assume that once the CODA is complete, you'll have the ammo to file the suits. However, Samuel, you're in a package where you get the suit filed, not filed for you, but we provide the suit, Liz Pennant, the information that you need to go and file the case against the CODA. So basically, you don't need to think all that stuff through. Everything you learned today is really more for beyond that standpoint. So you get the CODA, the lawsuit, and you just got to review it from a standpoint, is that what you want in your mind from an approach to take? But it's using all the state-specific statutes and codes pertaining to that CODA and what the CODA pulled through, and it's going for declaratory relief against your assignments, your deed of trust, and so forth. That is the full package. I do want to talk about an updated package a little bit. Now, we, if you all want to look at the screens, I didn't put it on this side. Dang it. Damien and I really started thinking through in the last couple months. People just feel like they are out there in the cold, and no matter what the support levels are, they're worried about their ability to perform, to take information and or data and to apply it to future litigation responses. We have some people that, a buddy of mine, 21-year-old, fighting on behalf of his mom, love him to death. He's kind of like a second son to me, and he filed his lawsuits, and then he got 4 inches of responses from 4 different banks and trustee and everything, and that stuff was kind of overwhelming. And I'm like, do you want to go forward? I'm like, you got to go forward. And he's like, I'm scared, I'm worried, I'm this, I'm that. And he was there's some immaturity there, but nevertheless, that's the way most people feel. So we basically have invented a package that is an ongoing litigation support for people, and anybody that's already got the mini-ARC program that doesn't want where they got a CODA, they've already got the declaratory lawsuit filed, they got all that information. We have basically invented a full litigation support model that we're going to send you out on an email that has an ongoing monthly expense, but you don't have to worry about the paperwork and or anything to respond. You just hand that stuff over, upload it into your profile. We work on the paperwork and responses and everything so that you can get filed. And it's your paperwork, it's your baby, but we're basing it on the experience and what we would do for ourselves in looking at the model for declaratory relief. So it is available. It's not something you need to do today unless you got a bunch of paperwork you're trying to get in response to, or even if you're maybe thinking about how to respond in your appellate issue or potential appellate issue or bankruptcy. We're trying to work it out so that you guys don't have to think or worry or stress. You just have to go and live and do what you do. I got to tell you something. This is the biggest stress that everybody has. It's their largest asset. It's their home. They want to get it protected. So we're going to be shooting an email off on that tonight so that you guys can have ongoing litigation support where you don't have to think. But this isn't going to preclude us from still taking care of you and helping you at the existing model on the mini-ARC. But you got to ask yourself, do you want to take on all the responses and use templates to deal with those responses and so forth? So, anything to add to that, Damien?
Yeah, absolutely. I can tell you from being in the trenches, what he's describing. There is a lot of work that goes into litigation. That's for sure. Not just getting your due diligence packages in terms of your CODA, not just making sure that you've identified causes of action, that you have privity of contract to, and that you've moved the trial court properly for them to grant you relief. Not just getting your declaratory judgment proper. That's a precursor to a much bigger challenge in terms of your initial complaint is specific to allegations, right? You're essentially giving a fact pattern and you're making allegations based on what you've found. Now comes the biggest challenge of the banks, right? The banks, they're well heeled. They pay their attorneys. The gauntlet has been laid, and the attorneys, they collect their Friday paycheck just like everybody else. They're going to respond. They're gonna make sure procedurally that they are putting the full court press on you. They are aggressive by nature. The emails that come back and forth, it's just not only do you have to get the action right, but when you do your responses, your pretrial motions, that's a huge amount of work in terms of having the resources to put together that type of work product. And then right whenever you get into discovery, you've got all of those requirements, making sure procedurally you request your discovery properly. There's just so many facets to executing a good defense on your own behalf that we are going to be able to support you with across the board. And we feel confident that all elements of that will be handled through this program.
Well, let me ask you another question pertaining to the bankruptcy aspect, because people are going to want support in that regard too. But people like Max Gardner have a boot camp where they deal with fighting MERS and, the reported supposed Pete coming into court. And they take the BK proof of claim form, they fill out the name of the lender, and they then turn around and they object to the proof of claim that they just filled out for most of the lenders, and it puts the lender in a position where they have to come in and prove the claim. Are we doing anything from a back office standpoint to support people in a Chapter 11 with that kind of strategy at this point?
Oh, yeah, absolutely. As you know, you guys may have talked to my partner, Joseph Escobar, but no, he went through all those Max Gardner boot camps back in the day. Joe is one of the few people that I've actually seen adversarially discharge the tangible note obligation and have it unsecured through bankruptcy litigation. So, yes, all elements of the bankruptcy side in terms of adversarial and trying to unsecure the asset through bankruptcy is full supported as well.
Okay, we have a question. They have a second property to discuss as far as the mini arc. Is there a review stage to see if it would qualify prior to investing time and money into it? Absolutely, Sam. Just call me tomorrow afternoon. I'm going to take a little bit of time with my family in the morning. But call me tomorrow afternoon. We'll hook up on that, and I'll answer any questions that you have and tell you whether it's a viable thing or not. I wanted to take Max Gardner's bankruptcy course, and we called them, and they only accept attorneys to come through. And so the first question they asked me, "Are you counsel?" I said, "Yeah, I'm counsel for a few people." And so I kept trying to answer the questions, and they said, "Where are you licensed?" And I'm like, well, as you know, no attorneys are licensed. We're just members of a bar. And they said, "Well, where are you a member of a bar?" And I said, "I'm not." And so I couldn't get around it. I was trying to get to go to the boot camp as a non-licensed practicing attorney, and they're practicing, just non-practicing. And so they caught me, and so I'm trying to get a few people to tell Max to work with the pro se. We have a question: which is best, in your opinion, going the declaratory judgment process or going through bankruptcy and trying to dispute the process?
I think they're both very important tools. I think the bankruptcy, I would use that if your financial situation from a big picture benefits the most, if your bottom line benefits the most from the bankruptcy arena, then I think there's a lot of good things about bankruptcy if you can discharge other obligations and put your family in a much better financial situation. If it's from a sheer standpoint of where you're starting in the beginning, FDCPA, declaratory relief, these title issues, filing an action, I think going that route is going to benefit you the best in terms of going in, having that ability to do that, but then being able to fall back on bankruptcy to stay any issues and fight it from a different arena. So I think it just gives you a little bit more flexibility and versatility on fighting these guys and maximizing your time in the property. I definitely think that filing bankruptcy should be outside of, if it fits your financial picture better, should be secondary to filing the initial action in state or federal court.
Remember, guys, we're only answering questions on the Housing and Education Live chat room on HISAdvocates.org. I know some people are on the other side. It's just very hard for us to read those questions over there. If you can pump it over here, that would be great. We're going to be having a course that's going to help people in court in the next 60 days, which is going to be timely for many people like that. Now, to add to what Damien said about the bankruptcy versus the court or the DJ, declaratory judgment aspect, personally, I'd go for the declaratory judgment aspect in state court first. You can use the same arguments within bankruptcy court seeking for declaratory relief by filing them as an adversarial proceeding within bankruptcy court. But bankruptcy court is very specific to law, very specific for processes and procedures and rules of court, and you're not necessarily dealing with the bankruptcy judge to start with. To file an adversarial proceeding, the average attorney that I know charges about $50,000 to $75,000.
Yep.
Straight up. So that tells you what is going on inside a bankruptcy court that makes it a little bit more complicated than filing a state court action. Plus, you can always use bankruptcy court secondary in the event of a potential loss, but you're dealing with maybe potential issues of res judicata and so on and so forth. So you got to be strategic, which is a whole other training level on a pro se basis that you're going to have to be dealing with. And so can we fight from both DK-CODA? You can. Well, go ahead.
Oh,
David.
if I understood the question right, can you fight in both courts? And the answer to that would be no. As soon as you file the bankruptcy supersedes any state or federal court issue in terms of foreclosure.
Right. It takes over that case. Essentially, the case freezes on the state level side. So again, please just keep asking your questions. We got a little bit more time with Damien, and we do want to get through them all. Make sure you're asking the questions on the HISAdvocates website. The link was posted back into that other side. So what I'm excited about, Damien, is just the knowledge that's coming out. One of the things that, and I want you to explain this the best that you can, if I believe you know the answer, pertaining to MERS. Other people are saying MERS has affected 50-plus million properties nationwide. Can you address that? Why?
Say the question one more time.
MERS has affected and clouded title necessarily on 50 to 70 million properties nationwide.
How have they done that?
Correct, in just a layman's opinion or term.
Okay, yeah. MERS is a reporting system in terms of ownership of interest in mortgage loans. Their capacity as a nominee or beneficiary to the originating lender as a mortgagee to the deed of trust is the biggest challenge. MERS is, in the language of the assignments, is the rouge of all this is that they're attempting to present that they're transferring beneficial interest in that original security instrument to a new party claiming to be a holder of the note. And as you know, MERS does not own a note. MERS does not have any rights to payments or anything like that. There is no agency to principal relationship many times to a bearer instrument. So in its capacity to make an assignment and what it's attempting to purport is the biggest challenge in terms of it's a method and means of slandering the title in just a straight language. MERS is the method and means to maintain the rouge of common law, that the security follows the note. That's really essentially the MERS system is the facilitator of the common law theory, that the security follows the note and MERS can bootstrap that interest at any time.
Awesome. We do have a question. Does a court ever insist that you answer a question rather than respond to a question? Let me answer it a couple different ways for you, Samuel. When you walk into a court from an argumentative standpoint, you're automatically, and I don't want to get into the judge's mind or make presumptions or assumptions, but the reality is you're putting yourself in a bad light in the judge's eyes. And what you want to do, not just respond but conditionally accept, and you can do that in any number of ways, like, the defendant is not a Pete. He's coming in, he's saying, they haven't made a payment. The judge says, did you get a loan or didn't you get a loan? And you're saying, well, what loan number are you talking about? And then they're going to say, just answer my damn question whether you got a loan or not. And say, I will be more than happy and compliant to answer any question you have pertaining to my loan number, and you can read of the loan number if and conditionally accept any and all things that this court may have if this man on the defendant's table can prove that I have signed an original wedding signature promissory note showing that the instrument is blah, blah, blah. And so your point is that you're not making an argument, you're conditionally accepting, and then you're putting the burden and proof of claim on the defendant to come forth with a response. And if the judge keeps, asking questions on behalf of the defendant, you can ask that judge to step down from the bench and so that you can depose him as a witness. And, you might piss him off. But you need to put the judge in his place in a nice, respectful manner. And this is a whole other training that's going to happen in about 60 days. It's going to be probably the most explosive, most powerful court training because I'm bringing in a super heavyweight that has won millions of dollars against state and federal governments, and he's going to show you exactly the due process and procedures necessary to do this. And so I don't want to get into all this with you, but this is a big one, and it's going to be the same process in any court for getting any remedy on how to get them to move in your direction that you want and to not move the case out of the court, dismiss it without your approval. So I hope that answers your question, at least at this point. But in a nutshell, Samuel, you're playing ping pong. That's it. They're not in the big black robe. They're not scary. They don't have a glow behind them. They're not God. They're 10 feet off the ground because they want you to feel inferior, because really in that black robe they have no muscle. There are a lot of them are fat, overweight, out of shape. They don't have what is necessary to, they're smart, intelligent men that don't understand their oath of office, and they're just trying to handle and administer a HJR 192 so that the bankruptcy can continue and they can keep bonding cases and making money. That's really what the court system is about. It's not about fair and equitable claims for the people. So I don't want to get into all that. Damien, anything you want to add to that?
Yeah, I'm gonna touch on it lightly because this is right now is in a phase where we are working adamantly on presenting this administrative process. But I'm just going to touch on what we're working on. This will be available very soon. The banks are operating in the capacity as a debtor on the Article 3 note. That's what most people really truly don't understand. You are the owner of your Article 3 note. You are the maker of your Article 3 note. And for a verbal agreement for the face value of the note, you have credited the note to the lender as a debtor. And what that means is that, in simple terms, if we make a verbal agreement for a loan or credit or something along that terms, and I make a note, Kelby, and I hand you the note, okay, and I pay the face value of that note, then you owe the note back to me upon performance. Is that correct? Mm-hmm. And so just to give you an understanding, if you're the creditor and you're the owner, we are going to implement an administrative process for you to reclaim your Article 3 note prior to going into these actions, and that's something that's on the horizon. But it really is a situation where we're going to put you in a position to have standing to call the note, to claim your Article 3 note back, and give you the position to where these issues that you're talking about there are not even going to come into play. Once you claim your note, you as creditor have the capacity to come in and bring these actions.
Right on. All right, we have another question. A few more questions, and then we're going to wrap this thing. If you have all your paperwork, is there a lawyer who can present the paperwork? Since I was told judges don't like pro se litigants. First of all, judges sometimes love pro se litigants, but they don't like people that are incompetent, that don't know what they're doing, that hold up the court's time. And they don't like people that want to go to a trial by jury, but they don't mind people that get the opposing counsel moved off and or shown to be liars, or shown to be in a position of fraud, or shown to be not the Pete. They don't mind that, because then they can move against them for declaratory judgment, and they still win. Remember, judgment is judgment. It's a bonded thing that they get to receive the reward on, and the court wins. The banks don't, so their friends don't. But not necessarily, it's not something that's a negative for you. We are working on, and I discussed this yesterday, Shelley, nationwide, but this is not easy, and Damien's going to tell you this, and I want you guys to just consider this. We're working on trying to get an attorney that's competent in each state who knows this stuff, but trust me, it's not easy to train somebody up on this stuff. Not easy at all. And so you're here for a weekend, you've gone through and you've listened and you've seen the preponderance of information. Guess what? 99% of all attorneys have no clue of what we just said this weekend. They don't understand Pete. They don't understand what we just went through. And so that's the critical thing and why there's going to be a market for this. If the world tarries and the Lord doesn't come back, this is what we're going to be dealing with for the next 50 years, is litigation pertaining to title issues. Damon, any comment on that?
On the attorney thing, yeah, I would say that that's very common, and there's been enough time in the trial courts to where, this word called securitization has really kind of fallen on deaf ears, and so a lot of the attorneys aren't willing. They're willing to take your money, they're willing to take your retainer, but they're not willing to bring these issues and aggressively fight them and present what's in your best interest. That's just what we have found across the board. So we definitely we work with many attorneys and training them. We're working on making sure that we have ones that we have a comfortable working relationship with, so that we can have some type of control over how they're engaging you, because that's been the biggest challenge is once they're retained by the attorney, then all bets are off, all understandings are off, and it's really hard to make sure that we convey the right message and the expectations are set properly without getting egg on our face when dealing with the attorneys. So when we feel comfortable, we'll definitely make those available to you.
Awesome. Another question. Okay, as I understand it, if an assignment was recorded 11 years later, there's no way that it can be valid. That would be correct. You just got to look at when the trust was closed. Because remember, you can't pull something out of a trust that belongs to something different. Number one, they already broke apart the instrument, which was the deed of trust and the note, and then they are using this reportedly inside of this trust now. And 11 years after the fact, recording an assignment, no, it's invalid. Any comment on that, Damien?
Yeah. What the banks will argue in that situation is, again, the common law theory. And the common law theory, for a lot of you guys that want to know what I mean by that, the biggest point of reference is going to be the Carpenter versus Logan case law, where the security follows the note as a matter of common law. And so what the banks are going to present with their capacity is that they're a holder. They were negotiated the note in some way, whether it was by physical transfer or special endorsement, and that as a matter of law, the intervening assignments don't need to be recorded. All that stuff is in business records in some file somewhere, and they are a holder of the note, and security follows the note as a matter of common law. So the assignment by MERS is proper, and that's their position. That's why the declaratory judgment is so important, to dispel the common law theory and show how through securitization the Article 3 note is manipulated, and negotiation is negotiated for less than full value. And as a matter of law, the collateral, the security instrument is a nullity, because rights cannot transfer based on a negotiation for the Article 3 note less than full value. So if you're just arguing common law and you're just arguing the note, you're going to lose that battle every day. That's why the declaratory judgment is so important, to look at rights of enforcement over the collateral.
Have you ever seen, Damien, any way that somebody can complain to the recorder's office to remove an assignment that is not valid, or show that why it's not valid?
To the recorder's office?
Right. Because lenders are non-judicially foreclosing, fraudulently foreclosing against the wrong parties all the time. Why can't somebody just go down to the recorder's office and file a notice of fraudulent foreclosure and do a grant deed back to themselves?
Well, I would say that the clerk of courts and the county records office is a component of a bigger machine in terms of the judicial system and the land records. A lot of these assignments are filed electronically. It's all a book entry system. And so there's not somebody physically going down there and doing that. It's a systemic issue completely. I have been a part of through an investigation here in Texas. Believe me, we've looked at every state, and not many states have this remedy. But here in Texas, through a 51903 hearing, it's an ex parte hearing where you can present facts, and the judge can make an ex parte ruling of whether or not the underlying instrument is enforceable. And I have seen the security instrument removed through that type of action. But specifically directly to the county recorder's office is just too much. In my opinion, there's just too much. It's part of the too big to fail issue. They're not. I don't believe they're going to let you do that directly with the clerk records.
Since people, what do you think our next steps here would be for helping people that have foreclosed on a property in 2010?
What was the question again?
Somebody's already lost the house 5 years ago. Is there any resolution for them? Anything?
In a non-judicial state, I mean, the problem isn't so much a lot of times that we may be able to come back and file for damages, right? For civil damages. It's a matter of tracking when they liquidate the asset. Okay, and we no longer have the ability to go in and identify which particular investment vehicle the debt was monetized to. That's the challenge. Is we may have what everybody sees in public record, but we don't have any private information to show the chain of custody of the transaction, all the transaction participants, to really bring a legitimate action forward. That, I think, is the biggest challenge, is that, again, after the loan is liquidated, it's no longer active, and it can be hard to find. I think that's going to be the biggest challenge. We'll definitely take a look at it. I mean, if we can find it, we would bring an action for damages for sure. The only reason why you wouldn't bring and this would be just kind of on the judicial states, or even if in the non-judicial state you received a summary judgment in your case. If the court has granted the summary judgment in the action, the Rooker-Feldman doctrine would come into play, and the Rooker-Feldman doctrine would bar any other court subject matter jurisdiction to hear any other action for remedy. So those are just some things to think about.
All right. Listen, this is if you got any last question, get it in right now. This is from a gentleman that we were helping in the past. His name is John. And I think we need to, John, deal with this privately, because what you're saying here, I'd like to revisit. He's saying that he's got a deed of trust with Wells Fargo in 2007. The deed of conveyance MERS on 3 documents. He purchased his house in 81, but he refinanced in 2007. Are any of those prior conveyances affecting anything? John, I want to talk to you about this tomorrow and the next day or two in private, so that we can. I really want to look at the file again. It's been 3 or 4 months since I looked at the actual file itself, because I know that they came to a head as, well, Wells Fargo made the loan, Wells Fargo hasn't transferred it or anything like that. I want to find out exactly what we're talking about. Damien, do you, I know it's coming up on the hour, do you have any closing thoughts or comments that you want to make before you get out of here?
No, just thank you for having me. God bless everybody. If you have any additional questions that you didn't get a chance to get through here, definitely send them to Kelby and we'll review them and get back to you right away. You guys have a wonderful evening.
Damien, I appreciate you coming on the call. I know you're busy and trying to pull you out of there, away from what's going on in your home life and stuff. I know it's tough, so Sunday afternoons are much obliged. You enjoy. I'll be in touch with you tomorrow, buddy. Have a good night.
Okay, you too. Good night.
Yep. Ladies and gentlemen, we're going to conclude the call tonight right now, and or the seminar. I really appreciate you guys coming on. And thank you. Appreciate it. No, thank you. That's what you get when you own a Android phone, and you can be your own applause. Guys, I appreciate every one of you coming on this. This has been one of the toughest seminars to get across. Big words that are stumbling me. We're going to get this uploaded so tomorrow you guys can start watching this. Don't send this out to everybody, guys. You guys paid good money, and this is something for you. This isn't something for the world. If there is somebody that has a need and they need this information, I take care of that on my end. They just have them call me up directly, and I'll take care of somebody on my end. I do it all the time. I've never refused anybody. I've never said that anybody could not have a help or support, but that's pretty much it. I want to say God bless you guys. This is an awesome training weekend. We appreciate you, and we look forward to seeing you guys. I'll be tomorrow night on the call, 6 p.m. Pacific, and we're going to have an awesome month. You guys have no clue of how awesome the court training is going to be or who's going to be there. It is the most unbelievable thing HISAdvocates has ever done. I'll be surprised if 1,000 people don't show up. All right, God bless and good night.